Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to a trial out of Jacksonville, Florida. Imagine that, another trial out of Jacksonville. This one is Mario Fernandez and Shanna Gardner. And let me just check my audio. So much for joining us. All right, audio is good. So their trials are coming up in August into September. So it's right around the corner. So we're going to do a little bit of deep diving and catch up. Well, we're going to give you kind of a high-level view of what happened, and then we're going to catch up on some hearings that have happened over the past couple months that we have not watched. So we're going to show that to you guys. So settle in, get comfortable. We have about an eight-hour stream ready for you, and let's get going. All right, welcome in, everybody. Welcome in. Good to see everybody. Thank you guys for joining us. Let me just do a little bit of a roll call here, see who's with us. We have Good Vibes Only and the Pretty Chick. Good morning to you, Camilla. Good to see you, Horse Welfare, Aussie Gardner. Dave and Barry, Christine. Good to see you. Fur Baby's mom, good morning. Sherry, good morning. You'll be back at 8, and you are now back with us. Kimbers, happy hump day to you. YT Hazel, good to see you. I got to scroll through. You guys were very talkative earlier. Jane Dixon, going to be 90 in Georgia. Lordy, lordy, lordy. And the immortal words of Jack Tripper. Lordy, lordy, lordy. Richard in the kitchen. Hello, brown eyed girl. Good to see you. Yeah, 90 in May in Georgia. Oof. Brenda Meyer, happy hump day to you. Good to see you. Shannon. Grandma Ruby, good morning to you. Eva Renee, good morning. Good to see you. Hey, Gordon, how are you? All right, let me scroll through here. Sherry, there's William. Good morning. Saying hello to everybody. Christine, good morning to you. Hey, Margaret, Selena K, Heidi, good morning. Great to see you guys. Gracie, hello, hello. Elspeth, Allison, welcome in. Shelley Broomer, hello, watching from South Africa. Awesome. Hey, Karen, how are you? Karen from Germany is in the house. Kaylee, Iowa Backyard Cam, thank you guys for joining us. Audrey Chance, great to see you. Mama of a Medic. Got a migraine? That stinks. Sorry to hear that. That's never good. Snow Caddish, hello. Hey, Michael, good to see you. Lisa, Deviant, good to see you guys. Thank you so much for joining us. Really appreciate it. Imy, good morning to you. IMME. High Alert, good to see you. JMS. Kathy Davis, Florida has an execution this week. Ooh, who? I'm sure they do. I just didn't know who. JPC, good morning. You're about to cut the grass, but you'll be listening. Christine saying it's 90 degrees in South Carolina too. Debbie, thank you so much for your $10. Really appreciate that. Thank you, thank you. That's a nice way to start off our Wednesday, our hump day. CJ Cozy, good morning to you. Hey Ray, how are you? JMS, Honey Badger, Nana, good to see you. All right, I think everybody's getting settled in. Bama Green Eyes, good to see you. All right, so get comfortable. We have about an 8.5 hour stream for you guys. We've cobbled together a bunch of hearings that we haven't watched that have been happening. I think the last deep dive we did on this was, what are we in May now? Was it this year? It certainly was last year. We did a couple deep dives, hearings, but hearings have caught up to us, so now we're going to catch up to them. So this case is out of Jacksonville. Again, we're looking at Jacksonville, Florida. Jared Bridegan is the victim. He was 33. Shanna Gardner is the defendant. She's 39. And Mario Fernandez Saldina is 37. Date of this incident is February 16th, 2022. Shanna and Mario are looking at first degree, conspiracy to commit first degree, and solicitation to commit first degree. The judge is London M. Kite. If you guys do not know who Miss Kite is, she is a fantastic judge. She was a cheerleader for the Tampa Bay Buccaneers football team. She was, I think, a high school teacher. She absolutely rules her courtroom like a bunch of high school kids, because these lawyers are acting like they're like middle school. Just wait. Jose Baez is Shanna Gardner's lawyer as well. So for those that don't know Jose Baez, anyway, we'll move on with him. Prosecution is Christina Stifler, among others. And then the defense is Patrick Curated, Rosemary White Peoples, and Henry Cox. We don't have Jose Baez on there. But anyway. All right, so Shanna Gardner and Mario Fernandez are charged in the ambush killing of 33-year-old father Jared Bridegan, who was gunned down February 16th of 2022 after stopping to move a tire intentionally placed in the road. So Jared and Shannon were married, right? They got married. They were married for about 5 years. They had two twins. They had twins, boy and a girl. They got separated, and then Shannon and Mario got together, and then they're divorced as well. So, here it goes. So Jared and Shannon were married, and they had 2 children together at the time of his death. The two were involved in a long-running and contentious custody dispute, which prosecutors allege played in a part in the attack. Jared's 2-year-old daughter, so he got remarried and he has another kid. His daughter was in the car when he was taken out, but I'm reading here, she was Jared's daughter with his second wife, so Kirsten. Right, so then we've got Mario was arrested August 2nd. Gardner was arrested the following day on August 3rd. Both are being held without bond, and if they are convicted, they will face life without parole. Give me a second, I have to let Raf out. All right, so that's kind of the high-level backstory. So let's get to, first I'm going to show a news clip, and then we'll get into some hearings. All right, so first we're going to show this news clip of, just kind of get you guys back in the swing of things. If you have been following this case, you may have forgotten it. We haven't covered it for a couple months. If you know nothing about it, then this will just kind of be a refresher. And we do have a playlist. We'll post that playlist in a second.
Following a twist in the murder mystery surrounding the execution-style killing of a Microsoft executive, his ex-wife is now under arrest and faces first-degree murder charges. ABC's Trevor Alt has those details.
A shocking twist in the brutal murder of 33-year-old Microsoft executive and father of 4 Jared Bridegan. Authorities charging his ex-wife, Shanna Gardner, with conspiring to have him killed.
Shanna Gardner's indictment acknowledges her central and key role in the cold, calculated, and premeditated murder of Jared Bridegan.
Investigators described the murder last February in Jacksonville Beach as an ambush, saying after Jared dropped off 2 of his children at his ex-wife's house, this tire blocked the road on his way home. And when Jared got out of the car, he was gunned down in cold blood with his 2-year-old daughter watching from the car seat. This January, authorities arrested Henry Tenon, saying he pulled the trigger, but emphasized they believe he did not act alone. Tenon has since pleaded pleaded guilty and is cooperating with the investigation. And in March, authorities arrested Mario Fernandez Saldana, Tenon's former landlord and Shanna Gardner's second husband. In his arrest warrant, officials claim the investigation into Jared Bridegan's background revealed a highly acrimonious divorce from his ex-wife Shanna Gardner and a contentious relationship with both Gardner and Fernandez Saldana. Now Shanna Gardner is charged with first-degree murder, conspiracy, and solicitation to commit a capital felony.
From very, very early on, everything in my soul and body told me that she was behind it.
Bridegan's widow Kirsten says the search for justice has been excruciating, describing her difficulty explaining these developments to their now 4-year-old daughter Bexley, who watched her father die.
I was able to tell her that who she refers to as the mean mom is going to be in jail as well.
That was ABC's Trevor Alt reporting. A lawyer for Shanna Gardner declined ABC's request for comment. She denied any wrongdoing in a July 2022 interview.
Now, Shanna Gardner comes from money. Her mother and her mother's sister, so her aunt, started Stampin' Up. So if you guys are not familiar with Stampin' Up, they have a website, literally stampinup.com, and they make paper products. They make paper products. So let me see if I can. So she comes from money. And she has a trust fund, but she herself, I don't know necessarily is necessarily rich, if you will. I don't think she has money on her own per se, from what I've been able to put together. Let me see here. See if I can interact with this. Okay, here, yeah, let's check this out. So this is Stampin' Up. So this was started by her mom and her aunt. All right. Oh, here, hold on a sec. I've got this blown out. Hold on a sec. Let me see if I can sort this out for you guys. I blew it out. All right. So this is Stampin' Up. So if you guys are into crafts, this is what her mom and her aunt started. Yeah, let's see if we can get, is there an about us? Our story. All right, so here's the story. Founded in 1988 by two sisters, Stampin' Up has provided high-quality paper products and a direct sales opportunity for over 30 years. So in 2016, company co-founder Shelly Gardner appointed her daughter, Sarah Douglas, to be CEO of Stampin' Up. So this is, that's Shannon's, Shanna, mom and aunt. So anyway, so that's kind of her background, where she comes from. All right. Iowa Backyard, they have great ink pads. Hey, Molly, good morning to you. Yeah, I've never really heard of them until this trial or this case. So we'll have to see where. Hey, Joanne, how are you? Real happy. Good to see you. And professional juror. Scrapbook and Berry, I guess. There's stamp pads. Cards, you could do cards. Yeah, I mean, seems like there's a lot in here. Yeah, they have stamp pads, envelopes. So if you're crafty, I guess you would know. Here, all products. Let's just check out products here. These are their products. So yeah. So anyway, that's kind of where she comes from. All right, let's continue on. So now you kind of have an overview of what's going on. Let's get into court. This was from April 14th. So while I play this, I'll get our playlist going, and you guys can check out. You can see our playlist. So if you need to do any further research. Yikes. Sorry about that. That came out of nowhere. Good grief. All right. Again, Judge Kite, you guys, is just, I love Judge Kite. She runs a tight ship. She's a good judge.
All right. Clerk Court HGLP's on session. Judge Kite presiding. You'll be seated. Morning, Your Honor.
Thank you. Good morning. Good morning.
Good morning, Your Honor. Christina Stifler on behalf of the state. We're here to address the cases of Mario Fernandez Saldana, number 4 on the court's calendar, Shanna Gardner, number 5.
All right. Good morning. If the defense could put their appearances on the record, please.
Good morning, Your Honor. Shannon Day on behalf of Mario Fernandez, along with James Hillenbrink Sony.
Good morning, Your Honor. Patrick Carodi and Jose Baez, who's on Zoom for Shanna Gardner.
All right. Thank you. All right. So tell me how it went with the disclosures or copying of the information that was due by Friday.
Your Honor, I provided the hard drives the defense provided to me. I provided back Thursday afternoon. They have signed an acknowledgement receipt that all the items that Your Honor ordered were provided. Other than anything that was a question to be answered, I told them I'm available to answer those questions at their convenience. But all of the actual items that needed provided have been provided, as well as the supplemental reports from the Jacksonville Beach Police Department. I spoke with ATF, and they'll be providing any supplemental reports if they exist this week.
Okay. And the one thing that was online, was that the unredacted, the 250-page?
Yes, ma'am. So what that ended up being was a true crime blogger got a public records disclosure from a media article and posted it. The Public Records Department had done redactions. It was just a consolidated version of all the ATF reports that had previously been provided to them, along with I had it in a binder with a cover sheet and tabs, and they had photocopied the cover sheet and tabs that I used. Your Honor, we have a discovery meeting with defense counsel Thursday to answer some of these questions. I am working with my paralegal on the missing and/or correlation of subpoenas to records received and search warrants outstanding. I do believe we'll be able to resolve almost everything on the list they provided. There are some questions that I think I can answer for them on Thursday. Where we are at now is I have Detective Shannon Padilla present from the Jacksonville Sheriff's Office and Secret Service to explain to the court the digital evidence, the extractions in specifically Defendant Gardner's motion to compel digital forensic data. He is here, as Your Honor requested, to lay a foundation for the state's request for more time and/or, at this point, a priority list from defense counsel for Ms. Gardner, given the amount of data that they're asking to receive.
Okay. Before we get there, I want to make sure from the defense perspective.
Your Honor, we would say we got about half of what we were supposed to get on Friday.
Okay. Well, hold on. Let me go back then. Mr. Hathaway, could you print the motion to compel? Give me just one minute. Do you know what docket? It's on Defendant Fernandez's docket line, the one with like the 200. Could you print that for me again? Just the motion with the list. Give me just one moment, Ms. Day. All right?
Yes, Your Honor.
All right. So tell me, from your perspective, did you get, y'all provided the hard drives, I'm assuming?
Yes, Your Honor. I believe I dropped it off after court that same.
Can you get closer to the microphone? I can barely hear you.
I dropped the external off at the state attorney's office after court last time, the same day. We received the download on Thursday of last week. There were some folders that we were not able to open.
Okay, well, tell me which ones.
Well, we did get a different download from Ms. Stifler this morning that I think resolved that issue. But for instance, the first item, the unredacted copy of the 250-page ATF report, we got a 233-page report, and the cover page is different.
What number was that?
Item,
If you could go by number.
yes, item 3.
3, okay. Okay. What's next?
Item 5, the ATF cell data animated PowerPoint. The PowerPoint in question, we have, as it appears to be an 8-slide PowerPoint. We received a single slide in response, and I don't believe it's the same map or report.
All right.
Item 15, the OSCR 360 photos. We received the same 4 diagrams that were previously provided, and I believe those are the same 4 diagrams that were also provided in response to item 157, which is the Faro diagram, and item 158, which is the ET diagrams. And I guess it's twofold problem. One, since we got the same 4 diagrams in response to all 3 items, we don't know which is which. And as it pertains to the Faro diagram and the OSCR 360 photos, we think we should have essentially the data that goes into the making of the diagram. We believe it's the laser mapping of the scene.
What ET created this? You don't know? You're not able to cross-reference what witness would have done this?
If I had to guess, I think Jarman, but I'm not positive.
All right. Okay.
Then item 22, we got an 8-page attachment, and it is unredacted compared to the attachment we previously received, but the one we previously received was 6 pages, and the one we just received was 8 pages, so we just, I guess, need to confirm how long the correct attachment is and whether we have it.
Okay.
Item 23, there was no response. Item 24 should have been an attachment for John Biggerstaff's Regions Bank response. And the report specifically states that it's a subpoena return from Regions Bank for Biggerstaff for May 22nd through November 22nd. And the documents that we received last week were from January 2022 to April 30, 2022. So they're not the right documents for that report.
So, tell me what the report says again. It's
the report says the subpoena return from Regions Bank is for Biggerstaff,
right.
May 22 through November 22.
May 22 through November 22?
Yes, Your Honor.
And then you got January 2022 through what?
April 30th, 2022.
All right.
Then for item 25, that is supposed to be an attachment to supplement 162, and that report states, I received a subpoena return from AT&T for John Biggerstaff's phone covering March through July 2022, and I believe we got 5 different subpoena returns on Thursday as this attachment.
So what's the problem there?
It should just be 1 return.
Is it for those toll records?
Yes.
Is it a different date range?
I believe that date range is included. I guess that just more goes to we're getting duplicative, more of a data dump than a specific response.
Okay.
Then item 27 is supplement 164. It should be attachment NFCU return for Gardner and Fernandez. And that report states, I received a subpoena return from Navy Federal Credit Union along with explanations as to why some documents were not given in the returns. Again, it appears that we received kind of a dump of all of Ms. Gardner and Mr. Fernandez's Navy Federal Credit returns, and I did not see anything that seemed to be from this return or any explanations.
And so you're saying you got
Your Honor,
just
I think what just to sort of explain what Ms. State's talking about is that we are getting all of the records that we've already gotten again, whereas 164, the narrative is, I received a subpoena return from Navy Federal Credit Union. We don't know which one was received on this date of this report, which is January 16, 2024, along with explications. I assume that that's a typo and they meant explanations as to why some documents were not given in the returns. And one of the major concerns that Ms. Day and I had going through this is, where is this explanation document that they received or letter that they received from Navy Federal that has these explanations as to why some documents were not in the return? And it says a copy will be placed into property.
So in response to 27, you got a duplicate of records that you already have, but you're missing the explanation.
Right, and the records, I mean, Judge, if I could, there are duplicates upon duplicates.
Okay.
The records are mixed in with each other in certain PDFs. I mean, you know, it bounces from Ms. Gardner's to Mr. Fernandez's to the trust back to Mr. Fernandez. And if that's the way they were received, okay, I got it. But we don't know that because they're not being provided to us what we believe, you know, in the form that they were received from NFCU. Maybe they are, okay, but there's clearly some explanation document as to why some documents are missing, and we don't have that either.
Okay.
And
what witness would this relate to, 27?
John.
the report was written by Detective Johns.
Is there a witness that's listed for Navy Federal?
I don't believe so, Your Honor. I think if anything, there may be a category B that has a custodian of records.
All right. All right, Ms. Day.
The next one, item 156, the DLE surveillance clip. I anticipated that being just one video, considering we only have one FDLE report, which is for a review of a single video. But on Thursday, we received 323 videos.
Of what?
A mishmash of surveillance, ring videos, Nest cameras, things like that.
Whereas FDLE in their report talks about a specific video, 1800 to 1900, Fed 16 driveway camera, 49.21 truck.mp4.
And you don't know whether that's contained therein, what was disclosed?
I have not gone through the 323 videos.
And I think our point is, Judge, is that they're just dumping things on us without making an effort on their side to be responsive to our demand.
So in the order, I wanted you all to get what was, at least according to the documents that have been filed, in the property room. So I gave them time, that is 5 days, to categorize and update the discovery. I don't think the 5 days have expired at this point. So what they provided to you, they should be documenting, and the order was for them to categorize them pursuant to 3.220. Do you see what I'm saying?
Judge,
like I wanted you all to be able to get whatever, in going through the list in the compel, some of these things, for example, where it says SDE, which stands for State Discovery Exhibit, July of 2022. So y'all, in my mind, should have had this 3 years ago. So I wasn't expecting necessarily that it would be categorized. I wanted you all to have the information. They had the time to categorize it at that point in time. If they needed to update, they could update. But what was sitting in the property room, I didn't want it just sitting there. I wanted y'all to have the ability to have it. So I think is some of this new to you? The fact that there are 323 videos?
This information they're telling me is new to me today, and all they had to do was call me and tell me. I had them come Thursday, the idea being, I didn't want this to happen, make an appointment with my paralegal. He did which is going to be part of my filing, actually organized each response based on what we pulled from the property room, exactly as it was in the property room, by the number corresponding to their list, for them to click on each folder in the presence of my paralegal, verify what was there. There was one video from Walmart that wouldn't work. They all spoke via email. They signed off, both Ms. Day and Ms. Peoples, at the bottom of this sheet. I heard nothing otherwise to indicate that there was any issues or problems that they're bringing to the court's attention now in open court. So I have not categorized or done the disclosure or the filing yet. From my perspective, I heard nothing. I got a signed receipt saying I received all these items, other than an email alerting me a Walmart video didn't work, so I brought a working copy this morning. So I'm sorry I can't respond to this right now. This is a surprise to me this morning.
Well,
but I will say to the court, what they've been provided, my paralegal and Detective Johns actually pulled the property clerk from Jack's Beach property and copied as is what was listed and attached to each supplement. The FDLE surveillance clip, when I looked at the folder, it was organized into subfolders, which showed the clips that FDLE had made, and I believe he included the full videos that they pulled the clips from, just for reference. It's not meant to be a data dump. It's meant to be a completion of discovery. Number 5, they received one slide. They showed me one slide in court Friday. I had no idea that there were additional slides they were requesting. So I'm going as best I can off their list. And I'm going off of the reference reports for Jax Beach Police. So I think this could be all solved if we just have a conversation or discuss this at our Thursday hearing, our Thursday discovery meeting, because I think there's some things where I could easily clear up, like the Oscar 360 diagrams, those 4 diagrams are what we have. That came straight from the property room. If they have other questions, I'm happy to answer them Thursday, but I will file the disclosure listing anything that wasn't previously provided and/or read.
Hold on. The FDLE, what unit is this? And
it is the video, I don't know the technical term for it. FDLE has a unit, and they were able to take surveillance video from the scene, from various Ring cameras, Nest cameras, surveillance cameras, and make attempts to basically zoom in, lighten it, augment the video so that it was more visible in order to identify the shooter. So it was more so just kind of a technical editing to make it more visible.
all right, and this, I'm assuming the 323 was not disclosed that way. The 323 videos.
I will have to look. All the videos were previously disclosed because those are the surveillance from the scene. I can disclose specifically the video clips that are in the subfolders in the folder they've been provided. It was more, and to be honest with the court, it was for investigative purposes that we did the video editing. At the time, we did not know the identity of the shooter. I don't know there are discovery purposes to it, but it was truly an attempt to identify the individual that we see on scene committing the homicide before we knew who it was. So it was an investigative step that we did.
Okay. Well, let me finish the list with Ms. Day.
Yes, ma'am.
We were on 156. So there were 323 videos.
Yes.
And the time frame was 1800 to 1900. You thought it was one clip?
I know it was one clip. The report from FDLE says they received one clip via email.
Okay. Okay, keep going.
Then we kind of already talked about 157 and 158 are the same as, I think it was item 15, the Oscar 360 photos. There was no response to items 160, 161, or 162. Item 171 was a surveillance video from 4021 Palm Way. We have not gotten those ones to appear. It just appears as black and white static. I'm not sure if it's that way on the state's end as well, or just ours, but that video we have issues with.
Which number was that?
171. Technical issues, like you open it up and it's nothing, or it just appears to be like?
It just shows as black and white static.
All right.
I believe we received 176 and 177 via a flash drive this morning, though I have not had a chance to go through them.
176 and what?
177.
Okay.
Or, no, I'm sorry. 176. We got 176 this morning, not 177. We got 177 on Thursday. But Ms. Stifler's assistant, Mr. Taylor, indicated Detective Johns could not recall what ESST stood for. So we got 155 surveillance videos, and we believe that they're duplicates, but I suppose we still don't actually know the purpose of them.
So you did get a response to 177 and it's 155 videos?
Yes.
All right. All right.
178, which should be the Snapchat clip of scene provided by E. Frauenheim. We received a screenshot of an Instagram post as opposed to a Snapchat video.
Is it Instagram related or no?
It is an Instagram post. I don't know why it's labeled Snapchat.
So that needs an amendment?
Yes, ma'am.
Okay.
Then there was no response to 179.
There is. On your hard drive, we included the last file, prior email regarding 179 and 180.
That's the question.
Yes, ma'am.
179 and 180?
And again, as I said, I can't provide something that's not tangible, so I did let them know that I was prepared to answer the questions. Nobody followed up. So I'm prepared to answer the questions. There's no ability to put that onto a folder. As far as 160, 161, and 162, there are none. There were no photos taken of those items, of the fingerprinting.
So 160, 161.
And 162, there are none further.
It says it was in a previous discovery download, is that not right?
There are no further media release images. We disclose the 3 that exist.
And when they're referring to photographs, are they talking about like latent print cards, or is that
Yes.
captured different?
Much like JSO processing, they don't, at least in my experience, there's nothing to photograph when they're processing the fingerprints. I'm certain that there are fingerprint cards, most likely, that when they depose the person who's doing the fingerprint, they could provide those, or I can request those, but there are no photos. They don't photograph the latent print cards.
Ms. Day, what were y'all expecting? Do y'all just want to inspect it if it exists with an expert?
Yeah, I had kind of just thought that there would be a photograph of a print collected. If that doesn't exist, it doesn't exist, but...
No, it probably exists in a different form, I guess is what... If it's similar to JSO, it'll be a card, and then the card remains with property.
They wouldn't photograph fingerprint, unless it was like a bloody fingerprint or something on a scene, there'd be a photograph, but just regular latent fingerprints, they don't photograph that generally, but there will... Did you
want to inspect it?
We may ask for that, yeah.
Why don't you clarify then, instead of no response, okay?
Yes, Your Honor.
Well, I'm telling the state to clarify. If it's a card, it's a card, or if it exists
Yes, Your
with the expert.
And I'm not trying to overstate this, but again, if we all speak Thursday and I'm able to file the state's response as required by the court, I think a lot of this will be cleared up.
Right, I just want to know when you all do respond,
Yes, ma'am.
that it's either resolved or we need to move forward. So,
We were at 178. Were there others?
I don't see a folder for 179 on my external, so
It's not a folder, it's an email. It says prior email regarding 179 and 180.
Okay, I just didn't scroll far. Okay, so I do have that one. Then 181, the body-worn camera from Henry Tenon's arrest. We received 2 videos from January 25th, 2023, but he was initially arrested on August 18th, 2022. That footage has been sent to the media, and we did find it or a clip of it on YouTube. So that is the footage that we're requesting.
Okay. So his arrest on the DWSR, not his arrest on the homicide?
Yes.
What are tire stains?
There was staining on a tire left in a road that was photographed and swabbed.
Did y'all?
I'm sorry, well, I don't know what was in the folder, but there was
Okay.
ET photographs of the tire. I don't know what she meant by stains. The stains were swabbed and sent for processing.
All right, y'all got that?
Yes, Your Honor.
Okay, what else?
I had marked 185 as a video that we could not play, but I did get it via flash drive this morning. I just haven't had a chance to open it and review it.
Okay.
And then I had marked 186 as we received 69 videos, but I was not able to get them to open or play.
So you believe you're missing one? It says 70.
Yes, so we're probably missing one, and still having trouble opening.
All right. Does that conclude it?
Yes, Your Honor.
Okay. So what I'm going to do is I'm going to hold and see what you all are able to resolve as far as this meeting that's going to occur. To the extent that the state can, I guess, maybe amend some of the things and have it prepared prior to your meeting on Friday, I think it might help clarify some things. For example, if it's mislabeled, if it's, like if you call over there and you say, these aren't photographs, this is a card that exists with, as much as you can clarify, because I think that, if I'm hearing Mr. Curated correctly, he wants to be prepared, Ms. Day wants to be prepared for what they're, I guess, going into, and they should be prepared saying, this is what we're missing. And then y'all are going to work on the remainder of the list? Is that how it's going to work?
Yes, on Thursday, I want to discuss with them.
Is it Thursday or Friday?
Our discovery meeting's Thursday.
Okay.
Specifically, the subpoena returns, the way that the documents are being tendered to them is the way that we receive them from the bank. Mr. Fernandez, Ms. Gardner, and her trust, they were all on accounts together, so the accounts are mixed together. I didn't just throw them in a pile and photocopy them that way. That's how I received them from Navy Federal, Regions Bank. The biggest lift for my side, as I told the court last time, is going to be to try to correlate for them the responses we received based on the subpoenas we were given. Because we sent subpoenas multiple times to the same bank because they were not responding to our date ranges, or they were sending unresponsive records. So it's not just a discovery problem, that is how we received it from the bank. If I have to list somebody from the bank and make them available for deposition to testify from their end about how they receive records, how they keep records, I'm happy to do that, but that's going to take me some time. I can't do that. Like going to the property room in 5 days was fine, but it's going to take a conversation between us and defense counsel, which is why I think Thursday will be helpful. We're not going to be able to solve it Thursday. I don't want to give the court or defense any false expectations there. I'm not going to be able to sit in an hour and line by line match up a subpoena return to a subpoena for each one of these bank records, but I can certainly get from them an idea of where their confusion is. Questions like, this subpoena is attached to this supplement, it has this date range, and we have records for X date range. Some of the explanations given were because detectives are calling and following up, so there may be letters of explanation, there may be information they received via telephone. I can help put on notice defense if there's information that they need to ask the detectives about at depositions regarding any conversations they had orally with any of these custodians or people from these financial institutions cell phone carriers, et cetera.
Okay. All right, let's, you have the detective here on the devices.
Yes, Your Honor.
Okay,
You want him to step forward?
yes. Good morning.
Good morning, Your Honor.
Detective J.S. Padilla, P-A-D-I-L-L-A.
All right, so the reason why I asked that you come to court is that the state, I believe you asked for 60 days.
I'll let Detective Padilla speak to that. Judge, I have spoken with the detective, and we have reviewed Ms. Gardner's motion to compel digital forensic data. What has become clear to me, having spoken to their expert via email and speaking with Detective Padilla, is that they are requesting forensic imaging and extractions from the devices themselves, which colloquially we have been referring to in court as quote-unquote raw data. That is generally not something that is in the state's possession. I have, in my career in our office, never received raw data from a phone extraction. I receive a Cellbrite download or an Axiom download for a device from the CFIU unit. I give it in discovery. That is not something we generally ever receive and or tender in discovery. There have been cases where defense hires a forensic expert who makes a request to inspect or a request to look at the raw data or receive raw data for a device. The reason being, and I'll have Detective Padilla testify to this in a moment or explain to the court in a moment, the data from the phone has to be parsed so that it's readable. If they have an expert who wishes to parse the data themselves, that is why they would want to receive that raw data. The raw data is voluminous. It is very, very difficult to transfer. It is going to take a long time to transfer between devices. When they parse the data, the court should not be surprised, and their expert, I'm sure, would tell you the same thing. The parsed data they get is going to be different from the data we parsed because it's been 2 years since we parsed it. Because of the way Cellbrite and Axiom work and the way cell phones work, as iOS's update or Android software updates and Cellbrite updates its software over time, we are able to parse more data as we catch up to the technology of the phone. So I just want everyone to not be aware that that's going to happen, and that's normal and expected. However, their motion to me seems to be just a blanket, we want this raw data for every device in the case, including devices that in a state's estimation have little evidentiary value. The deceased victim's work computer, the deceased victim's laptop, some other items, and the computers contain an exponentially large amount of data, larger than the raw data you would get from a cell phone. So I will have Detective Padilla explain to the court the timeline and the procedure of what he's going to do, as well as to advise the court. And as it regards to Jared Bridegan's devices, the raw data is stored currently on a CFIU detective's hard drive. CFIU for JSO recently moved offices to a new location. During the move, part of his hard drive was damaged. Detective Padilla has been undergoing a data recovery procedure, and I'll let him kind of explain to the court how that's going, but that is going to, at least for the deceased victims' devices, that is going to be longer than 60 days to recover that data and give them the raw data from his computers. If they wish to parse the deceased victims' work computer data themselves, I mean, they're entitled to ask to inspect and do this, but it's not something we normally do in discovery. It is something if they are requesting and the court orders me to do it, we will do it, but it is going to take some time for those devices particularly.
All right, so I want to kind of hone in on the issues. Is that what the defense is requesting? Did you want this detective to do it, or were you all attempting to have your expert, because I recall it could be related to some other issue, but I recall you all saying that you were having an expert come in, making an appointment, that appointment was canceled. So explain to me exactly what you are requesting related to these devices.
Your Honor, it's my understanding that we want the raw data.
How? Do you want your expert, like you can make an appointment, inspect, and
copy? I mean, I think that was the initial idea, was to copy the raw data.
All right, and so you don't necessarily want JSO to provide it, you want to be able to copy it?
If JSO wants to provide it, we'll take it. Or if they want to make it available to us, we'll copy it. I don't know why Ms. Stifler says it's, quote, not in the state's possession. Obviously, if it's in the possession of the Secret Service or other agencies that worked along with the state to prosecute this, it's in the possession of the state and it's subject to inspection, copying, and otherwise discovery. So we've asked for it. That's what we want. If they want to copy it and provide it to us, that's fine. If they want to give us access to their CFI, I think part of the problem is it's on a CFI hard drive. My understanding is they don't want to give us, our expert, access to their computer system, so they need to put it on some other form of media for us to take it.
All right. Well, Detective, if you'll be sworn in.
One thing, Your Honor, just to clarify that. Their expert can't extract the devices himself. It's not like I can hand him the computer and have him extract it, because once you turn a device off and leave it off, the system is going to update it, and the data that we've extracted is going to be more complete than if you did another extraction. The data we extract, okay, well, I'll let him speak to it. But to copy this data, he's saying copy it. His expert can't just come and copy the data. It's going to take
Let me answer that.
36 hours.
All right. You raise your right hand to be sworn in.
Detective, do you solemnly swear from the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would please state your full name for the record.
Yeah, Detective James Padilla, but I go by my middle name, Shannon.
Okay. Detective, have you reviewed this list?
Briefly, yes. I was provided this on Friday.
Okay. Let's, do you understand what they're asking for?
Yes, and if I can just clarify a few issues that would be we're all in the same.
Wait. I want to know the easy answers first.
I'm trying.
Okay, the easy answers from this list, what can be provided as quickly as you can?
Quickly is a relative term in regards to this.
Well, what is what can you provide?
I am currently not in possession of any of these items, so I first have to get it from whatever examiner provided this dump for them.
Wait a minute. Who?
There's multiple examiners that were involved in this case. I was not one of them.
All right.
I was brought in to help facilitate making sure all the data that was collected from all the examiners, one point of contact, so that the defense can have one response from us.
Okay.
That's been what I've been tasked to do. And to clarify, there are 3 states of information. First is the actual device that was being used, say a cell phone. Next, we're going to extract data off it. That would be what we call the raw data. And then there's the parsed decoded data that we would provide normally to the state. Our general practice is we do not provide the raw data because it's such a large data set. We usually parse, decode it, and provide that report to the state. We will provide the raw data when necessary. In this case, we're looking at somewhere around 19 devices. That's a large amount of data, and it's going to be very difficult. And to put into some kind of perspective, most of these are going to be roughly 1 terabyte to 2 terabytes worth of data, which is a large amount of data. 1 terabyte takes 4 to 6 hours to copy from point A to point B. I'm having to get this from whatever examiner provided it initially, which means they're going to take 4 to 6 hours to copy it to a device to give to me. I'm going to have to take 4 to 6 hours to move it to a device that I can work on it. And then I'm going to have to validate and verify that the data is the same as provided to me. And therefore, that's another 4 to 6 hours of processing and validation.
Wait a minute. So on this list, I'm counting 13, not 19. Where's that coming from?
That's, like I said, roughly 19. I haven't counted.
So it's 13.
Yes.
And I understand that it would take some time. So what this court wants to avoid is that they are I guess, scheduling this time with whatever expert, that it's not wasted, okay? So let's just, is one of them, I know that you want all, is one of them more probative to move you all forward? And you can have kind of a priority list of your work. Since I don't like to look at things in this big, like, oh my gosh, this is too much, because that never gets anywhere. Because if you just stop, or if we don't prioritize, we're not moving. So if y'all had to prioritize this motion.
Judge, can I file something with the court then after
Yes.
today? I'm not prepared to answer that right now.
Okay.
And just for court and defense's information, and I had spoken with Ms. Medina about this. On their list, there are 2 categories at the end: not accessible, Apple MacBook Pro and Lacey external drive, and then another one, found in Potomac and not correlated to Tenon, 4 devices. We have no ability. The non-accessible means that they are encrypted, so the data is, we can't decode it. So those are not accessible to us or to defense. So there is no ability for us to give any kind of discovery related to those items. Through no fault of our own, we're unable to, I guess, crack into them, I guess is the way I would phrase that. Found in Potomac and not correlated, there were 4 devices that we seized during a search warrant at the Potomac house. We were unable to correlate those 4 devices to any of our suspects or co-conspirators in this case. So
Were they downloaded?
No, ma'am. They're just in property, they're not downloaded. So that, again, there's no discovery relating to these items. They were not correlated to our search warrant. We had no probable cause to connect them to our suspects, so we have not downloaded them.
Okay.
Judge, if we could get a written response, I mean, I think part of the problem is that this motion that Ms. Medina was filed the 31st of March, and this is the...
No, I get it.
Yeah.
So,
And Ms. Medina and I have been emailing about this. In fact, these categories, not accessible and found in Potomac, are based on the information I gave her regarding what I just put on the record. But I've been telling the court and telling defense I plan to file a written response. I just have not been prepared to do so until we discuss amongst each other. I'll discuss with my expert, discuss with my detective. After our discovery meeting, I should be able to file some written responses to these if we're not able to come to an accord.
So I guess maybe some of this confusion maybe came up that it got uploaded on this evidence.com. It was placed on some type of disclosure as an exhibit, but what detective we're trying to avoid as much as possible, right, is a moving target on
He's reviewed this motion. There's some indication here that there's a download user error because some of the folders are different sizes and cannot extract, which it could be there was a computer task occurring at the same time the download was happening that interrupted it. But he is verifying the data and hash valuing each of these devices so we can tell defense this device should be 184 gigabytes. If you have it, it's that size and you're opening it, that's the correct version.
Okay. So for example, let's just start with the first one, just so I have an understanding. Black iPhone. Were you able to associate that? Has it been down? It says no forensic images or extraction. So are you going to go through this list and say whether you had it extracted or whether there was a second search warrant?
Yes, the black iPhone 19 belongs to the deceased victim in this case. It was extracted and the data was parsed. They're requesting forensic images and extractions, which is the raw data. Raw data, unless you have a forensic machine, like a physical analyzer on a hard drive, they could give it to me, I would never be able to open it and read it. I don't have the correct forensic equipment to parse and decode the data to make it readable.
Okay, hold on just one. Is that what y'all are requesting? It looks like you just don't have anything. It says that the Word document cannot be opened. I don't know what CRC stands for, but has an error. It just appears that they can't open it.
And Judge, that's my understanding as to what Ms. Medina was pointing out.
Right, not that Like,
And I think that's separate and distinct from getting the raw data from some of the devices that was being requested.
So many of these, they have the cell bright extraction, and I have disk.
what does CRC stand for, just so I know?
It's it's like a hash, but it's a validation check that a software does. I'm assuming that's a zip file or an archive file, that when it was extracted, it failed at CRC check.
Oh, so maybe it's not working on y'all's end either.
I have not looked at the data yet. I'm still trying to gather all this data from all the examiners.
Okay.
But my task was to take all of the data from all of these devices and collate them together, verify that they all work, verify that this is all the true and accurate thing, and then so they can get a true copy in one dump. The biggest problem I have is one of the examiners, as she mentioned, his hardware failed. The majority of these items are on that piece of hardware. I'm actively trying to recover that data. I am about a week into the recovery process right now, and it continues to fail. So my hope is by the end of the week that I'll have access to that data. But that's the biggest challenge, is getting that data off that drive.
And that particular data relates mainly to the devices of the deceased victim in this case.
Okay.
But handing them, their expert and I have been in communication, Ms. Medina and I. My understanding is they want the raw data because they have a forensic expert who will be able to parse it. Otherwise, if I hand a defense attorney a hard drive with forensic imaging extraction raw data, I might as well be handing them a doorstop because you can't read it, you can't view it, you can't do anything with it.
I understand.
The physical analyzer.
I understand.
Something like that.
But what I'm looking at on their motion to compel is that what the detective just said, that these things have failed, they have no ability to even look at what detectives have. So why don't we...
Do we want to prioritize? So Gardner's motion to me is a request to provide raw data.
I will let them...
This motion is...
I'm going to let them talk about it. But to me, the raw data, I understand it's going to take some time. I don't know how long it would take to come up with just usable reports for attorneys to look at. It looks like 1, 2, and you're saying that hard drive got corrupted, and that's what these are on, and the devices don't.
So it's a RAID. It's 4 drives that work in conjunction as one drive, and there's a hardware component that makes them talk together. That hardware component failed, so the individual drives are not talking to each other, and the only way to get data off those drives is to make those 3 talk together. So the hardware has failed, and I guess in the transit or the move, it got damaged.
What about the device? It doesn't exist on a device anymore?
I don't know exactly what's on his hard drive.
No, I mean, like, so...
Just talking about re-extracting.
Yeah.
Just redoing the device. You can't do that?
JSO doesn't have any of these devices. This is all Jack's Beach, so they may or may not have the devices. I don't know the status of the evidence. Because when we got, just to back up a little bit, when somebody submits something that's out of jurisdiction for JSO to us, say a cell phone, it's not our property, got nothing to do with the case, we would have returned it back to the investigating agency, in this case, Jack's Beach.
Jack's Beach still has these services in the past.
So maybe...
That is possible. The problem is when you talk about a cell phone, it's running off of SQLite databases. As soon as you power that phone back up, data is going to move. Databases are going to purge data that was scheduled for purging, and it's going to have a lot of different data that we didn't have, 3 years ago when this was all done, or 4 years ago. So it's going to be different data, and it's going to create a whole host of other information if we do that.
Well, they're saying they don't have anything.
I know, and my hope is I can recover the data off this hard drive, and I will have all of the original data. But I won't know that until later this week when the process. I've gone 16 and a half hours so far of actual computer processing time of it rebuilding that RAID. So I haven't been to the office this morning, so it was running over the weekend. So I'm hoping when I get to the office this afternoon that at least phase 1, and I'm able to image all those drives to start the next phase, is to recover the data off it. So that's my goal, is to get that data. The majority of these items are on that hard drive, and that's the first challenge. The second thing is re-extracting all this data. You're talking 40 to 60 hours of work to download all these datas again, and that's actual time.
Okay. Well, I'll table it. I'll let y'all talk. You prioritize.
Yes, Judge.
In my mind, so obviously I'm familiar with like re-downloading, the fact that Cellbrite updates, that it can get more information. If it is, you know, when you all speak, maybe, you know, to me, it should be wherever y'all are with the discovery. Let's say, according to this, whatever was filed, they don't have anything. So saying that the extraction hasn't been received. So
well, the extraction refers to the raw data. They do have the Cellbrite reports because
you do,
as Ms. Day noted on her motion, they have a lot of the Cellbrite reports. They're having different sizes of files. All these Cellbrite UFDR reports that are readable have been provided on evidence.com. For the deceased victim, I have CDs, discs. If they're missing that, that's news to me, and I can provide that this week. It's their motion, I'm reading it as forensic imaging and extraction, and that refers to the raw data. That to me was what they were missing. And that's kind of been my conversation with Ms. Medina, because Mr. Green, the only reason I'd ever provide this is if somebody had an expert, otherwise it's not useful information. This was what we were doing to get ready for that meeting with Mr. Green. So this was a list that she and I have been passing back and forth that she's picked.
is that what y'all are looking for?
Judge, I can't answer that question.
Okay.
You know, I have reason to think that Ms. Stifler is incorrect. Yeah. So if that's the case, that's the case. I just know that there was a motion filed, and that's what we were looking for.
All right.
And just to clarify one thing, because if we're going to start down this road, the prioritization would be very helpful, because the bigger devices, some of the ones that are going to take longer, are computers. So if the deceased victim's work computer is a low priority to them, that is one that would take a long, long, long time. We can put it to the bottom of the list. I also need to know from Fernandez's team if they are requesting raw data, if they have an expert that's going to parse it, because I need to know if I need 2 copies of this down the line. Obviously, it'll take twice as long.
Okay, well, y'all can handle that offline, okay? I will get an order out. I did see the notice on the report, so I will enter an order allowing Mr. Gano to distribute his work.
Yes, Judge.
All right. 2 weeks. Two, maybe 3. Maybe the week of May 5th.
Yes, ma'am. I'm out all next week, so I would ask for 3 weeks so that I have time to coordinate. Bless you.
Sometime the week of May 5th.
Yes, Judge.
You all tell me.
If it's fine.
5th? Okay.
We could have the 6th or 7th.
Judge, I have a 10 o'clock federal court hearing on the 6th, so for as long as you can get me out of here by 9:30.
7th? Really, Mr. Crody?
I'm available the 7th.
7th? Have you all talked about the trial date? It's set for October. We're not going to make it.
We've discussed the...
Mr. Rahi was not at the last court date, so
Right,
we discussed
so
the trial date. I think the defense was going to...
I'm just asking, did you all discuss it amongst yourselves, or do you want to wait until this May 7th date?
The state has discussed it amongst our team. We have not discussed it with defense yet.
Do you want to wait until May 7th?
That's fine, Judge. Do we want to strike the October dates at this point? I don't think anyone in this courtroom believes we're going to make it.
Let's strike it.
Thank you.
So I'm holding courtrooms. The clerk's office is, even what I'm trying to get y'all to do, like Mr. Mizrahi, you weren't here, but my thought was we move it to 2026, and with thought into scheduling, thought into if we're going to have that number of jurors, right, and I want them working as simultaneously as they possibly can. And when you all are talking about, like, we're going through the discovery, right, that the state thinks about how you would do it. As much duplication as possible for the jurors. Obviously, physical evidence cannot. They could share it, but I want the juries working as simultaneously as they possibly can. So I want them overlapping. I want them, like, for example, like one gets closed down, one is closing, both are working. The defendants, if it becomes necessary in a penalty phase, as little downtime as the jurors can have.
Well, all right then. I guess they're cutting poor judge off right there. All right, so that's a big mishmash. I got some cool stuff to show you. I got a video from Axiom, evidence.com, which talks about it. So they talked about a lot. There's an online blogger that has a website with documents. They talk about this ATF report. Yeah, the Secret Service is involved. They talk about so the defense isn't receiving. They're receiving a mishmash of surveillance videos, 223 items. The defense is complaining the state's just dumping stuff on us. So evidence.com is this. I posted a couple of times. It's just like this portal for. And Axion is the body camera, right? That's the body worn camera that we see. And so it's a portal. It's a portal that JSO, Jacksonville Sheriff's Office uses. And I guess there's Jax Beach as well. So there's Jax Beach officers. There's JSO, Jacksonville Sheriff's officers. So this detective, Shanna Padilla, so basically they extracted these. They said 19, but judge says she only has 13 devices. They extracted them 2 years ago, maybe not all of them, but they extracted some data from 2 years ago. And as OS's update, you can get more information out of those extractions. And with Cellbrite updating, they're always updating their software as well. So the defense wants the raw data, but Detective Padilla is saying, I can't give them the raw data because that's like, and states like, that's like giving them a doorstop. They can't do anything with the raw data. They have to put that through Cellbrite, right? And and the defense wants it within, I think, 30 days or 60 days. What did I write down? I think they want it within 60 days. And Detective Padilla is saying each device has a terabyte and takes about 4 to 6 hours. He's already put 16 hours worth of work in, and he needs at least another 40 to 60 hours. So I guess he's saying he can't deliver what the defense is asking for in the time that they're asking. So, and then one of Jared's devices, I guess it was his computer, got some damage in transferring from wherever, I guess his house, to the lab or wherever they do the extraction. So he was talking about that. So even that's a problem. So it sounds like it's just a big cluster all the way around. All right, so here's evidence.com. Let's check these guys out. This is a video. It might help us understand a little bit more.
And more evidence.
All right, so this is from evidence.com.
Every day, more and more agencies are adopting body cameras. What does this development mean for prosecutors like you? Better video evidence than before, and more evidence to manage than ever. We think the evidence sharing process is broken when agencies have to burn evidence to disks and ship them off to you. Then you have to share the evidence within your office and prepare files for the defense, the public, and the press. This process could take a week or more. Well, what if we can make sharing files easier? Enter Evidence.com, a secure digital data management system used by prosecutors and law enforcement agencies across the country. It's easy to use. Once an agency creates a new file and shares a case with you, you'll be immediately notified. With just a few clicks, you can accept a case and share it with others. Now, a week-long process can take you just a few hours, if that. Concerned about security? We are too. That's why we employ industry-leading security practices that have earned us the trust of thousands of agencies on our platform. All your actions are recorded in an audit log to ensure chain of custody and authenticity. And don't worry, your files are still admissible in court. Ready to live in a disk-free world? Evidence.com's free standard plan may just be the answer to your office's evidence sharing needs. Contact us to learn more.
So it's basically moving people or moving evidence sharing from disks, which I guess were paper files at one point. Then everything went digital, so you got onto CDs, and then now it's just sharing via cloud base. So it's just the next step. All right, Richard, this is for you. You were talking, or you were asking about Henry Tenon. This happened in February, so let's check this out. So Henry Tenon is the alleged shooter. He's the alleged trigger person. So let's check this out. So this is a lawyer reacts to it, but then I actually have him in court. So we'll see Henry Tenon, and Henry Tenon was a tenant of Mario. So that's the connection there.
This is a major issue for the state of Florida in that their key witness is now saying, I am not going to get on the stand and I don't care what happens to me.
Henry Tenon submitted a motion to withdraw his plea on Friday morning. G. Nichols is an attorney we talk to frequently for legal analysis. This case is no different. The document Tenon submitted is 3 pages and doesn't give us much information about the reason why he's changing his plea. It just says he informed his attorneys that he will not testify against Shanna Gardner and Mario Fernandez.
So he has not come out to say I was coerced or I was threatened or I was forced or I misunderstood the deal or I wasn't advised of all of my rights. He is solely coming out to say, I don't want to participate in the deal that I entered into anymore. And so now it will be up to Judge Kite as to whether or not to let him out of his plea.
Tenon still hasn't sat for a deposition, and defense lawyers are wanting more information from him as well. Nichols believes that Tenon deciding to change his plea throws a wrench in the state's plan.
Knowing that Tenon is a huge linchpin and he is a huge part of blaming the other two, and if he's not going to get up on the stand to blame the other two, that it's definitely going to cause the state to have to pivot a tremendous amount.
With the plea deal, Tenon was facing a minimum of 15 years and a maximum of life in prison. If the plea deal gets taken away, he's likely walked himself into a life sentence. Nichols says the reason why he's changing his plea is something lawyers hear about all the time.
People don't want to go to prison when everybody knows that they've testified against others, and so that could be one of the reasons. He could have a change of heart. He could have a change of mind. He may have given a statement that wasn't true in the first place. We just don't know at this point in time, and the motion in and of itself doesn't tell us that.
So, yeah, Miss Bree, he was the alleged shooter. He's the alleged, Henry was the alleged trigger person. He's the alleged trigger person. Here, I wanted to show, we're kind of jumping around a little bit, but we were talking about, is this DP? And yes, they are seeking the DP. So let me show this real quick. So this I don't know if this is going to change, but this is what notice of intent to seek DP, notice of aggravating factors. The state of Florida, by and through the undersigned attorney, the assistant state attorney, does hereby give notice to the defendant in this case, pursuant to Florida statute, that the state of Florida intends to seek the DP for the first-degree charges in this case. The applicable statutory aggravating circumstance are as follows. The defendant was previously convicted of another capital felony or of a felony involving the use of threat or violence to the person. The capital felony was committed for pecuniary gain. The capital felony was a homicide and was committed in cold, calculated, and premeditated manner without the pretense of moral or legal justification. We heard all about that in the Charles Jones shooting, CCP, cold, calculated, and premeditated. And they only have to meet one. They only have to meet one criteria as we aggravating factor, as we found out in Charles Jones, the Julio case. So they are seeking the DP. So they're going to seek the DP. All right. So next, I want to show Henry Tenon withdrawing his plea deal. So we just kind of heard a little clip there. Let's actually watch him do it. So he is the alleged shooter. He's the alleged trigger person. He's the alleged shooter. He had first admitted it, and then he's withdrawing his. Hold on a sec. I'm going to take that down. Yeah, we'll just do that. All right, so he admitted it, and now he's recanting that.
If it's okay with the court.
I'm fine with that.
It's defensive of that.
Certainly fine. Okay. Do you want Mr. Tenon to be seated? Certainly. Okay.
So, Mr. Tenon.
Let's just, give me one moment, I'm going to make sure. Okay. Did you take care of that housekeeping matter?
Yes, Your Honor.
Okay. In that 22 case, correct? Okay. All right, so we are operating on the motion that was filed in 23 CF 888. Ms. Schlatt.
Yes, Your Honor. On Friday, we did file this motion to withdraw plea pursuant to 3.170 subsection F. And specifically, we're asking this court to use her discretion and allow Mr. Tenon to have a trial on the merits in his case. Your Honor, we have not alleged any wrongdoing. We are just simply asking the court to use her available discretion, since Mr. Tenon has not been sentenced, to set this case for trial and proceed to trial.
What's a good cause?
We are not articulating a good cause, Your Honor. That's why we are simply asking under 3.170 for the court to use her ability to grant a trial on the merits.
Okay.
And the state has no objection to the court granting that motion with forward to a trial. At the same time, the state is not filing a motion from the state's perspective, to have the defendant's plea agreement undone, and the state would have no objection if the court proceeds to sentencing right now, or in the next few weeks with the defendant. So we leave it up to the court's discretion. We have no objection to the granting of the motion.
So my concern is that I just want to ensure that it's bona fide. That I don't, whatever path to resolution, it obviously does not, I don't care, but I do care about how an individual is charged with a crime wants to resolve his case. So if you don't mind, I'd like to inquire of Mr. Tenon, just to make sure that it's bona fide. And this is what he wants to do, because I'm assuming that the state isn't going to go back and forth as well, like with plea offers. And is there anything that you want to put on the record related to Mr. Tenon's decision for him to consider?
Not from the state's perspective. We're willing to go to sentencing right now. It's made clear, and we're willing for the court to grant it to the trial. state's position.
All right. All right, Mr. Tenon, if you come forward, please.
Mr. Tenon, will you raise your right hand as best you can, sir? Sir, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, good morning, Mr. Tenon. So the reason, did you understand what I said to your lawyer?
Do I know what?
Did you understand what I said to your lawyer?
Yes.
Do you have any questions about it?
No.
All right, so the reason why you're before me is because there was an information filed in your case, it looks like way back in February 1st of 2023. Are you with me?
Yes.
Okay. And then after that, there was a plea entered that there was an agreement that was reached by you in the state of Florida in this case, correct?
Yes.
All right. And then your case, ever since I met you, has been kind of tracking along. And then on Friday, there was a motion filed indicating that you no longer want to enter a plea of guilty.
Correct.
All right. So my purpose in talking to you is just to determine whether you've had enough time with Ms. Schlax to discuss this matter with her.
Yes, we've got enough time.
Is this what you want to do?
Yes, it is.
Okay. And so if I do grant it, she's asking me to use my discretion, which means the state of Florida is willing to, I guess, keep whatever plea agreement you have entered in with them. That is what is it, 15 years to what? 15 years to life. Okay. Or Ms. Schlack's motion says that you want to try.
I didn't quite understand all of that here in the last.
Okay. What then? Do you want a moment with her?
I heard it, didn't understand it.
Move the microphone away, Ms. Schlack.
Okay.
So what do you want? Let me just put it simply. What do you want to do? Do you want to maintain your plea or do you want to try?
No, I want to try.
All right. You got it. It's granted.
Thank you.
Yes, sir. The motion will withdraw. His plea is granted.
Thank you, Your Honor.
You're welcome.
We will proceed with discovery if we could have a past date of approximately 3 weeks, Your Honor.
Has there been any participation? I don't think so.
My depositions, I have not. My first task will be getting transcripts for all the positions that have previously been taken.
Okay. So if the state would please facilitate that by, I think you filed in the Gardner Fernandez case, basically what has been accomplished. So if you could forward what you filed in their cases, they, for my purposes, have indicated that witnesses have been deposed already, and that should hopefully give you an opportunity to see what transcripts you should order. Okay. What's the state's status on the discovery in this case? Okay. Does Mr. Tenon's case have the same level of electronic?
No, but I'll provide both co-defendants. So we'll still get, even if it may or may not be relevant to this case, we'll still get the entirety of the discovery that's been provided.
All right, now that Mr. Tenon is back in basically a pretrial posture, what is the state's intent?
To try.
When?
As soon as Ms. Schlack's in the court are available, we're available. So, obviously, she has to be called up to speed. August is realistic to do that.
Well, he's not joined, so I mean, I would set a different date. That would be my intent. Okay, so what we'll do, tell me what your availability is.
I would suggest, Your Honor, March 16th, Monday.
I'm out then.
The next Monday, the 23rd.
Is the state available?
State's available the 23rd.
Okay, I'll see you then. So it'll be March 23rd, 9 a.m., and that's for pretrial. I'm assuming he's waived.
If he has not, we would immediately do so, Your Honor.
Has he waived? Mr.
I think
Hathaway?
he's later this week.
Okay, we need to get that accomplished today.
Your Honor, we can just pass it temporarily. I'll be happy to go over that with my client.
All right, thank you.
You're going to strike 4-7 status hearing?
Correct.
Thank you.
Thank you.
All right, so that's Henry Tenon. That's Henry Tenon, who was never connected. He was never going to be tried together with Shanna and Mario, and he recanted. So he first says he was the trigger man. Now he's saying he wants to have a trial. So he wants to go to trial. All right, so that's a little side jog there. Let's continue on. We're going to go back to July 31st of 2025. And as we go through these hearings, we'll hear them being separated or severed, and then also trial dates. So that's all coming up. So we just have to, we'll all watch it together.
So we now know the start date for the
All right, I'm not going to play that. I don't need to play that. That's it just being pushed. Oh, wait a minute. Is this it? All right, this was 9 months ago. Let me play this.
trial in the shooting death of a First Coast father of four. It will be delayed until August of next year, August 2026. That's more than 4 years after Jared Bridegan was shot and killed in Jack's Beach. And today the judge also decided the civil case against Bridegan's accused killers will not move forward until we know the outcome of the murder trial. Shanna Gardner and Mario Fernandez are both charged with first-degree murder and Bridegan's alleged 2022 murder for hire. Henry Tenon pleaded guilty to second-degree murder charges, but Bridegan's widow, Kirsten Bridegan, is also seeking $100,000 from Gardner, Fernandez, and Tenon for battery resulting in wrongful death. Kirsten Bridegan is seeking money to compensate for multiple things, including pain and suffering, loss of economic support, burial, and funeral expenses as well. The judge in the case said today she is considering bringing in as many as 500 potential jurors for the murder trial because of the high level of public interest in this case.
Woo! 500. All right. Good vibes only. Found a news from. They originally were seeking the DP. Now they are not. So November of 2025. They are now not an act of mercy, but state drops DP in Bridegan case. So they are not. Following months of motions, wrangling, and court hearings, the state's attorney's office, with support of Jared's widow, has withdrawn their intent to seek the DP. So they are not. This is not a DP case. So thank you, Good Vibes, for that. So this is not, I repeat, not a DP case. I didn't think so. And then when I saw one of the filings, I'm like, whoa, okay. I didn't think so. So I'm glad that that has been cleared up. So this is not going to be a DP case. All right, so now what's this here? Okay, so that little beep, beep, beep that you guys hear, that's signaling, literally signaling Judge Kite coming into the room. So every time she announces her presence. I love it. So Judge Kite announces her presence. So it may be annoying, but it's actually kind of cute. that the judge announces her. Oh, come on. The judge announces her her coming in. Jeez, my chat is so far behind. All right. Anyway, while that takes time to catch up, this is a hearing from September 9th of 2025.
All right. So for the CRB's on session. If that's kind of presiding. So we're not talking about full session. Have you seen it? Morning, Honor.
Good morning. Good morning, everyone.
Good morning, Your Honor.
Ms. Stifler.
Your Honor, Christina Stifler on behalf of the state on the cases of Mario Fernandez and Shanna Gardner, numbers 1 and 2 on the court's calendar.
Thank you. Good morning.
Good morning, Your Honor. Patrick Carodi, present with my client, Shanna Gardner.
Good morning, Your Honor. Jesse Dreiser, present with my client, Mr. Fernandez, along with Ms. Day, Frank Tassoni on Zoom, and James Hill on Zoom.
All right, thank you. Good morning.
Good morning.
And Your Honor, for the record, next of kin is present via Zoom for today's court date.
Okay, thank you for that. All right, we're here for a pretrial and a status, so.
Yes, ma'am. We've been conducting monthly discovery meetings. As we advised the court, we would be, the last being yesterday. We received the court's orders on the motions for protective order filed by both defense teams. And we have collectively, for both defense teams and myself, made redactions to the state's supplemental discovery exhibits based on the court's order. They're highlighted in orange so the clerk knows what needs to be redacted to comply with the court's order. And I've let Mr. Dreiser and Mr. Carodi review this, make additions, and we're all in agreement that these redactions encompass the court's order. So I'm filing state's 8th, 9th, 10th, 11th, and 12th supplemental discovery exhibits at this time.
Does the defense agree?
Yes, Your Honor. For the record, there are highlighted portions on those exhibits that we've agreed to be redacted.
Your Honor, for this hearing, may I remain seated? The microphone issue.
Yes. Yes, I'm
quite awkward.
Absolutely. The dates listed on here, those are the dates of disclosure to the defense?
Yes, Your Honor. I was just holding off on filing until the court's ruling on their motions. So the dates on there were the dates that I provided, the discovery exhibits for either to defense or viewing to defense, and the items listed have been provided as of those dates listed on there.
The 9th does not have any redactions. Y'all agree with that? Do you want to see it?
Sure.
Okay. I just want to make sure y'all agree, because that's the only one that does not have any highlighting or to the clerk. No, I don't. Thank you.
Then we were discussing while you were reviewing those records, just kind of putting the clerk's office on notice that although it's highlighted now, someone from the clerk's office will black it out through their protocol. Is that,
yes.
We're all on the same page on that? Okay.
Right, Ms. Nelson? Okay. All right.
Okay. Your Honor, defense also is in receipt of the verified hash valued extractions and the raw data requested by defense counsel. Both teams received a hard drive from Detective Padilla for the Secret Service and Jacksonville Sheriff's Office Computer Forensics Unit of 2.13 terabytes. And I confirmed with them yesterday that's the amount of data they have. They have an itemized list so their experts can compare the hash. And Detective Padilla confirmed for me that it should be 2.13 terabytes. So we're all in receipt of that digital evidence. And that was in response to the defense motion regarding duplicative devices. And once they've had the chance to review that, we can address it with the court if we need to. But that should have solved that issue. We do have depositions set October 10th and October 17th.
I did see that.
And I am working with defense on accepting service of subpoena for some of those witnesses.
And I'm assuming, I think I appreciate the cross noticing from Ms. Gardner's case so that both sides are documenting like the work that you're doing. And there's one witness, I think on the 17th that is North Carolina.
There's a few out of state. I've spoken with some of them are family members of the deceased victim. Defense has advised they will allow out of state witnesses to appear via Zoom, and those witnesses have confirmed that they'll appear via Zoom.
Y'all agree with that?
Yes, and we thank the state for their assistance with those witnesses.
Okay, you don't have to stand up. Okay, it's probably equally as awkward. Yes.
And just because we agree for the purposes of these depositions and probably many, but I don't know that that's a global agreement at all times that out-of-state witnesses that we won't do in person.
That's fine. I specifically asked Mr. Cody and Ms. Day yesterday at our Zoom meeting, and they said they were fine for this round. Rather than all of us traveling out of state, they're fine with these particular witnesses being via Zoom.
That's correct, Your Honor.
Okay. Is there anything further?
One additional matter on scheduling, if we could just approach sidebar.
Sure.
I want some time to think about some of the things that both defense has suggested and the court has suggested in regards to scheduling. And we will reach out to Your Honor regarding our logistics meeting.
Okay. So does the defense want to be heard at all? Okay. All right. So what I've done over the last few days is I've been going through the docket. It is this court's intent to honor that date that we have previously set. So in my mind, we need to start kind of using that time frame and then working backwards, making sure that we're all kind of getting to that point, because there will be a lot of resources and time spent on both sides. So I want to make sure that we are going to accomplish that date. So with that being said, in looking through the docket, I need the defense to kind of go through the motions that you have already filed and let me know whether you need a hearing on them or not. Okay, so some of them, I think Ms. Stifler referenced that this takes care of X motion. So the pending motions that this court has not entered an order on, I need by the next court date, a decision by the defense, whether you want to call it up for hearing or whether you want to file a notice of withdrawing it. Okay. And if you do file either, if you would just indicate the docket line, because we're getting deep in the docket, so that I can get to it expeditiously. Next is that the state, I believe, on December 12th of 2024, you provided the court with a discovery exhibit documenting the depositions that went forward. And then I believe that documented up to the deposition notice of the defense up to your 11th. And so now you all are on your 20th. So what I'd like to do, I'm going to enter a case management order So from this point forward, I would like for the parties to file notice with the court of the depositions that are accomplished. So on your notices, you have the list of names. It doesn't have to be anything like super formal, even if you all just want to put on the side, excused, whatever, and then file it so that we can just keep up to date, like not huge disclosures, but just kind of one after the other.
And I had intended to do so every 6 months or 10 notices. Do you want us to do it after every round of depots? I've been keeping track. I can file up and through where we are today.
Okay.
How often does the court want us after every round?
Well, I just, what I intend to do is I'm going to basically come up with an Excel spreadsheet. I'm going to put all the witnesses in the spreadsheet. I'm going to cross-reference what has been filed so far. And, the rules allow the lawyers not to take depositions of someone or for whatever reason. And so if you don't intend, I believe, especially in capital cases, it needs to be documented. So in some way. So if you don't intend to do it, so it doesn't appear, later down the line that it was an afterthought or something that was overlooked, there is documentation for whatever. So you can just say, excused, don't intend to reschedule. Some are excused to reschedule, things of that nature. Okay?
If the state doesn't have an objection, and I am fairly certain it would be no issue to send it to the state to look at first, if it would help the court, we have that Excel spreadsheet already made, and we could give it.
Well, thank you, because
So I'll run that, unless they have an objection now, I'll send it over to them, and then we'll send it to you, and then you can, work off of that, whatever.
I appreciate it.
Sure.
Because to get a good sense of like where y'all are at, to me, it helps. Like, for example, however many witnesses y'all have, if y'all have been kind of talking offline about like, okay, we don't really need that person, it appears to me that if they're listed in a way like that, then that's something that could cause significant, time. So then I believe it was probably like mid 2024 when I wanted to make sure, and are y'all having these conversations, I guess is my question, that y'all are communicating about, what witnesses may have information that is pertinent to the penalty phase. Are y'all doing that? Because the state's position, this is my recollection, the state's position was, well, we're relying on a lot of these witnesses for the information related to potential penalty. So, which is fine. I just want to make sure that when y'all are, because there is significant time being put into the depositions, that information is also being covered / notified to the defense so that they're able to ask whatever questions they need to that may not come in the guilt, but potentially would come in the penalty. But I'm hoping that y'all are having those conversations. But number two is that if there are witnesses that are solely for the penalty phase, I need the state to disclose them in that manner.
Yes, Your Honor. At this time, I can't think of any that would solely be testifying in the penalty phase other than victim impact. And many of those are listed as guilt phase witnesses as well, but I will let defense counsel, particularly before our next round of depositions, some of those witnesses will be for both portions, both victim impact and guilt phase. So I'm not looking towards victim. I don't think that's necessarily an adversarial process. I think that's a constitutional right by the victim. What I'm referring to are information or witnesses that potentially the defense could
or the state would be relying on for penalty purposes only, let's say, for example, not purposes only, but has information that might be relevant to penalty.
Yes.
Either for aggravation or mitigation.
Yes, ma'am.
Okay.
This time, the state's not aware of any witnesses that are solely for penalty phase aggravation. Due to the nature of the aggravators, they interweave or intersect with our guilt phase evidence.
Okay. So to that extent, I want to make sure that that is being put forward to the defense so that y'all have time to process / question. Now, on the defense side, I know that there have been some of the, capital motions that have been filed. Do you have a time frame in which, do you think that you can have them, the remainder, kind of filed by the beginning of the year?
Yes, Your Honor.
Okay. Mr. Dreiser?
Yes, Your Honor. We believe that we could abide by that timeline.
Okay. What time frame?
I thought you suggested by the beginning of the year.
Well, that can mean many things.
January 1st is what I took that as.
Okay. I'm going to do mid-January. Do you all have a sense of when the information related to the discovery on the
Your Honor,
guilt?
I'm sorry, on that point, it's our position, and I'm sure Mr. Crody would agree, is some of these death penalty motions are fluid. That may be a deadline for the ones that we know we're going to file, but I hope that's not a deadline in the sense that as case law emerges, as new issues emerge, I mean, the death penalty in Florida is, and across the country, is in flux with the number of people and the unanimity issues. So we would file motions that we thought we needed to file at any point up to the trial.
Sure. I'm not going to preclude you from filing them, but like to the extent, so some of them generally I will take under advisement, especially the ones that are related to like jury selection and things like that. But the ones that, you know that you're going to file for whatever reason. But if there is something new and emerging, I would not preclude you. I'm just trying to get to a point where we can handle the bulk / majority of them. And I'll handle whatever motion you want. But we've been going along. I think that there have been four or five filed so far. So if you all could kind of get what you want or need to preserve for whatever purpose, if you could have that filed by the first of the year, so I can schedule at least some time to address it, and whether you want a hearing on it.
Yes, ma'am. We're on the same page.
Or if you want the court to rule on the papers. Okay?
Yes, ma'am.
Do y'all have an idea of when you think the discovery guilt phase would kind of be concluding?
In terms of depositions?
Yes.
I will leave that to the defense to answer that question. I don't know what depots they intend to take.
Maybe I'll take that up at the next court date. So this is, all right, so let's say the hard stop is August, okay? Right? You all, I would assume, would want to work back from that date for kind of, this is what we have. This is what the state has. This is what the defense has. And we can get to a place where y'all feel like you have gotten the majority of the information. That's what I want. At the next court date, I want to have some kind of idea, all right? And I'm thinking, around April-ish. So 4 months out, this is the evidence, okay? So then from the evidence, we can work as far as, are there evidentiary motions? Are there, is there litigation that needs to occur? related to any issues that have now arisen. But 120 days out from the date, that is August, that everybody has a good picture of kind of what's on, on both sides. Then also, I believe that if there is any mental mitigation or anything like that, that needs to come at or around that time. Okay. So
You're saying in April, Judge?
yeah, around that time.
I mean, but the rules don't require it, I think, until 20 days prior to trial. So I can't tell the court that I'm gonna be ready in April. That, I mean, we typically disclose it a month before trial.
Your mitigation?
Yeah, our mental mitigation.
Oh, I strike that. You're right. Mitigation. I'm assuming the state would want to talk to some people.
Right, no, I agree.
Okay.
Yeah, we'll disclose witnesses that we intend.
Around April. You think that's unrealistic?
I don't, no, but discovery's ongoing, right?
Right.
But as far as this statement of particulars for mental mitigation.
No, I said strike that, Mr. Critty.
No, I'm with you.
I'm moving on.
Yeah.
I said the wrong thing. So I'm saying at around that time, because otherwise you need more time.
As soon as we have confirmed that we will intend to call someone during the penalty phase, our intent is to disclose it first. And we will have at least a list of people by April. Whether or not that's our complete list, and I can't assure the court.
I don't want to. I want to as much as y'all possibly can. Okay.
I understand the court's intent.
Right.
Yes, sir.
Because I don't. At the last minute, I don't want everything to go away because no one has time, or something is disclosed at the last minute, or there's a discovery issue, or Richardson that completely. I mean, I want to handle as much as I can pre-trial so that when we get to that point, we kind of know what it is. Everybody has everything that they need so that we can move. It's going to be already hard enough. Okay. So I don't want to have side issues like that take a lot of time. Okay. So to the extent, and y'all have been working well together, I just want to tell you what my intent is. This is a heavy lift on all parties, all parts, right? And so I just want to make sure that we are planning and moving towards that date, like that is the date, okay? So to the extent that you can, because I don't think that I've seen any disclosures by the defense.
No, there have been, Judge.
There have?
Yes, ma'am.
Okay, all right, then I'll look closer then. The state hasn't scheduled any depositions though.
Most of the disclosures related to the Arthur hearing. So some of those witnesses have testified, and we have received information from defense counsel that we're investigating. So,
all right.
Mr. Fernandez has not made any disclosures.
Okay. When do y'all want to come back?
November or December, Judge?
Alan Mizrahi next because as was mentioned before.
Yes.
Alan Mizrahi on behalf of the state. I just wanted to clarify something the court said about our disclosure about penalty phase witnesses and making sure that their information is known to defense and depositions can be taken of them. We're obviously doing that. The court also says to me about mitigation. And I just want to make sure that the court wasn't putting a burden on us to disclose mitigation that we don't know whether it exists. We're under a duty under Brady to disclose anything that's exculpatory.
Right, no, okay. I'm not. I was, maybe I'm not being artful. So what I'm really saying is that if there is impeaching information or something along those lines of information that would relate to the penalty phase, that it's disclosed in some way to the defense, that y'all are having those kind of conversations. And I know just generally in litigation and in depositions, like you're not doing it necessarily formally, but you know that there is something and then it's alerted and the defense is able to question about it. That's all I'm saying. Not a burden, just that you all are communicating / doing those things is what I was just bringing up. Is that occurring?
Yes, Judge.
Okay, that's all I was saying. So no burden. I'm not making up new rules. I just want to make sure that you all are having those types of conversations. The depositions, the discovery, that's y'all's business. My business is making sure that we are moving towards the date that was set, okay?
Yes, ma'am. Defense and state are in constant communication.
Great. So the 17th. Will y'all be in like the holiday week? I don't intend to have a trial, so I can hear y'all pretty much any day that week.
The Thanksgiving week?
No.
Oh, I'm sorry.
November 10th is Veterans Day, I believe.
Yes, ma'am. I'm out the 10th, but I'm available 12th, 13th, or 14th.
And when Mr. Bias filed a notice of unavailability, when
I think it was October 15th through 29th.
Your Honor, he's not available October 15th to the 26th, so he should be available in November.
Okay, thank you. Is that Ms. Medina?
Yes, sorry, Your Honor.
All right, thank you.
Wednesday, the 12th is fine, and Friday, the 14th is fine.
Mr. Critty, Ms. Medina.
Judge, I've got a federal trial scheduled for the trial term of November, but they don't tell you what week it is. And
Is it here?
yes, Judge.
Okay.
Presumably,
Could someone
I
from
don't even know if it's going to go, so I would schedule it.
Could someone from the firm cover?
Find someone to cover.
If you do,
Yes, Judge.
is there anyone else that wants to be heard about the date? I'm going to set.
What's the date, Your Honor?
I'm sorry, November 14th.
14, let me see. Yeah, that should be fine.
I know affirmatively I'm going to be out of town on the 14th. I'm sorry.
You will?
I will.
Okay. Do you want to check with your colleagues then?
Well, Miss Medina is my colleague, so
Well, I know that,
she
but
says that she can cover.
Okay.
Then you can.
Miss Medina, she can barely hear you, Mr. Critty, I'm pretty sure. Miss Medina?
Yes.
Are you able, Mr. Critty said he's not available.
On the 14th?
Correct.
Yeah, I believe one of us would be able to cover.
Okay, so I'll use that date. Thank you.
Thank you.
All right, so the next court date will be November 14th, and that'll be at 9 a.m., and that's for pretrial. All right, thank you all for your time and your work on this case.
Thank you, Your Honor.
Thank you.
All right. So you heard Judge Kite. Next hearing will be November 14th. So these are all from last year. This will be the last one that we watch from 2025. And then we're going to go forward into 2026. And then we'll hear, so initially they were going to be tried together. Initially there was going to be DP, but that was, as we'll hear going forward, they're going to be severed and DP is off the table. Debbie, thank you so much for that. 5 Trial TV Live gifted memberships. Come on down. Anybody that we know in chat? Kelly, Gavel, Baba Ganoush. Baba Gadoosh. Nice. And Kalpolis. Anyway, thank you, Debbie. Appreciate that. So initially this was DP. They took that off the table. Initially they were going to be tried together. Now they've been severed. So we'll hear that. So we'll hear that going forward. Okay, so Judge Kite said and it starts August 10th, 11th, somewhere there. And then that's Mario's, and then Shannon's going to be after that. I think they're both about 2 weeks. I think they're both going to be about 2 weeks. But again, we'll hear that. They're going to talk about that soon. So Judge Kite said November 14th. So let's go to November 14th. Shoot, I don't think this one has closed captioning. All right, let's see. All right, so this is from November 14th. So this is a hearing from November 14th. All right, this is a hearing from November 14th, 2025.
Thank you. Good morning. Good morning. All right, Ms. Stifler.
Good morning, Your Honor.
Good morning.
Christina Stifler on behalf of the state, numbers 5 and 6 on the court's calendar, Fernandez, Saldana, and Gardner.
Good morning, Your Honor. Patrick Brady, Shanna Gardner, who's present before me, and Michelle Medina from Bias Law Firm is on Zoom.
Thank you. Good morning. Good morning.
Good morning, Your Honor. Jesse Dreiser here on behalf of Mr. Fernandez, along with Ms. Day, Mr. Tassoni, and Mr. Hill, and our clients present. May I remain seated for the rest of the hearing?
Yes, thank you. Good morning. All right, if the parties could please give me an update.
Your Honor, since our last court date, we have conducted 2 full rounds of depositions. I think other than excusing one witness and the state relisting 2, we had 100% attendance rate. We do have depositions set November 21st and December 5th, and we're asking for a pass date to December 8th following those depositions.
Okay. And does the defense agree?
Yes, Your Honor.
Yes, Your Honor.
And I appreciate the parties filing the motion so that I guess we can get organized. My plan is to put out a case management order, by the first of the year. So I appreciate y'all getting that work done between the court dates as well. So everyone's available on that next date?
Yes, ma'am.
December 8th?
Yes, Your Honor.
Okay. So in both Mr. Fernandez and Ms. Gardner's cases, we will return back to court on December 8th, and that's 9 a.m. for a pretrial. And that case will be handled first. That's a jury selection day for me. Okay?
Yes, Your Honor.
All right. Thank you all very much.
Thank you.
Thank you, Judge. Have a good weekend.
Thank you. You too.
Well, that was quick. that was pretty quick. It's like, why bother showing that? Just because I can't get enough of Judge Kite. I'm going to go to this trial. I don't know for how long and how many days, but I'm going to go to this trial. And it is a fantasy of mine that I will get trapped on the elevator with Judge Kite. That's my fantasy of going to this trial. I'm going to get trapped on an elevator with Judge Kite. And be able to talk to her for like an hour and just be like, Judge. All right. So this is Mario only. All right. So now we're into 2026. So this is Mario only. All right. So Mario only hearing. All right. Mario only hearing from January 26th, 2026. Hey, Texas Cat, how are you? Lori, good to see you. Yeah, if you guys have any questions, check out our description. Go look at our description. I think we got a pretty comprehensive description of what's going on. And we're just doing, we have a playlist as well. If you guys want to get caught up at any point in time, here's a playlist. I will post this as well. So there's our playlist. If you want to go back and look at anything that you may have if you have questions, I would say read our description first. If you have questions, go ahead, absolutely ask. We'll do our best to answer them. And now let's go with this. So this is Mario only from January.
Obviously, this is within the discretion of the court. It's a matter within the sound discretion of the court. It's not a legal right for the defendant, but it depends on the circumstances, whether it is necessary for the defendant to prepare their defense in this case. The state has alleged, and we are only halfway through depositions, based on physical evidence, digital evidence, and the anticipated testimony of witnesses at deposition, a variety of date ranges for an entering a conspiracy. Within the indictment, we have named specific co-conspirators as it applies to Mr. Fernandez. If Mr. Dreiser is talking about what he believes to be inadequacies in the charging of Ms. Gardner for time periods in which she's conspiring with other individuals, which the court has heard some evidence of at her bond hearing, those particulars have been made known to her defense team at the bond hearing, and her information and discovery do not prejudice the defense for Mr. Fernandez from preparing a defense in their case. I believe it's properly pled. We're not asking them to guess. We are not required to reveal our theory of the case. There is sufficient discovery through depositions left to be done that I believe this is not ripe at this point even. I believe that this information is discoverable through regular deposition schedules and regular review of the discovery provided by the state. A conspiracy on its face is a fluid and flexible allegation, unlike, say, a particular act, a one-time act such as a homicide. With a conspiracy, there is a date range. There are various locations in which it happens. There are various individuals. So asking the state to lock itself into providing specific acts and statements outside what is already discoverable through the process in which we're engaging, I believe prejudices the state's ability by forcing us to tip our hand as to defend our state theory of the case to defense. I don't think it's necessary based on where we are in the discovery process and depositions at this point. I'm happy to reconsider it at a later time if once they've spoken to witnesses, once they've reviewed the discovery, once they've deposed co-conspirators or co-defendants. If they still believe that they are prejudiced, they can readjust it with the court at that time. But I don't believe at this time this is a ripe issue for the court. I don't think that they are prejudiced in their preparation. I believe it's properly and sufficiently pled in the indictment for them to conduct necessary discovery and depositions, and I believe requiring the states to line by line point to specific statements and evidence at this point in the case would prejudice the state's preparation. It has not much to do with this motion, but at some point the state is going to be filing motions regarding admission of co-conspirator statements for the court to make rulings on pretrial admissibility. And at that point, that would necessitate that many of these questions will be answered following the discovery process and the depositions of some of these witnesses and further discovery on the part of defense through their review of what's been provided.
So, I mean, obviously I haven't read these cases yet, but I will.
I have not either. They're not plotted to me.
Do you want some time? Do you want a moment to look them up? I was going to try to look them up.
If we have enough time, if not, I could do a written response if I felt it was necessary. But I just wrote the sites down. I have them up, but
okay.
I know we're limited on time.
I know. I'm sorry. So I'm going to table this for a moment. I was looking at the rule. I'm going to try to read those cases. Let's move to the second so I know where the issues are. And then the
court.
I
had some response, but the court doesn't feel like it's necessary.
No, I do. I'm not. I can't think about it until I look at what was just given to me. Okay. So let's table that for a moment. All right, let's move to the second motion.
Your Honor, on behalf of Mr. Fernandez, the defense has also filed a motion to issue interrogatories to co-defendant Henry Tenon. Mr. Tenon is now a cooperating witness, as the court knows, and Mr. Tenon gave a 5-hour interview to law enforcement when he was first arrested. Nothing, not one really single fact that he gave in his voluntary interview with detectives is consistent with now what is his sworn statement that he's given. Mr. Tenon denied being at the scene. Mr. Tenon denied having any involvement, having any knowledge, sometimes being in Jack's Beach, sometimes he admitted he was in Jack's Beach, but albeit not one single admission to the crime he is now alleging that he participated in and has given a sworn statement many, many months later. As this court may or may not know, I was provided with the sworn statement and audio. We've since had it transcribed, and we have limited information as through yes and no, primarily a question and answer format as to what he says his involvement is now. This case, as you know, ad nauseum at this point, is humongous. The cell data, it is overwhelming with the amount of data they have on different individuals like Mr. Tenon, like Mr. Fernandez, like Ms. Gardner. We consult with an expert, we map calls, we do things in preparation of our defense, and the state does the same. They provided us FBI Cast Agent Blythe, who is mapping and routinely providing data discovery as to the work that he's doing, for example. The financial records in this case are so voluminous that, of course, as you know, it wouldn't blow your mind at this point, but it would blow a normal circuit court judge's mind of how many bank records there are, how many months, how many different accounts that the government ascertained. So, in preparation of Mr. Tenon's deposition, in which we would anticipate that we would want to fact check, document check, consistencies, inconsistencies, you cannot do in real time in this case. In any deposition in which we all routinely take, you're talking about a red well, sometimes you're talking about a disc or some body cameras, and you're either so familiar with it you can ask questions to push the truth or push back on the truth, depending what your strategy is. In the deposition, we all know that. You can look at a arrest and book report, you can look at a photograph, you can look at a Ring doorbell camera, all things that we regularly and typically do, and we do not ask in advance for someone to give us interrogatory questions in advance. But in a case in which there is so much cell data and so much lack of information that we know about what Mr. Tenon is going to say, and given that he is a key witness in this capital case, he's been discussed and talked about, the deposition has been talked about when it's going to occur and how long it's going to occur, and the arrangements. It's a central feature of this entire case. Mr. Tenon gave his information, and my client was subsequently immediately arrested. He is what I would say the central witness for the government that says that my client is involved and led to the arrest of my client for many, many months after the homicide, where he was not arrested. And I provided the questions to the court for your review. These aren't gotcha questions. They're not confusing. They can be answered very easily.
Can I interrupt?
Sure.
Who are you proposing to answer it?
Mr. Tenon via his counsel.
So,
He's well represented.
so practically speaking, so his counsel, this is what you would requests. His counsel go to him with these questions. Then he answers through his counsel and gives it back to you. So how is that not, in that private setting, essentially setting up his counsel to be a witness if he decides to say something different than what is on the interrogatory, and then therefore creating a potential ethical conflict between him and his counsel?
I suppose it's an interesting thought that you have and you posed to me, but that happens every single day, tens of thousands of times across the state of Florida with interrogatories. We use them
in a criminal case.
In a criminal case, they're used less often. They have been used. Certainly it's less often, but to answer your question in the generality, it no more makes Mrs. Flax a witness in the answering of the questions than it does Mr. Hill a witness in any case in which our office has been served with interrogatories in a family law case, an injunction case, or a civil matter. The lawyer...
Isn't it different in the sense that if you wanted, in those cases, which I'm obviously not an expert on, but I do consider myself very familiar with criminal law.
Sure.
So if someone says something different, and then he denies the paper, or he says something in the creation of the paper that would be the inconsistent statement, the only way to basically attack the paper would be to call the person that was at or around the paper, i.e., like, so let's say Ms. Schlax is like a police officer, right? Like, so you call a police officer and say, I did hear this witness say X, and that is how you would impeach in front of the fact finder.
They're sworn to. So I would use the document itself, not Mrs. Schlax. Well, I would say Mr. Tenon, am I the leader on both sides?
No. I'm just trying to think this through. So your thought would be, I order his counsel to make him basically make a statement, and so then he makes these statements, then it's delivered to you. He then, for example, I'm sure you had the situation where the witness is like, let's say on the deposition, they're like, nope, I didn't say that court reporter got it wrong. How do you say in the creation of that document, you call a court reporter? You can attack through that, or you could. I doubt that any of y'all good lawyers would just let something go like that. If you have the ability to say, call someone and say, no, that document is authentic. Yes, that document is what it says it is. So to me, it's a little bit different than a deposition because there are multiple people. There's a court reporter there that certifies it. So this is a person that is charged with a crime. This is a person that the defense is, like you said, going to totally attack his credibility. And if he goes sideways on you, not answering the way that you want, the paper may say something different. But if you have the ability to say, let's say he says the creation of that paper is not authentic, then that is what I'm asking you about.
Everything that you're saying is what anyone could say when confronted with an interrogatory in any civil or family law case in which they're obviously used routinely and daily. So
I don't know anything about those rules or those laws.
That's how they're used. You would say, you said on this, you were asked, how much did Mr. Fernandez allegedly agree to you to commit to the homicide of Jared Bridegan? You answered $150,000. Do you agree that you swore to tell the truth? You were sworn in, just impeach him like anybody else? And then I guess if his answer is, I never did that. That was his, I don't know, I was never there. I think that's just a fact for the fact finder.
Well, what if it's answered in the sense that my lawyer told me to say that? My lawyer wrote that down. I didn't do that.
Is that your signature? Did you swear and affirm that that is your signature? I mean, and then yes, that's my signature, and then the fact finder makes a decision. They would decide.
So you would be willing to say that Ms. Schlax would never ever be called as a witness to impeach her client?
Absolutely. In this particular case, I had never heard of that. I've never even thought of that. I've used interrogatories to impeach people. I've also never heard anyone say, I didn't answer those interrogatories, but he could. But sure, of course.
I mean, we don't know. I'm asking hypothetically to think about, like, to me, this is very unusual.
It's not so unusual. I mean, I did not come up with this idea on my own. It's been used in criminal cases. It has the rules, and I think I cited that there is a rule that would give you the authority when justice may require. I don't think these are complicated questions. I don't think they're questions in which a cooperating, I mean, really all of the questions that you're posing to me are almost as if we don't have a cooperating co-defendant. I mean, what Mr. Tenon has said in his sworn statement is, I'm a cooperating witness, I have a deal, I'm going to live by the deal, and in part of the deal that you're offering me, I'm going to testify truthfully. And in fact, as I sit here and say it out loud, I don't know how that's much different at all than what I'm asking. I mean, I guess Mr. Tenon could come in at one point, had Mr. Tenon ever decides that he no longer wants to be a cooperating witness, and he'd be like, that's not me. I never said those things. And then what would the state do? They could call an investigator to come in and say, yes, you did. You were sitting there with my own eyeballs. It sounds like your voice.
So that is exactly what my question is to you, which is, that is what avoids the situation. Essentially, you're requesting the court to compel the attorney or the client that could potentially create an adverse relationship between those two if he were to make allegations towards his attorney. And I know that you are very experienced, and you know that when individuals are either post-conviction and they're convicted of things, they say that their lawyer does this, this, and this, and then we have to have hearings, the lawyer becomes the witness. That is, what I'm asking is essentially, are we creating that potential situation pre-trial where the criminal defendant would say, I did not get adequate representation, my lawyer did this, this, and this. I understand that you need the information. I have some more questions, but let me pause you and I'm talking. What's the state's position?
Here on the state objects, and for some of the reasons the court has brought up. First of all, procedurally, first of all, the rules for interrogatories for civil cases contemplate that interrogatories are between parties to a dispute. So you have a respondent and a plaintiff, and they're sending interrogatories back and forth, which is not the case here. There are factors in consideration that may not be present in civil cases. Number one, Mr. Tenon would have to waive attorney-client privilege to be discussing the facts of his case because he is pled and not yet been sentenced. So the defendant still presumably in that posture, maybe working on mitigation or sentencing factors, he would have to waive attorney-client privilege because he's discussing the facts of his case and potential issues that could be germane to a sentencing hearing with his attorney, and then releasing that information to a co-defendant's attorney. I am concerned about this idea that Ms. Schlax would sit down, ask him questions, write down his, and Ms. Schlax is a wonderful attorney, no one's saying that. In general, the idea that we're relying on not a witness, but another party putting onto paper what their response is does cause issues in terms of the reliability and the ownership of those statements by the witness themselves. And yes, eventually, if a defendant is sentenced and does not like their sentence and filing post-conviction motions, the first thing they're going to say is, I didn't say that, she just handed me a piece of paper to sign with whatever she wanted written down on it. The state is prejudiced post-conviction in litigating these issues. When we have procedures to do this, the questions they are asking are questions they would ask within the normal scope of a deposition, and are answers which are outlined in the state's discovery, including his sworn statement.
Well, I mean, and the reason why I'm asking it, okay, so I have 2 cases that I looked up that reference the rule that you are using, and I'm very familiar with discovery rules, okay? 3.220F, okay? And so I have, let me give it to you. There's a 1st district case, 351 7 3rd 197 Thomas v. State. In that particular case, the court actually granted kind of like a similar motion. Actually, it was in this circuit. And then also, and then I have Bazemore v. State, 7-9 7 3rd 828. And actually, let me start there. That's the one. No. I think I gave y'all one case. I gave y'all one case. Sorry. Sorry. Dennings, which is Orange County Sheriff's Office, forget the Bazemore case. And it's 158 7 3rd 622. It's a 2014 case where the trial court actually granted a motion, and it also has a good discussion on what is material and what is not. And they took the trial court up, the sheriff's office did, on a writ of mandamus, basically where the trial court compelled what I guess the court viewed and abused its discretion in giving over this particular information. So I thought that might be helpful related to like what the rule requires, what material means, and like how trial courts, while we do have like incredible discretion, we must exercise it within the bounds of the law, which 3.220 and F, in my mind, and I hear you, I guess is what I should say at the outset. I hear you, Mr. Dreiser, okay, that this case is voluminous, but what I do know, what I'm posing the question, is that essentially the court has had to grant a motion to withdraw for Mr. Tenon already, one of his lawyers and what the hypothetical that I am telling you, I don't necessarily know what the conflict is once the conflict was certified, but it's pretty apparent that part of it was that the state of Florida disclosed over notes made by his counsel, and it could be used potentially to impeach him during a meeting. Mr. Chipperfield's notes were part of the disclosure, and then fast forward, here he is, he's got to get off the case. Now Mr. Tenon is on lawyer number 2. The proposal, I think, by the defense of Mr. Fernandez is running dangerously close and potentially making the Schlats put in the same spot. What he would do, what he would say, whether he would admit, whether he would deny, whether y'all would use a paper, or whether I find myself in a situation either potentially in the middle of a deposition or in the middle of a trial trying to appoint Mr. Tenon another lawyer because you all are doing everything that you can to defend Mr. Fernandez, and you're going to use every mechanism you know how if he does something that no one is anticipating. So that's why I was asking you the questions related to his representation. So this is my other question. So let me start with this premise. I believe that you are entitled to know exactly Your identification as him to be a critical witness against Mr. Fernandez, obviously that's true. What I'm going to ask is this. In the scheduling, you said a red well is generally what you could use. Why couldn't you use the civil type of scheduling on a deposition where you schedule it not just for an hour, that you schedule it over days, that you take a certain period of time, you all take a break, continue the depo. If it takes 3 days, if it takes a week, if it takes 2 weeks, that if you needed to fact check that way, you ask your questions, you fact check, you come back, you ask more questions. You haven't concluded the deposition and you are continuing it. So why couldn't that procedure be used?
It can. I'm satisfied with that.
Right?
Yeah.
So, I mean, I don't know why, in criminal law, you're like, oh, I can take a critical witness's deposition in 15 minutes. This is not that case, but maybe because of the volume, you all schedule it. You all think through. Say, do I need to regroup? Do we need a special room for it? Do we need a TV? Do we need this? All of that can be planned out. All of it can be scheduled. And it doesn't, in my mind, run a very dangerous risk of making his lawyer that is supposed to be guarding his rights a witness against him in any way, shape, or form.
Fine, Your Honor. If we just may have time on the other issue, I'm satisfied with that ruling and understanding of the court's concern, and we will do it that way.
And if the state, I mean, the rule, to me, the rules contemplate, right? If it becomes unreasonable, the state files a protective order or Ms. Schlatt's files, and that would be the point. But making her a potential witness is, I do not.
And Your Honor, just for record purposes, as part of the state's concern, additionally, I do think that a regular deposition set with sufficient time, sufficient access to whatever they need, should cover it. Interrogatories, because interrogatories used in civil cases.
No, they said fine.
Okay.
So it's no on the interrogatories. But as far as how and the mechanism in order to depose him, for them to, obviously I am aware, I don't, well, let me rephrase that. I have really no clue, okay, of what y'all are looking at. Absolutely no clue. Y'all keep telling me what it is, and I have absolutely no idea, okay? However, I do understand and weigh the defense's concern that they have a lot of information that apparently doesn't lead them to any ability to defend their client, because they have a 5-hour interview of him saying nothing. They have a succinct sworn statement by the state, and they have a bunch of terabyte million computers worth of information. And so with that, I'm going to send the parties forward, talk away, and you can come back if you have a problem. But as far as hey, this is going to be an hour, Ms. Stifler, you got to think that's a problem. That's a no. No. Okay.
I don't think any of our depots have been an hour.
Okay. I don't know what they are. Okay. I have no idea. All right. I have no idea.
I anticipate that certain depositions will need a significant amount of time to accommodate that.
I don't know what y'all's depots have been, but it needs to be thought through in that way. Okay.
Understood.
All right.
On issue number 1, would I, if I may ask, to allow us to read those cases, come back for an additional 15 minutes?
Yes.
And then we'll square away and ruling on that.
We'll table it.
I will. I have a few more cases. I'll send all the case logs that we were able to find as a team to both court and counsel today, and we can follow up with written responses or oral arguments needed.
Okay. Thank you. And I'm not sure what that basement case was about, so just all right.
Can we approach that for a minute?
Yes. All right. Court series 7. Yeah, I'll cover this.
Wow, so Mario got his hair cut. Look at him. Wow, I didn't even recognize him at first, but that's Mario. So remember, he had long hair. He trimmed his hair. Do we have a? Yeah, he has his hair pulled back there in a ponytail. Here he's all shaved down. All right, so basically that was from January 26th of 2026. They're talking about co-conspirator statements. Henry, it kind of revolved around Henry Tenon. I guess he's on attorney number 2. They don't want, the judge doesn't want his new attorney, who we saw, I think that blonde woman, to he's not going to make her a witness to testify against Henry. So they're talking about interrogatories are used in civil cases, not necessarily the case here. I guess Henry has made statements, and then the state disclosed notes to his first lawyer that could be used to impeach him. So he had to withdraw, and then now she doesn't want the second attorney to run into any issues as well. All right, so let's move on. Let's continue on. We're going to go next to March 5th of 2026. So this was just a few months ago. So let's see what this one is. Let's see. All right. All right, I'm not sure if this is a different angle. All right, so this is a hearing. All right, so this is a hearing from March 5th. So let's see what this one's about. This is a completely different angle. Completely different angle. All right, let's see what we got here. Let's see what this one's about.
Thank you. Good morning. Yes.
Slide 8 and 9 have an abundance of just not being used to that kind of cause. If you want to go adjust, we're at 7. I don't want to play by accident and just start. I will do my very best. I'm letting everyone know it's slide 8.
So we're off the record for a moment. I was giving the media an opportunity to contact their counsel if they wanted. Do you still need a moment, or can we start the proceedings? Start? Okay. All right. Let me see the lawyers one more time.
So maybe this one's about the media. Maybe this is a media request issue situation. Wow, is there anything on here? Oh, here we go. All right. Lay it on us, Judge Kite. And of course, now there's no audio. Hopefully this will kick in. Ah, no audio. Doggone it. This one may be a bust, you guys. Yeah, this one may be a bust. Let me see if I can, hold on a sec. Sounds like this one may be a bust. Let me see if I can find out what this one was about. Because we're not getting any audio. Hold on a sec. Thank you, Debbie. Are you going to take off? All right. Have a good rest of your afternoon, and thank you for that. Appreciate that. Let me see if I can find out. Nope. All right. Yeah. So we're not going to get, this one might be a bust with no audio. All right. All right. We will we'll put that one in the trash bin. The recycle. Put that in the circular bin, and move on. All right. Next one is from March 31st, 2026. Let's see what this one's about. Hello, Super Ball. Super Ball's doing a cruise by, drive by, meow by.
I think there needs to be, because.
All right. Oh, this one's with Jose Bias. All right, here he comes. Here's Mr. Bias in all his glory. What am I saying? Bias. Is it Bias? 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 Jose Bias? Jose Bias? I have no idea, Happy. I don't know. There's no audio, so I don't know. All right, let's go on to this one. This one is from March 31st. All right. So this one is from March 31st.
Christina Stifler on behalf of the state. We're here on number 1, Mario Fernandez Saldana. Number 2, Shanna Gardner.
Thank you. Morning.
Good morning, Your Honor. My name is Jesse Dreiser, here with Shannon Day and James Hill and our client, Mr. Fernandez, who's present. How are you?
Good morning.
Good morning, Your Honor. Jose Baez. I have Michelle Medina, Professor Sullivan, Diane Menashe on behalf of Shanna Gardner.
All right, thank you. And Mr. Dreiser, I don't know if you, Mr. Tassoni is also on. Yes, he's on.
And Frank Tassoni as well. Thank you, Your Honor.
Thank you. All right, so we are here for a pretrial.
Yes, ma'am. Some updates.
Okay.
We took depositions last week. In taking depositions, we are in the process of setting more depositions. There are 3 defense teams and a multitude of lawyers. I've provided multiple dates and I've asked for advance notice so that I can secure some of these witnesses are care of the state and some are federal agents, which require 2 letters. Ms. Day and I are working on a joint coordinated schedule with everybody. They've provided me this morning depo dates. We have some this Thursday, April 10th, April 13th, April 16th, and then I provided a counter date for one of the witnesses the week of April 20th.
Who are the federal agents?
ATF agents, Secret Service agents, FBI cast analyst.
And those are outside of the agents that have already.
Yeah. Well, you've heard about the cast analyst before.
No, I thought one of the Secret Service and ATF.
We did ATF last week.
Yeah, the Secret Service agent appeared on Thursday. The deposition of the ATF analyst went long, so defense counsel excused him. And we're going to reset him.
How is the 2E process working?
I've been handling it. It's been fine. Everyone's been willing to appear.
So, like timing wise?
The ATF, as long as they give me sufficient notice, at least 2 weeks for some of these depositions, but they've been turning them around on our request in a couple days.
Okay, great.
We're hopeful to be done with all of the depositions from the Fernandez team within June. I think we're really nearing the end.
Okay. And so let me address also the defense team for Ms. Gardner. She is obviously not present, and that's by request of parties, correct?
That is correct, Your Honor.
Okay. And
I mean, we just didn't, since we're not present, we figured we could just have
it doesn't make any sense. From your perspective, Mr. Dreiser said his anticipated completion of the depositions. Do you all agree?
Yes, ma'am.
Okay. June.
I'll discuss with defense counsel, or I'd like to get a schedule through June if we can. And then obviously the state has, I won't say concerns, but the state does need sufficient time to prepare post their discovery depositions ending. So I think June is reasonable and agreeable to the state. If it looks like we're not going to get there, I may ask for the court deposition schedule to be some kind of deposition schedule like they do in civil practice to be filed with the court. Just so I'm making sure these witnesses are they can be there. We're not excusing people or missing depositions because they don't have sufficient notice. And I'm happy to coordinate, and I'm not saying anything against defense. We've been coordinating with Ms. Day. Well, I just have concerns. The state wants adequate time to prepare, potentially asking for a deposition deadline sometime in mid-June.
Well, I don't want to put you all in a crunch. So I'm logistically speaking. So it's April, let's say. I want to give you all sufficient time so that we can kind of use July for getting any motions or whatever heard, or I don't want to run y'all right up against a trial date. So what do y'all think?
I think depositions are moving slower than anticipated. The length, I think we just need to get together and be more realistic about the amount of time we're setting per witness. And I just need more time.
Well, now we just need, how does Tenon factor in?
He's no longer a state witness.
No. I mean, as far as the discovery.
Ms. Schlax is coordinating with defense and participating in depositions.
Absolutely. But it's a great question because it's another cat that we have to herd in this scheduling issue. So it has been a little slower. I think from the defense team, I would say we've been machines in depositions. We've been thorough in depositions. They may have gone longer. There's now a new lawyer asking lots of different questions on behalf of her client. So it may have slowed down, but for obvious reasons. There's a new defendant in the case.
I need y'all to stop talking kind of in generalities. Give me practically what is occurring. Because in my mind, Gardner and Fernandez are set in stone. We are going to try this case. And so it is, the rules say reasonable coordination efforts. And if Ms. Schlax is, because she's coming in kind of back end, I think there needs to be, because of the circumstances, you all need to do reasonable scheduling efforts, and then maybe these witnesses she orders and then ask additional questions if she can't make it. Because these, I can't have someone who is not set for trial slowing down cases that are set for trial, charged in the same indictment, going to be like, I can't have that occurring. And so that's why I'm saying don't talk in generalities, talk real with me, meaning I want to know. Operate on the rules. The rules say reasonable. If she can't make these, then okay.
It's not her fault.
I'm not saying it's her fault, but I'm saying that this has already been set.
Understood.
So that's what I mean. So if it needs to be a concession on the state, my understanding is you're not seeking to try him with them, correct?
Yes, ma'am.
So that means y'all operate. Okay, y'all operate on the trial date with those deadlines.
There are witnesses that are not going to be witnesses against Mr. Tenon that we can set depots for that Ms. Schlacks probably, in my conversations with her, would not participate in.
Okay.
There are some witnesses that do not overlap all three defendants.
Okay. Well, I'm just relying on y'all. Like, I don't want that to like slow things down, if that makes any sense. And I don't, unless y'all are telling me exactly what's happening, I really can't comment any further than that. But my intention is I want y'all done sooner rather than later, because there's a lot of litigation. The state asked for May for hearing time. And so my thought was that y'all would be finished, like, hopefully near the end of April. And then we use May to litigate. I leave y'all alone essentially until we need logistical things. And so if the addition of Tenon as a defendant and his defense team, in my mind, it just, y'all have to operate with the schedule that we have, because there's too much at stake.
Probably a good time for us to address either today that we're going to address it at some point soon, but trial schedule, not necessarily when it's starting, but who's going to be tried, seems to have shifted amongst the parties. I don't know how much.
What does that mean?
Is aware. It's by agreement, my understanding that the state and defense, Mr. Gardner prefers to try our case first and separately. So it would be, we would go jury selection and our trial, which we anticipate we could be done within 2 weeks. Then Ms. Gardner's trial would go next. And then Tenon, obviously, not my concern, would not factor into that. But they no longer intend on trying these cases together. And that's by agreement by all parties.
Okay. When was somebody going to let me know?
Well, we asked for a logistics meeting with the court, and I believe it didn't work out because of defense schedules. But Mr. Mizrahi and I think, discussed it a little bit with Your Honor at sidebar. We can certainly have further discussions.
I didn't understand it that way.
Alan's driving the opposite. The plan is to pick out the same panel and swear both juries at the same time. That's why, like, Your Honor, not the parties. Mr. Dreiser's in agreement with that plan. I'm not so sure the parties are in agreement with that plan. Not that they really have the ability to object to it.
I'm sorry, can Mr. Mizrahi speak in the microphone?
Can you talk in the microphone because they can't hear you?
I'll speak into the microphone. The plan is to, of course, is to pick out of one jury panel, swear both juries, and then proceed with the Fernandez trial until its completion, and then begin the Gardner trial with its sworn jury immediately afterwards. Therefore, we can try both of them together. Just would be we have two separate juries anyway. That was always the plan. The only real difference is we're going to have both juries in the courtroom for certain witnesses. Based on Mr. Tenon's withdrawal of his plea, that main witness that is not going to be present, juries together, since there are numerous witnesses where the two juries will be separate anyway. More witnesses separate, or at least comparable witnesses separate than would be together. And the number of witnesses that would be in front of two juries would be mostly professional and ministerial in nature. So that's the state's proposal. Yeah, so everything, nothing changes in terms of the dates we have blocked off or anything.
Yes, it does. I mean, Mr. Dreiser just said it would take 2 weeks to try Fernandez. And then Gardner, I'm assuming they would need the 2 weeks too.
I was including jury selection.
Right. I don't think it's going to take 2 weeks to try Mr. Fernandez.
Yeah, it won't. I agree with that.
The time frame, Your Honor, is going to be virtually identical. There may be, obviously, there'll be certain witnesses that we would only do one direct on as opposed to two directs on that we'll have to do. So that timing of the witnesses that we do two directs on, you're talking about several hours difference in the two trials. Everything else is the same. The crosses will be the same, the openings and closings will be the same, and the shuttling of juries is incredibly difficult logistically.
And timely. I think to cut into the 2 hours that you just talked about, you could subtract time for the shuffling and objections and whatnot. So I bet it's a net zero.
Mr. Baez?
Yes, ma'am.
What are your thoughts while I'm looking?
Our position is we're in agreement with separate trials. However, we would like to, rather than picking the juries at the same time and then having the Gardner jury wait and perhaps create a whole slew of issues, we would like to go immediately following the Fernandez trial. We could then pick the jury right then and there and proceed like a normal trial. It eliminates so many logistical issues as well as potential appellate issues. It's just a lot cleaner that way. And I agree with everyone else. The time frame is going to be the same. We just think that it would be much cleaner to do them back to back immediately, one following the other immediately thereafter.
And the state disagrees with that. The time frame is completely different if you have two different jury selections. That's completely moves the time frame several days probably.
Well, I'm listening. I'm listening to both sides. So what we had initially planned was jury selection happening concurrently, trial concurrently, closing down one. And I was asking the state, duplicate as much as you can so that then when verdict is reached, I could seal and then close down the other, then bring them both, summon both, publish at the same time. And so my thought is that if you all agree, what really should happen per the rule is Rule 3.152, and it says, and it's 3.152B. It says on the motion of the state or the defendant, the court shall order a severance and separate trials. Okay, so it needs to be by motion, not agreement, because what has brought them together is a joint indictment. And so if you all want separate trials, it needs to be by motion. And then once that occurs, I think we need to adjust the time frame. I would be nervous and concerned for everything that Mr. Baez just said, which is you go send a jury home. There's been great media interest in this case for them to sit down. And so whatever jury you would have picked for Ms. Gardner, you would have, in my mind, you would have to pick 10 alternates, so that just in case you'd picked. And so to me, it doesn't do anything. So I would be willing to call in a special jury selection process for Ms. Gardner, maybe on a different day than we normally would. You know what I mean? If you all talk to me about the scheduling, like when you believe that Mr. Fernandez's case would be almost concluded.
Your Honor, that is, in the state's mind, it's an illogical process. The reason to try these cases together is in large part for judicial economy.
Agreed.
Separate juries, it completely eliminates that positive aspect of doing it, of picking one. There's a couple of things. One, if you pick one jury, both juries at the same time out of one panel, all that media attention, all those questionings, all this preliminary stuff that we're going to be doing is going to be done once, not twice. Once the Gardner jury is sworn, I agree, we'll pick more alternates for her case. They will be instructed to avoid media contact. Some won't. We'll pick more juries than we normally would because they have a longer break before they're seated. if we pick their jury immediately after, the panel that's going to be coming in is going to be filled with people watching the media for the 2-week Fernandez trial.
Agreed. That's why I don't know why this is even a question to me. I understand maybe some of the witnesses don't overlap. To me, those are order of proof issues, meaning that you group the ones together with the thought that that jury would sit out as little as possible. You pick both juries, but if you pick Ms. Gardner's jury, it is just, to me, filled with potential of error and of exposure. And you can say, come back next week, and then we'd be through another jury selection. And I'm sure the state wouldn't want me to swear them.
Absolutely, we'd want you to swear them.
You want me to swear them?
Yes, absolutely.
Okay. And then, we went through the jurors and potentially lose some of them or all of them, and I'd have a mistrial potentially, and then we'd have to start this whole process all over again.
Yeah, a mistrial in any case, at any time.
No, but you're building in a situation where it would almost, we're just asking. It's like Pandora's box. Don't open it. Don't open it. And they're presumed to follow the court's instruction. Logistically, I don't really see if we know that jury selection would take 3 days. And how long are y'all anticipating Mr. Fernandez's case to go?
I believe the state has told me they believe less than 3 days or 5 days for their case in chief.
I think a week and a half is very, very conservative and safe for the completion of the Fernandez trial post jury selection. And I think it's more likely a week, but a couple more days after.
And I've said 3 days for the defense before. I'm now comfortable saying 2 days, and that's conservative. That's giving me time that if my client chose to testify, I'm building that in. Whatever experts we know that we're going to call, I'm building that in. And we're close enough now that I'm pretty comfortable as to who we're calling and what that would look like.
So you're saying 2 days for the defense case?
I would imagine that's enough time.
Okay. With your scenario, Mr. Mizrahi, what do we do if Mr. Fernandez's case goes over? Just keep the jury?
If we were trying them together, we would tell the other jury to come back on a different day, because the plan would be for them to come back, let's just say, for example, on the 2-week, the Wednesday. So you'd have a full week of Fernandez's trial. They would come back the next Wednesday. If we're bleeding into that Wednesday, you would tell them to come back on the Thursday. You would tell them to come back on the Friday, wherever the case may be. They would be sworn and told not to watch any media. It's the same as if we were doing the trial together. This trial with 2 juries is going to take a very long time. These jurors.
It's not the same. I like it.
Longer,
no, disagree. It is not the same, because what we discussed is that you pick the juries at the same time. They're reporting in potentially having different, for example, hypothetically. Okay. So logistically, Mr. Fernandez is the A defendant. You all would give opening statement. And so the state, generally speaking, when you're trying 2 defendants at the same time, you give one opening statement. You ask one jury, if you're talking about things that are not admissible in front of the other jury, you say, may I have a moment? You send that jury out. Then you finish your opening statement. Defendant A gives his opening in front of A and B. Defendant B gives their opening statement, A and B. And then you all start your case. All the jurors sit in there almost concurrently, working as much at the same time as possible. Generally speaking, some witnesses, they go out, you give them a longer break, but they're working the whole time. Everybody's working. Maybe a break with Mr. Fernandez, maybe a break with Ms. Gardner's jury, but they're all working. It is not, hey, I've got this case. It's not going to be a secret that it has attention. And so you're going to pick 2 juries. I'm going to tell them, don't watch the media. But then I have no way to really ensure that / protect them. I was going through specific steps to protect them. They were going to be sequestered when they are not working. Okay, so they have added protection, but if I'm a follower of the rules. So if this is the way that y'all want to do it, I'll just extend the time frame. And I'm not gonna put myself or the jurors in a situation where if one case goes over, and I know that y'all, we all have great expectations that we can finish things very quickly, but the reality is there has been no hearing in this case. There has been no proceeding that has ever been short. I mean, it's never been short. So, I mean, that's a reality. We all have expectations or hopes, but the reality of this is there has not even been a hearing. I think there's been less than 30 minutes. So, I mean, if that's how y'all want to do it, I'm going to rewire it, and then I'm going to get with the clerk's office, and you all, if they're severed, they're severed.
Right, but the state was not in agreement with that. The parties haven't reached an agreement, so we're just going to have to, at this point, we're in the exact same posture that we were before.
What do you mean?
Because Mr. Baez's team does not agree with this.
No, he said he does agree.
He does not agree. He wants to do a completely separate jury selection. He does not agree. We're not agreeing.
Well, okay.
We got it.
What rule? I mean, so you're not asking to sever, you're just asking to try them separately. That doesn't make any sense.
We are picking, I've done this in multiple occasions, we are picking out of the same panel. We are swearing both juries. That's the only thing that's going to be together. So I mean, that's a partial severance.
So you've done a concurrent trial where you've picked two juries and sent a jury home for 2 weeks and tell them to come back.
It was a week. It wasn't 2 weeks.
Well, this will be 2 weeks. I mean, let's be real.
I've done it where I've picked two juries, sent one jury home for a week, and then.
Okay, what case?
The Alan Wade and Tiffany Cole.
Okay.
And Your Honor, if I may, Diane Menashe on behalf of Shanna Gardner. I talked about this issue with the prosecution when I was in town last week about if they're severed, then they're completely severed, right? Separate jury selections, et cetera. Although we could certainly go, we would be willing to go immediately after the Fernandez trial is over. I would also say when the prosecution has said that they've done this before, this case is different. This will obviously be nationally televised. We're not talking about just media or print exposure. I mean, potential jurors, they can be told not to look or watch TV, but this is the case, as we know, even participating today is the Law and Crime Network. The trial will be live streamed, and by the state's own admission, there will be evidence, witness testimony, physical evidence, et cetera, that will be introduced in the Fernandez case that will not be introduced in the Gardner case. So I would submit that if there isn't any precedent for that type of sort of jury selection and then holding a jury back in a prior case, that it's apples to oranges.
We'll say that in terms of inadmissible evidence in the party, it's really the reverse is true. Although there may be a small piece of evidence that's not admissible in the Gardner case, it's admissible in the Fernandez case. It's really the reverse. It's the vast majority of the Gardner case is inadmissible in the Fernandez case. So I'm not as concerned with that particular issue. I mean, I'm trying to save time. The cases are now joined. Defense objects. We can always just keep going the same plan that we were always going. I was trying to make these things efficient and easier for everyone to go, because what I can inform the court of is this is not a case in a situation where we're going to be able to shuffle a jury out for a witness or shuffle a jury out for part of our opening. The core of the Gardner case is inadmissible in the Fernandez case. So you are talking about at least a half a dozen witnesses, if not more, that are not, just not admissible, probably more than 8 to 10 witnesses that are not admissible in the Fernandez case in their totality because they contain statements that Ms. Gardner has made. So the openings are not like we're going to send one jury out and say, oh, by the way, here's 2 lines. I mean, it's integral to our entire case. The reason we charged them together is obviously they're co-defendants, and as well as when Mr. Tenon was testifying, there was a logistical reason to keep them together because he was a testifying witness in both. Without him, it becomes less of a priority for the state to keep them together. But that's the way it is, and no one's made a motion now, so we can deal with it when we have a motion.
Judge,
Go ahead, Mr. Biles.
no, I was going to say, both of these trials are really only 2 weeks. We've all tried cases 6 weeks long, just one case. And for this to be such an issue when we're really looking at just 2 weeks, given the complexity of the case and what's admissible and the witnesses as described just now by Mr. Mizrahi, not to mention the potential issues that could arise, appellate issues, it's just far too important. And we're really not talking about that much time. 2 weeks, that's nothing. I welcome a case like that. I expected this case originally to be somewhere along 6 to 7 weeks long. 2 weeks seems like a major cut in what we were expecting to begin with.
So can I weigh in just a little bit? Okay. First of all, this motion, I don't necessarily think that there is a motion, okay, but because the state's asking, I guess, to try them together, but just in a different way. And so if the defense wants me to consider a total severance, and I agree, like it is one thing or it is the other thing. You can't have your foot in both camps. So it has to either operate as a complete severance. But what I will say is if the reason why, Mr. Mizrahi, I have concern. I'm not making any rulings, but I do have a concern, and I think that you should maybe take a little bit of input. If I logistically go the way that you are suggesting, okay, meaning the scheduling of this, you're saying it saves time. That's up for debate. But however, in the case for Ms. Gardner, to me, there is a lot of potential for prejudice. So let's say we do your time-saving jury selection, you do your trials, okay? I would think that there would almost have to be kind of a reinstitution, or I would have to allow the parties for the state and the defense to ask questions of those jurors to make sure that they did not get any type of exposure before I just sat them and had them try the case under like extraordinary media coverage. And so like you would want them sworn, I have to bring them out, I would do that. So like to ensure that her jury, if sent home for a week, 2 weeks or whatever, was not somehow impacted. I think that that's worth it. So if the state thinks logistically, I'm going to leave it to the parties, and then I'll consider whatever motion y'all want. But I think this being a time saving, I don't know if it necessarily is or isn't, because I wouldn't be able, if Ms. Gardner's case came forward, I'd have to have some type of separate proceeding with her lawyers in the state and allowing that jury to be questioned at least to make sure that they didn't see something that's going to be live streamed or whatever. And I'm looking at the case that you cited, which is Allen Wade, which was a death penalty case. And I'm looking at it. It looks like the jury was selected, it looks like in a day and a half. And things have changed quite a bit since 2007, and how, like, I know that was an extraordinary media coverage case, but it didn't have the level of time. And so I understand saving time on jury selection. I have no idea how the state or how many witnesses overlap with one another. But that's why I was saying, like, I think that if thought was put into it, that you could put it in a situation where the juries aren't out for as long as a week or 2 weeks. Maybe they're out an hour, an afternoon, or a day, and then you put on the witnesses and then have them report the second day. There's not that lag between, but it's not before me. You all talk, but I do need, if y'all are going to change things from what we were initially discussing, that has a lot of implications. I was making a big ask of this circuit and the resources that we have to ensure that those jurors were taken and not exposed. And so if y'all are going to change things, I need sooner rather than later. And I mean, not out of April because it takes a lot of money from the stakeholders and logistical plans. So that, Mr. Bias, that's why it is a big deal to me, because like there were dollars that were asked for. There's things that I was putting into place based on our prior discussion. If y'all are going to change the landscape, I need to, it doesn't matter to me. I have time to do it, but we need to do it sooner rather than later. So
a priority from the Fernandez team because it affects the strategy of the case entirely. So we will either make an agreement with the state or file our own motion to be heard on this.
Okay.
Very quickly. And
I need it because they're already doing things. The clerk's office is already working on the summons and how we were talking about doing this whole thing. So it can't just be a conversation. It needs to be like a meeting with everyone that was working kind of to make this happen and make it easy for the attorneys and the parties. Okay.
And we'll address it at the right time. But I have to say, not that Mr. Fernandez's case doesn't have media attention. It does. But I am convinced that our jury selection is entirely different than Miss Gardner's jury selection. I believe the way the media covered Ms. Gardner versus Mr. Fernandez, the level of interest, the number of blogs, the family of the Gardners, international being well known, and respectfully to Mr. Baez, I cannot imagine, and Ms. Menashe and the team of lawyers that they have, that does not factor in to jury selection, given the high profile cases that he's had in Florida and the media attention. Respectfully, no one knows who I am or my team, and that won't be a feature of jury selection as it's never been. So I do think there are significant differences that need to be taken into consideration as well.
So, I mean, tell me what you're saying. I don't know. I mean, like you're saying that.
I'm saying that
as far as the
who Mr. Baez is, I'm sure that's going to be a factor of jury selection. People saying, I know.
But tell me what that means.
That means my jury selection, I don't anticipate being all that complicated. Just like a normal murder trial that we've all tried before, with some level of, I've heard about that case. I don't know that even when people know about the case, they know necessarily as much about Mr. Fernandez as some of the others involved. That's what I'm saying.
Okay. All right. I understand what you're saying now. So you think that the jury selection could be somewhat faster?
Mine versus Ms. Gardner's, yes, I think will be faster.
Okay.
I agree with that. I think it will be faster.
So why wouldn't that weigh into like doing them separately, like totally separately?
Why don't we talk about it and see if we can come to an agreement?
It will take the duplication of directs by the state is what we would be wasting time with by separating these cases, and that the duplication of directs. In other words, we'd have to do a direct examination of the responding officer twice as opposed to once. Everything else is the same, right? So the duplication of jury selection in this case is exponentially longer than the duplication of direct examinations. The duplication of direct examinations is several hours. The duplication of jury selection is several days. That's the difference.
All right.
But
and then no
motion. So
lastly, Judge, we filed a motion to suppress. I think likely the only evidentiary motion that the defense will file from outside of motions in limine, the more closer to trial type motions. That's what you asked for. You set aside time for. It's probably a 2-hour hearing, I guess.
I had time to review the motion. It's pretty straightforward from the state's point of view. I don't know necessarily if I'll need a witness or just introduction of evidence, but I would probably say 3 hours just to be safe.
Good call.
And we have motion hearing time set aside the week of May 4th, the week of May 11th. I set one for Mr. Tenon the week of May 11th, which is also quite short. I'm anticipating getting suppression motion from Ms. Gardner's team, as Mr. Curated said, on the T3 wire. So that one might be a little lengthier. and I'll defer to Mr. Dreiser if he wants to set this to be set May 11th. We could do this motion one day, Ms. Schlack's motion another day that week.
Let me ask, is there, I know y'all are busy, okay. Are there dates that you want me, I can just block them off, like instead of like a to be set, like if I had a trial and make it work, I can block dates because of y'all's schedules.
Sure, we can do that. I haven't had a chance to talk to them yet, but that would be, I think, fairly easy. And I'll speak with Ms. Schlacks as well and get the court dates for those two defendants' motion hearings.
Can I?
Wednesday the 13th is
Wednesday the 13th.
That's fine. That's fine with the state.
Okay. I think Ms. Schlack said something about a trial or
a capital case that concludes the week of May 4th. So Mr. Tenon's is to be set forth, understanding it will be set the week of May 11th. Hers is quite short, so we could set hers that 14th or 15th when she'll be out of trial. I'll get with her and we can email Ms. Wilkes some dates. Or leave it on as a to be set on the 4th.
I don't want to do that. I want to block the dates off and then just give y'all as much time as you need. Can I circle back to the motion, non-motion that was brought up? Do y'all think you can have a decision made by next week?
I think if Ms. Gardner's team can coordinate with us for a Zoom meeting, then yes.
Yes, I absolutely we can.
Well, we'll have a better idea if we have an agreement or not. If we do have an agreement, I doubt we'll have the details hammered out by next week.
I don't need details, but I do need like what you all are at least like, because when did we initially meet? January? When was that meeting?
January.
Okay. So, and we are 5 months out, so that would not stress many people if we could have something, and then we'll be 4 months out. That's doable in my mind. So if we do need to pivot and do something different, that's fine. But and if it can't be settled, that's what I'm here for. So, I mean, y'all know the case. I don't. I'm just trying to make sure that there's enough time reserved. I have no clue. So the only thing I'm asking for you all to consider is not hope, but reality of this case. And then like, meaning how long things just generally take. These are not issues that are generally, they're unique. Let me look real quick.
My recollection is you blocked off 8 weeks. Is that right?
No. So I changed it. I had, we were picking, this was the initial plan. So I'm going to send y'all off to have fruitful discussions. Okay. August 10th through August 14th, that whole week. My hope was that everyone said that y'all think that it wouldn't take that long. So I said, regardless, let's say y'all finish on the Wednesday or y'all finish on the Thursday, I would still be out of session. The jury would be picked. Y'all can work. I'm trying to give y'all time to work. Okay. That after the jury selection, y'all have built-in time. Okay. We would start the trial, I thought both trials, August 17th through the 21st, working full days. And when I say full days, I mean 9 a.m. to like 5:30 p.m. No calendars, no nothing. If I did have something, I'd meet with them way early. Then the full week of August 24th through the 28th. And y'all said you would be done, I thought, like midweek that week. And so I was using the 27th to close down Fernandez, 28th to close down Ms. Gardner's case. I was going to seal the first verdict, close down the second case, And then once Ms. Gardner's case had their jury reach the verdict, I would summon both juries back. Mr. Fernandez's case would only be sequestered for the night or the time frame that it took Ms. Gardner's case to get closed down and verdict. Then this is what I'm saying. They were sequestered. They were just, after their work was done, they're going to a hotel room for a very uninteresting vacation, okay, for a day. And then they get brought back to publish, to pull. That was my thought. And so I did not. Those are 3 weeks. So
The first week of September, blocked off as well.
I didn't have that.
All of it.
I didn't have that.
Oh, sorry,
Mr. Hathaway?
Your Honor, I don't have it on the official schedule.
Well, there's been, in fairness, there's been sidebars, there's been.
Right, but I'm just telling you, well, Mr. Hathaway matters. Okay, so like if it's not on the court schedule, I didn't have it. I have other cases set for trial that week. And so that is what we had 3 weeks, 2 weeks set aside for the trial. Y'all might have had that other week because there was a potential penalty. Once that went away, that went away.
I think when we had potential penalty phases, we blocked off almost 8 weeks.
Right. Well, the schedule has been posted on the docket.
As you instructed, we're going to get this resolved by agreement or by motion, and we're going to do it within days. Okay?
Great.
And then
I'll see y'all next week.
Lastly, from the defense, Your Honor, we had spoke about giving me an opportunity in another courtroom today to be alone with Mr. Fernandez. I don't know if you recall that.
Yeah.
Can we get that logistic?
Yes, sir.
Put away.
Yes, sir.
Today.
Yes, sir.
Thank you.
Your Honor, if I may, if we had a penalty phase necessary, we did cordon off through 9/18.
Yeah, but that went away. So I'll see y'all next week, and we'll talk logistics, okay?
Okay.
I'm back on Thursday.
The 9th is fine. We have depositions set April 10th, so.
Thursday.
The 9th is not good for me.
Yes, sir. When are you available?
Anytime before the 9th.
I'm out.
Are you back? We could do it early in the morning on the 9th, if that works.
What about Friday?
What's Friday? The 10th?
This week.
Oh, this week?
Yes.
Yeah, I can.
Courthouse is closed this Friday.
Oh, it is. That's why I have Friday.
What time on the 9th were you thinking?
We can be here at 8:30 if that is easier for Mr. Baez. That's agreed.
It doesn't have to be 9 a.m. on.
I'm an early bird, so if you want
8:30 is fine. Yeah, 8:30 is fine. 8:30 works.
Deal then.
Okay, see you then.
8:30.
Perfect. Thank you. Have a good day, everybody.
Thank you.
Take care.
Mr.
All right, April 9th. April 9th. And we have that. So we have that. We'll play that next. So this was just basically them talking about separating the trials. Are they going to try everybody together? Are they going to have the two go? Are they going to go, each one go separately? They talk about Jose Baez, of course, has the high profile name. So that jury selection is going to take longer because the chances of people knowing Jose's name versus the other attorneys' names are, especially in Florida, is probably pretty high. She talked about trials starting August 17th through the 21st, 9 to 5:30. She's going to go full days, and then the 24th through the 28th. So they think that it's only going to be, meaning the defense thinks for Mario it's only going to be a week and a half. No, that's the state. A week and a half, and then the defense is 2 days. So you're looking at 2 weeks tops. All right, so let's get to, sorry, got cat fur. Let's get to, what'd she say? April 9th, right? April 9th. Let's go to April 9th. And let's see what this one's about.
Good morning, Your Honor.
All right, so this is a hearing from, nope, not that. Hearing from April 9th. So hopefully this will help you guys as we get closer to the trial. You know, you'll remember all this stuff, and it'll help you understand, you know, all the, I like all the background, the history. I think that's really important. All right, so this is a hearing from April 9th.
Stifler, on behalf of the state, we're here on number 7, Mario Fernandez, and number 8, Shanna Gardner. Next of kin is present on Zoom.
Does anyone know who Jared Tanner is?
No, ma'am.
Good morning.
Good morning, Your Honor. My name is Jesse Dreiser. I represent Mr. Fernandez, along with Mr. Hill, Ms. Day, and Mr. Tassoni, who's present on Zoom.
Okay. Good morning.
Good morning.
And I know there's counsel present via Zoom.
Yes, Your Honor. Michelle Medina on behalf of Ms. Gardner, as well as Kirsten Nelson.
I'm sorry, I didn't catch the name.
Kirsten Nelson. She's also on the line.
All right. Thank you very much.
Thank you.
And Your Honor, we have discussed with counsel for both teams. The state is planning to proceed with the separate trials as we always had planned, 2 separate juries. We're going to hold the trials back to back instead of simultaneously in looking at the order of proof. It's in the state's interest to do so. So we have cleared that with both teams. They are in agreement. We'll ask the court for a follow-up logistics meeting at some point in the next couple weeks to discuss some ideas we have and finalize scheduling.
That's correct, Your Honor.
All right, so start from the top, because this is different than what we talked about in the other meeting.
Yes, ma'am, and circumstances have changed since that meeting, with the co-defendant withdrawing his plea and no longer testifying as a state witness. We believe that we can try Mr. Fernandez's case in about a week and a half, Ms. Gardner's case in about 2 weeks.
Picking the juries at the same time or not at the same time?
That is the state's hope. I don't believe the defense teams are in agreement with that, so we would plan to pick Mr. Fernandez's jury, try his case, then pick Ms. Gardner's jury at the conclusion of his case, try her case. We discussed with Mr. Dreiser this morning some ideas we have we can float to the other team and discuss with the court about ways to ensure that potential jurors are not exposed to media unnecessarily, either through bringing panels in at the start and releasing them for 2 weeks and ordering them not to view media, or perhaps through summons, some kind of court order in their summons or some instructions in their summonses. But we can discuss that with the teams further and give the court our ideas.
But it will be 2 separate juries.
It's always going to be 2 separate.
Just so that's clear.
Yes.
No, I always thought that.
Oh, no, I'm sorry.
But
We'll have 2 separate jury selections.
yeah, okay. And then Ms. Stifler is saying...
I don't know what that hope stuff about. We had an agreement that there's going to be 2 separate jury selections.
Yes, that is the agreement. We have some ideas. We will discuss them amongst each other, and we'd like a meeting with the court.
Okay, can I hear from the attorneys from Ms. Gardner?
Good morning, Your Honor. I wasn't privy to the conversations. I believe Ms. Menashe was in contact with the state with regards to this topic, but it is our understanding, just like Mr. Dreiser indicated, that we would be in agreement with a severance and with 2 separate jury selections right after the conclusion of Mr. Fernandez's trial.
Ms. Menashe did email us acknowledging Ms. Gardner's team's agreement with this plan.
And we were privy to that as well. We were all on the same communication.
Okay, so let me look at my calendar, okay? Mr. Hathaway, so right now we have set aside August 10th for jury selection, right?
Yes, Your Honor.
Can I ask this? So initially, the court schedule was August 10th, jury selection in both cases, and I was going to set aside the entire week, meaning that if you all were able to select a jury earlier, I would still leave the time, meaning break the trial, then start the trial the following week. Is that still y'all's thought?
Yes, Your Honor.
So then the trial of Mr. Fernandez would begin, so the jury selection would be August 10th. His trial would be August 17th through the week of the 24th.
Yes, Your Honor.
Yes, Your Honor.
Okay. Did you all discuss sealing or non-sealing?
We did not, but I assume it would proceed as a normal trial.
Okay, I'll discuss that matter later, but so as to not impact the second jury, my suggestion would be to seal and then publish at the same time. And then just summon the other jury when the other case concludes. They wouldn't be sequestered. They'd already reached a verdict. Then I would seal the verdict until the other case concludes, and then I publish both at the same time.
Certainly we can discuss that. My concern actually was not with the jury being sequestered, and I appreciate that they wouldn't, but my concern is that if Mr. Fernandez is found not guilty, he's staying in custody for an additional 2 or 3 weeks. That does concern me, and I'd like to at least research that and have a more finite discussion on that when we do our logistics meeting. I'm not saying I don't agree, I just am not saying I agree either. I see some concern.
So there's if you want me to publish, then what I would do is I would set aside more time for Ms. Gardner for jury selection and some more jurors. If you don't want to seal it, I understand your concern. So if you don't want to seal it, then I'd double the amount of Ms. Gardner's jury panel. And then I'd set aside more time to pick her jury because it would take longer.
That's something that we can all consider and let Your Honor know which we prefer.
Well, I'm going to do it now. I'm done with this. I'm going to do it now. I'm going to reserve the time now because my calendar is filling up. When I cleared those dates, I started setting trials. So I don't want to try to scramble around and move trials in other cases. So I'm going to do it now. So this is my thought, okay? So.
That's fine.
What's fine?
That we make the decision now and that we are sticking with our proposal that
don't seal?
That we don't seal.
All right. It'll just make the second case harder to pick.
I'm sorry.
That's not your fault. I'm just saying, I need to logistically plan for that. I can't try to crunch it and then not have enough time. That is a nightmare. It's better to reserve more time and not need it than need the time and not reserve it. So, Mr. Hathaway, stick with me, okay?
Yes, Your Honor.
August 10th will be the full week. That is August 10th through August 14th will be the jury selection in the state versus Mario Fernandez, okay? His trial will be scheduled August 17th through August 28th, okay? If you all finish early, okay, I can meet with the Gardner case if need be to handle any issues that may or may not arise, okay? If you don't, then you'll have the time. Then Shanna Gardner's case, and you all, Ms. Medina, speak up, okay, if this is not acceptable. My thought would be that we would schedule her jury selection the entire week, working full days in that case, August 31st through September 4th. It's actually good because September 7th is a holiday, and if we don't finish, I can bring up the court. You know, normally we would completely be down, but if we needed the extra day, it would be built in. Then I could always bring up. And I could also, if it becomes a true issue, I can work into the weekend. I'll ask the chief judge for that permission, okay? And then, so it will be a week. Again, if you all finish early, great, you'll have the time to work. If you don't, then we'll have the weekend into the holiday weekend, okay? And then we would start the trial September 8th. And what's the thought between the parties of how long Ms. Gardner would take? A week, 2 weeks?
I think 2 weeks, yes, Your Honor, until the 18th, if you want to block that off. I have a better sense from the Fernandez team about how long the trial will take than I do from the Gardner team. I will talk to them, and if we need additional time, if they think they're going to need additional time for their case, they can let me know, and we can let the court know.
I can always take it. I'm sorry, go ahead, Ms. Medina.
Yeah, I personally would rather be conservative and ask for 3, just to be safe.
We can.
I can always take it off.
Yes, we can book it through the 23rd. 24th.
All right, so are you still with me, Mr. Hathaway?
Yes, Your Honor.
So jury selection, August 31st through the 4th. Gardner's trial, September 8th through September 25th. Okay.
And Your Honor, a number of jurors for each panel?
Give me a second to do some math. Yeah. Okay. Oh. 250 for Mr. Fernandez. Do y'all have any objections to that? I would summon them in 100 panels, like 100 jurors at a time.
That's fine. Certainly don't need more than that.
That's very I think a conservative estimate. I don't think we'll need that many.
250.
I'm in agreement.
All right. For Gardner, 500. 100 every single day. So it'd be 50 in the morning, 50 in the afternoon, 50 in the morning, 50 in the afternoon until we get a set panel that you all agree to. If we get to the questioning panel, I'd excuse the other ones, okay? So it would be the same plan, meaning we would spend essentially the first days using high publicity hardships only so we can get through the panels. It would be 50 in the morning, 50 in the afternoon, 50 in the morning until we get to the seated panel. And then those that aren't excused for those reasons would get a questionnaire to fill out before they leave, and then they would be coming back on the day if we get an idea of how many jurors. Okay, and I'll work that out at a later date. So 500 for Ms. Gardner, 250 for Mr. Fernandez.
Yes, Your Honor.
Yes, Your Honor.
Okay. All right. You want to keep the other dates?
Yes, Your Honor.
Okay.
We have, just for the court's information, we have depositions set. We've taken a couple rounds since our last court date. We have depositions tomorrow, April 13th, April 16th, April 23rd, 24th, 29th, 30th, and May 4th. And then we have a motion deadline this Friday, as well as time set aside the week of May 11th. The 13th, we have Mr. Fernandez's motion set, and I will get with Ms. Schlacks about setting Mr. Tenon's motion that week as well.
Okay.
I've not received the Gardner motions yet.
I'm sorry, Your Honor. We had no indications that there was a motions deadline for this Friday. We had a date for May 4th for evidentiary hearings, but I was having difficulties finding anything written.
No, I think it was just verbal agreement, Ms. Medina, so it wasn't anything. Okay. I think we just discussed it so that you all would have the time. So I'm not sure if you all are contemplating any evidentiary motions.
We are.
Okay. How long do you think you need?
I see. I would say at least a week, Your Honor.
That's fine with the state.
To be able to follow them.
Okay. I want to give the state, whatever you file, I want to be able to, because we were going to handle it that time in May. But obviously, this case is a priority, so if y'all needed more time or a different date, I would make the time. So why don't y'all discuss it, and we can come back if you want, or you can just let me know.
Okay, will do. Thank you.
What do you want to do?
I can get back to the court today.
Sure, I'll speak with Ms. Medina. If they can get me their motions by next week, that should be sufficient time for me to get whatever witnesses I need and prepare. I mean, I have 3 different defendants and 3 different motions, so I would like time to make sure I'm prepared for all 3 defendants' motions with whatever necessary witnesses I need. But if she's asking for the end of next week, that should be fine.
Okay. All right. Well, let me know if something changes.
Yes, ma'am.
Okay.
Of course.
So what's the next date, Mr. Hathaway?
Your Honor, the 13th for Mr. Fernandez is our hearing on motion date.
May 13th, yes.
Do you want to just go to that date? Is that fine?
We can for Fernandez, and for Gardner, we can do we had a May 4th to be set, I believe.
Right.
When I receive her motion, maybe we could coordinate a date certain and email the court.
I'm okay with that.
Are you still in trial with Judge Fine?
So that is, we're in talks right now, Your Honor, with the state.
Okay. Because I thought
Unfortunately, the judge has not set dates yet for arguing motions, but all that has been submitted. So we're just waiting for a date on that, and then I'm sure by that point the judge is going to want to know whether it's going to proceed on the 27th or not.
On the 27th. Okay.
Yeah.
So.
And it's still a death case.
All right. So what do you want to do about, I don't want to conflict with his schedule. That is, myself and Judge Fine are teaching together. I do have that date. So we're teaching together on the 18th through the 22nd. So we'll both be out that week. And then I guess he's coming back to that trial on the 26th or 27th.
The 27th.
Ms. Medina.
So it would have to be, I guess, the week of, hold on. So the week of the 11th?
Right. Do you want me to call him?
Sure. That would be helpful because we still don't have a status, like I said, a status date on that.
All right, court will be in recess. Yes.
All right, so that was some good information. We just found trial dates. So that was really good information there. Trial dates are jury selection the 10th through the 14th of August. So trial starts the 17th, going to the 28th. That's for Mario. And then immediately after that, Shanna's going to be the 31st for jury selection. They're going to impanel 500. They're going to talk to 500 jurors, prospective jurors for Shanna, and 250 for Mario. And then her trial is going to be the 8th through the 25th of September. So mark your calendars because we will be absolutely streaming that. And Judge talked about sealing the verdict for Mario, but I'm not quite sure. Did she finalize that? I don't know if she finalized that or not. Not sure if she finalized. She said she was going to possibly seal it. So I'm not sure. Did she actually finalize that? I don't know. I didn't hear her actually finalize that. All right. In any event, here's a quick little news clip, and then we'll get to another pretrial hearing. So here's a quick little news clip of what we just watched. Let's see if they...
A married couple charged with...
Let's see if they can break it down at all for us.
Murder and the ambush killing of a St. Johns County father will be tried separately. Good afternoon, everyone. I'm Jennifer Waugh. Thank you for joining us. A Duval County judge has ruled that Shanna Gardner and her estranged husband, Mario Fernandez, will not be tried together in Jared Bridegan's murder. Bridegan was gunned down 4 years ago after dropping off two of his four children at their mother's Jacksonville Beach home. At the time, Shanna Gardner and Bridegan were in the midst of a contentious custody fight for their twin children. News for Jax reporter Brianna Brownlee was in court this morning and is joining us now live. Bree?
Yes, Jen, the big takeaway from today is that these trials will not happen at the same time. Judge London Kite did rule for these trials to be separate with two separate juries and two separate jury selections. Now, this comes a week after there was much confusion in the courtroom on how they will move forward. Now, here is what that schedule is expected to look like. Now, Judge London Kite laid out a tentative timeline for both cases, starting with Mario Fernandez. His jury selection is set for August 10th through the 14th, with the trial expected to begin August 17th and run into the following week. Now, Shanna Gardner's case will follow with jury selection scheduled for August 31st through September 4th, and her trial is expected to start September 8th and run through late September. Now, Judge Kite also outlined the scale of jury selection in this case, saying it will take hundreds of potential jurors, especially for Gardner's trial.
250 for Mr. Fernandez. Do y'all have any objections to that? I would summon them in 100 panels, like 100 jurors at a time.
That's fine. Certainly don't need more than that.
That's very I think a conservative estimate. I don't think we'll need that many.
250.
I'm in agreement.
All right. For Gardner, 500. 100 every single day. So it'd be 50 in the morning, 50 in the afternoon, 50 in the morning, 50 in the afternoon until we get a set panel that you all agree to.
So yes, Judge Kite says there will be a follow-up discussion to finalize some details. However, it seems like some of the issues that they had last week seems to be resolved. Everyone is expected to be back in court in May. Reporting live, Brianna Brownlee, Channel 4, the local station.
All right. So, September is going to be, August and September are going to be, it's going to be a busy month for us. No question. We will sort it out, though. All right, so let's continue. So she said May 13th. So let's go to May 13th. So this is Shanna only now. So this is a Shanna only, what do you call it, hearing.
All right, at the
So this is from May 13th. Oops, no. Sorry. Oh. These are both May 13th. So Henry Tenon had one. Thanks. That's Super Bowl. So Henry Tenon had one on May 13th too. I didn't know that. All right, let's. This is a hearing from May 13th. Sorry. What did you guys? Did she say anything about sealing it? She said she was going to seal it. The verdict would be held so they both get read aloud on the same day. So, right, but if it's, and Sherry's like, if it's live streamed though, how's she going to do that? Maybe she won't live stream that. Maybe the verdict won't be live streamed. Thank you. Yeah, thank you. That's good. How do you seal a verdict when it's being live streamed? We'll have to, I've never really saw that one before. Hey, Play on Crime. You've been waiting a few hours to ask this question. Why are they making this trial so complicated? Tampa just completed a 4-defendant trial not even a week ago. What's special? Thank you. The two parties aren't playing nicely together. Everybody's squabbling over everything. The Charles Jones trial, I think the parties were more in agreement with each other. It seems like they worked a little bit better together. These three parties, there's the state, there's three defendants, don't seem to be giving discovery, and everything just seems to be a slog, to be quite honest. That's what I'm getting out of all these hearings. Even into last year, we started watching this last year, and it seemed every hearing the two parties were like, they didn't do this, they didn't do that, they didn't give us this, they didn't give us that. So to me, it seems like it's just the two parties not playing together. So, all right, let's continue on. I'm going to just step away a little bit. I've got some pad thai. I made some pad thai over the weekend. Aaron just heated it up, so I am going to enjoy my pad thai while we watch this next little bit here. So, here we go.
attorneys will please place their appearances on the record.
Afternoon, Your Honor. Christina Stifler, Ms.
All right, so we have a few motions, and I want to know kind of where the parties want to start.
Had some discussions with the defense counsel, Mr. Curated, regarding the defense motion to exclude testimony of minor child BB.
Was that adopted by Fernandez too?
It was, Your Honor. I've had discussions with Mr. Dreiser as well. The state's position is at this time the motion is not ripe to be heard. It's not a constitutional suppression motion. It's a motion to exclude testimony. The state has told Mr. Curated and Mr. Dreiser we would like the opportunity to sit down with the minor child BB, speak with her ourselves, determine if we believe we will call her certainly as a witness at trial or not. If we do make the decision to call her as a witness at trial, I think both sides would agree that a competency hearing would need to be held at that time. The court can rule on this motion without conducting that analysis and without hearing from BB themselves.
Do you agree with that?
Partially, Judge. I do think the court can rule based on section 403 and 604, 403 and 604, as articulated in the motion, regarding the minimal probative value of her testimony, and using the evidence that we attached, which is the forensic interview that was done with her, I believe, 2 days after the incident. So there are two grounds. Your Honor, the first one we don't believe involves BB. That is your consideration of the probative value of her testimony and whether or not it's outweighed by unfair prejudice. That argument is simply that there's no dispute that BB was in the car at the time that Mr. Bridegan was murdered. There's no dispute that she was 2 years old at the time. There's no dispute that she was in a rear-facing car seat in the back passenger side of the vehicle. There's a picture attached to our motion as well that shows her car seat in the position that was an ET photo. There are several scene witnesses that took BB out of the vehicle, and BB's, the one thing that we believe BB would add based on her forensic interview that's before the court is that she heard booms. There is surveillance footage that captures the gunshots in this case. And there is no dispute that Mr. Bridegan was shot. And so our position is that on a 403 and 604 ground that she's two, she was in a rear-facing car seat. There's a forensic interview of her where the only thing that's probative at all is that she heard booms, and daddy got sick, I think is what she's saying. And Your Honor, there's simply no dispute that she was present in the rear-facing car seat. And so there's minimal value in parading a very young child into a trial of this magnitude. And so we would ask that the court, without further information, without further evaluating the child's competency, just make the call. Now, if the court's unwilling to do that, we do have competency concerns. She's a very young child, but we agree with the state that the first step in that, the state has indicated to us that they are not sure that they're going to call her. And so if they do not intend to call her, then there's no purpose in going forward with a court-appointed expert to evaluate the child's competency. And there's no point in us trying to depose the 6-year-old child now.
So just a couple of things. I understand what the defense is proposing to me. However, I look back at the indictment, there's count 4 where BB is named. And so exclusion of potential quote unquote victim testimony, I think, to just automatically rule, I'm going to wait, I think, to see if it's offered, right? So just across the board, exclusion of witness testimony is a harsh remedy / sanction. If I needed to do the analysis, I'll do it if the state says that they're going to offer it. So I'll just hold this one, okay? I think that's...
I would ask that the court set a deadline for the state to make the call as to whether they are going to call her as a witness. A very reasonable deadline, sometime in June, give them more than a month, but I think that we need trials coming up.
No, I agree. We're running out of runway. So when does the state believe that you're going to make the call?
I've told Mr. Curated that I intended to speak with her in June. We've been heavy in our depot's schedule in the month of May and obviously preparing for these hearings. We've not had Mrs. Bridegan, Evie's mother, they are out of town, so I have not had the chance to coordinate with her, but if the court wants to set a deadline at the end of June, that's fine with the state.
No, sooner than that. June 15th.
We have the following week. I'll be out the week of the 8th. And 22nd.
So what I'm hearing, so let's say hypothetically, the state does intend to call her. Someone wants to do a forensic evaluation.
No, if they don't intend to call her.
No, I said if.
If, I think the law demands it at this age, that there has to be an independent forensic evaluation ordered by the court regarding her competency. She was 2 years old at the time. Competency is judged at the age at the time of trial, which is 6, but the law is pretty clear that 6-year-olds have to be evaluated for competency.
Your Honor, I believe the court makes that determination.
In a hearing? What are you citing?
Competency to stand trial, it's competency to testify, which is the court would undergo an inquiry with the child in court of whether she has the ability to understand the difference between right and wrong, a truth and a lie, can present testimony in a coherent narrative manner.
I don't want to push. But I feel like I have to, okay? It's May 13th. If I wait to June 22nd, y'all have not taken a deposition, correct, of BB?
They have not, no.
You're correct.
Right, and so when would you all, so let's say I wait to June 22nd, when would you all be able to accomplish that? And then this court have a hearing?
June 18th then, Your Honor. That gives me the week of, I'll return obligations the week prior, and that'll give me enough time.
Understand.
By the 18th, I'll have an answer for defense counsel as to whether we believe we'll call her.
June 18th?
Yes, ma'am. That's that.
Sorry, but I just don't know. I mean, this has a domino effect on everyone's schedule, and then there'd just be no way to get it accomplished. So June 18th will be the deadline.
Thank you.
Thanks.
And Judge, the case that I was citing for the independent forensic evaluation is Lloyd versus State. That's Florida Supreme Court, 524 Southern 2nd, 396. And in that case, I don't know that it's required, but the defendant did motion. The court granted it.
Wait. 520, is Lloyd
versus State.
Was it recently decided?
1988.
1988, okay. I'm thinking another one. 524 Southern 2nd.
396.
396. Thank you. I'll look at it, but if I'm going to hold it, then I'll read it.
Yes, Judge.
Okay. So this was for the forensic evaluation?
And we're motioning for that, I guess, as opposed to saying that it's absolutely required under Florida law.
Okay. Which one do you want to take up next?
I'll defer to defense.
Judge, if we could call up the motion to suppress the wiretap evidence.
Okay. 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 Thank you. Okay, I'm ready.
Yes, Judge, and as a starting point, I don't think there is any dispute on the law between the state and the defense here. And as I heard this court state this morning in Mr. Tenon's case, oftentimes motions turn on the facts. And so I'm going to focus more on the facts and the law. I believe the court knows that essentially it's supposed to give deference to the magistrate or the judge in this case that signed the warrant. But we do ask the court to conduct the appropriate review of the wiretap warrants that were provided to the court. I've also provided a disc to the clerk, Your Honor, with the same documents that were provided to the court. Your Honor, the wiretap evidence should be suppressed because the intercept orders were not supported by particularized probable cause. The state's presentation was voluminous. It's a very long document, but volume does not equal probable cause. The application and the affidavit repeatedly grouped Ms. Gardner together with other target subjects, but the facts actually alleged against each person are materially different. And this court must evaluate the probable cause for Ms. Gardner separate and distinct from the other targets. The affidavit contained direct evidence tying Mr. Tenon to the murder scene, the suspect truck, and the tire. It articulated evidence tying Mr. Fernandez to Tenon, Ordway, and Biggerstaff and the rental property. And it articulated communication or movements between those individuals, those 4 individuals, not Ms. Gardner. The allegations in the affidavit made against Ms. Gardner were largely motive, family court history, post-defense media reaction, and her marriage to Mr. Fernandez. That is not enough, Your Honor, and it should not have been enough for the reviewing court if the reviewing court had actually looked at the affidavit,
and analyzed it as they were required to do under the law. Because what we're talking about here are real-time interceptions of private communications of a United States citizen. The January application expressly identified the 5 target subjects. Those were Tenon, Ordway, Biggerstaff, Fernandez, and Ms. Gardner. I'm sorry, Tenon was in jail at that time. But in collective terms, held that they had motive and opportunity, confirmed relationships, communication patterns, and evidence of the conspiracy. So he used generalized terms and then sought to intercept the phones of Fernandez, Gardner, Biggerstaff, and Ordway after law enforcement was to publicize Tenon's arrest in order to trigger communications among the targets. So that's the framework that the police and the state have orchestrated with the hopes that they would get a warrant to record all of these individuals' phone calls. But here's the problem. Biggerstaff was described as Fernandez's longtime associate, having frequent contact with him before, during, and after the homicide, and having lied about a potentially relevant firearm that may have been used in the murder. Ordway was described as Tenon's roommate who had been Fernandez's tenant, and someone believed, I'm talking about Ordway, someone believed to have had a role based on witness statements and phone records. Ms. Gardner, however, was described simply as Bridegan's ex-wife, Fernandez's spouse, and that she lived in her house where the children were dropped off that night. The affidavit sets out evidence that the homicide was a planned ambush, that Tenon's truck and tire were connected to the scene, that Fernandez was the single link between Tenon and Bridegan. It then asserts that Fernandez enlisted Tenon, Ordway, and Biggerstaff to assist in the murder. And the only link is that Ms. Gardner, quote, provided monetary compensation to Fernandez, which he then used to compensate Tenon. Now, besides the fact that monetary compensation to Fernandez is simply false, and this court knows that from prior evidentiary hearings, that there's no evidence that Gardner provided any monetary compensation to Fernandez, which he then used to compensate Tenon. But the factual basis for the affidavit's leap to connect Ms. Gardner is thin. It's simply motive. It's not a communication. It's not any direction. There's no evidence of any actual payment by Ms. Gardner or any specific transfer of money or funds. There's no surveillance that observed anything involving Ms. Gardner. There's no cell site location records implicating her, and there's zero statements by anyone connecting her to the alleged murder for hire arrangement. The state's strongest facts against Ms. Gardner were simply motive facts. The assertions, the motive, is not the same as probable cause. Because even the state's case law that I believe they're going to give the court, you have to have facts. You have to articulate specific facts that connect someone to a crime. And they simply didn't do it. Many people have contentious divorces. Many parents have custody disputes. Many people consult lawyers, public relations professionals, friends, and family after being publicly associated with a homicide investigation. And the United States Constitution in Chapter 934, they require more before the state can listen to private communications in real time. There's nothing that particularizes probable cause against Ms. Gardner, and there's nothing that shows she knew about the tire, the truck, the firearm, the plan, or any payment to Mr. Tenon. The application's trigger action section further exposes the weakness in the probable cause, showing that the reviewing court should have picked up on if they had not abandoned their role. The state did not claim that Ms. Gardner had made incriminating calls before with anyone, or that there was a real probability that she would make them if this trigger thing happened. So it was not a, hey, we know she discusses the murder on the phone with other people. Instead, it planned to create a media event and then listen to her reaction. And so it relies on leaking to this leak to the media that there had been a break or an update, and then announcing Tenon's arrest. And that may have been an investigative tactic, but it cannot support probable cause retroactively. It had to exist before the interception began, and a plan to provoke conversations about a highly publicized murder investigation does not prove that Ms. Gardner was likely, or that they had probable cause to establish that she was criminally involved. There's also issues with the February application, Your Honor. That's an application where the state obtained a wiretap for Ms. Gardner's sister's phone, SH, believing that based on an intercepted phone call, Ms. Gardner would seek to use her sister's phone when her sister was visiting her. Your Honor, there's not probable cause to believe that any conversations using the sister phone would actually have supported, would actually have occurred that would have discussed the murder, or that there was probable cause at that point that Ms. Gardner, again, was involved. In the February application, they rely on actual intercepted statements. You'll see that. But if you actually read or look at how they describe Ms. Gardner's calls with Ms. Jensen, they're discussing media coverage, public relations advice, alternative theories, some concerns that Mr. Tenon might implicate her, and a concern that law enforcement may interpret some seed money that Mr. Fernandez gave to Mr. Tenon as a payment. Those are not admissions. Those are consistent with a person who knows she's a suspect, is receiving legal advice, and is worried about media pressure. There's simply no connection, no nexus that is necessary between the crime here and recording Ms. Gardner's phone calls, either in the January application or the February application. The warrants rested on guilt by association and investigative hope. And Your Honor, that is not simply enough to wiretap someone's phone. I know we don't like to say that the standard of probable cause is different depending on what type of warrant the state is seeking, but there is a whole section in the Florida statutes dedicated to wiretapping for the very reason that it requires heightened scrutiny. And the reviewing court did not sufficiently read this affidavit and the application with respect to Ms. Gardner and simply rubber stamped it. There was not probable cause here, and the wiretaps were unlawful, Your Honor. And for that reason, this court should suppress the wiretap evidence of Ms. Gardner's phone and her sister's phone.
Thank you. Hear from the state.
Yes, Your Honor. I provided a case to Mr. Curated, which I'll provide to the court as well. United States versus Ventresca, VENTRESCA, 380 U.S. 102. It's a United States Supreme Court case from 1965. And what it discusses is the deference given to a magistrate's determination on a search warrant. And the court goes through a historical overview of the purpose behind a search warrant for the Fourth Amendment purposes, and that the case law and the review by those looking at a magistrate's determination is given great deference because the courts historically have accorded great preference to police action
taken under warrant, which is subject to judicial review, rather than search and seizures without one. They discuss that probable cause is less evidence than would justify condemnation. So while Mr. Curated argues the evidence, in his mind, probable cause is a low bar. In his mind, it may not rise to the level of a higher standard of proof, but certainly the courts have well established that probable cause is a flexible, it is a rational and common sense approach to looking at evidence. It is merely reasonable grounds that evidence of a particular crime will be found in a particular place. In this case, the court writes that the recognition that the Fourth Amendment's commands, like all constitutional requirements, are practical and not abstract. That's at page 746. Affidavits tested and interpreted by magistrates and courts must be done in a common sense and realistic fashion. These affidavits and warrants are drafted by non-lawyers in the midst and haste of a criminal investigation. Technical requirements of elaborate specificity, once exacted under common law pleadings, have no place in this arena. And they discourage the court from taking a grudging or negative attitude towards warrants, because that would discourage police officers from submitting them and having that judicial review. The court writes that the resolution of doubtful or marginal cases should be determined by the preference to be accorded to warrants. I say this to the court to say, in no way do I believe that this is a questionable or marginal determination before the court. I believe that the affiant, in this case, outlined with specificity and at length the bulk of the evidence in relation to a conspiracy between multiple individuals and to Ms. Gardner's participant as a principal to the murder of Jared Bridegan. The cases cited by Mr. Curated in his motion generally support the fact that courts are begrudging to suppress or exclude evidence where a magistrate has reviewed it and where there has been specific and articulable facts outlined by the affiant. The test, he cited Cherney versus State in his motion, 348 Southern 2nd, 395. That is a third DCA case. The court in there, and he cited it for the proposition that probable cause cannot be based on mere suspicion. That the court in so holding goes further and says that the test to whether an affidavit establishes probable cause is not whether the evidence is admissible or sufficient to prove guilt at trial, but whether that information would lead a person of prudence and caution to believe an offense has been committed. And that test depends on the probabilities determined by factual and practical considerations of everyday life on which reasonably prudent, cautious persons, not legal technicians, act. In the case he cited, the court found that there was sufficient facts outlined in the affidavit, that reasonable inferences could be made from those facts, and that an inference is the essence of probable cause. What we're talking about here is a perfectly acceptable way to prove a case beyond a reasonable doubt or by probable cause or otherwise, which is the law recognizes circumstantial evidence as well as direct evidence. The affidavit is replete with both as it relates to Ms. Gardner. There is a discussion of direct evidence that would suffice for probable cause in her involvement. She is one of the co-owners. She was the one who applied for a limited liability corporation license for First Choice Home Rentals, which is the account on which the payments to Mr. Tenon were drawn. There is evidence in here that she financially contributed initially to First Choice Home Rentals through payments from her trust fund, the Shanna Gardner Irrevocable Trust Fund. So there is a nexus between her finances and the payments that ended up in the hands of Henry Tenon. There is evidence in here from direct statements from Ms. Gardner herself to members of the deceased victim's family that she was, and I'm paraphrasing because I don't have the page in front of me, but that she was looking for someone to take care of him, to get rid of him. She told a friend on page 7 of the affidavit, she advised a friend that she and Mr. Fernandez had a discussion, that Mr. Fernandez told her he could take care of him and no one would ever know, referring to the deceased victim. That Mr. Fernandez told her, and she's telling this to a friend directly, that he could, quote, get 4 guys, break into Bridegan's residence in the middle of the night and take care of him. So there is direct evidence from her own statements to individuals that are outlined in this affidavit, that she had the conscious intent voiced on her desire or hope to take him out, get rid of him, take care of him, hire a hitman, etc., and that she had had those conversations as disclosed to a friend with Mr. Fernandez. And Mr. Fernandez, throughout this affidavit, has direct connections to Henry Tenon, who is more than enough evidence to suggest and to prove that he was the shooter in this case. Video evidence, Google location evidence, cell site location evidence, DNA, his possession of the vehicle. The court looked at evidence as outlined in the affidavit of her phone discussions or her phone calls during significant times in the investigation with significant members of this conspiracy. Specifically, when Mr. Fernandez was asked to come give his interview to the Jacksonville Beach Police Department on February 28th of 2022, it was scheduled for the next day, March 1st, 2022. He deleted over 5,400 items from his Google account. He went to the interview. Ms. Gardner went to the interview. It outlines their statements to police, which outline their dislike for the victim. Mr. Fernandez's comments to police that the kids would, quote, be better off without him in the picture, that they were fighting for majority custody, that he and Mr. Bridegan had some sort of confrontations, altercations, or disagreements in the past about child care issues and drop-offs. And then we see in the affidavit outlined, at the time known to the affiant, that she is calling Mr. Fernandez while in between the time that he had his interview, their children are scheduled, or rather his stepchildren, her children, are scheduled for a CPT interview regarding the whereabouts of all parties and the deceased victim denied the homicide, that she is repeatedly speaking to Mr. Fernandez as he takes what Your Honor has heard in testimony before in other hearings, but is outlined here, an unplanned, spontaneous trip up the coast. There's evidence that Ms. Gardner had phone contact with Mr. Fernandez and with her criminal defense attorney and her public relations firm on August 18th of 2022 when Mr. Tenon was arrested on unrelated charges, unrelated to the homicide. So there is direct evidence of her communication with co-conspirators. There is evidence of her having direct control and or access to funds that were used to pay Henry Tenon. Just because there are innocent explanations for individual pieces of evidence, the law says that the court is to look at probable cause under a totality of circumstances. Just because you remove one fact and can give an innocent explanation to it does not mean that that innocent explanation should or can or shall be accepted. The court can still consider other purposes for that evidence and consider it in the totality. And in fact, the courts caution against doing that. They want the magistrate to look at this in a totality, to look at it with a common sense viewpoint, to look at it at what is known to the affiant at the time and what the affiant's reasonable assertions and conclusions from objective evidence can be relied upon. Detective Johns in this affidavit did not merely say Ms. Gardner has significant contact with her co-conspirators, she contributed financially, she has a motive, case closed. He gave his opinion, and he also gave the magistrate the objective data and facts outlined at length. So the magistrate was free to accept or reject his assertions based on his training and experience and the knowledge that he received from other agents and other officers in this case, as well as statements he received from witnesses in this case. Mr. Curate's cases he cite, for the most part, the court has upheld denial of defendant's motions to suppress. Further, in the cases he cited in his motion, discuss the exception or the Leon exception for good faith. I know and I understand that the defense is limited in what they can argue to exclude the entirety of the wiretap because of this exception. And if a magistrate issues a valid search warrant that appears to have probable cause on its face, the Supreme Court and the progeny of Leon has said an officer, the point of suppression is to deter bad police conduct, not bad magistrate conduct, bad police conduct. So for Your Honor to grant the relief Mr. Curate is asking for, you would have to find that this 51-page application and an 18-page order that outlines these direct and circumstantial pieces of evidence that draws upon reasonable inferences the affiant made from objective evidence that he provides to the magistrate is so devoid of probable cause that any officer reviewing a validly signed warrant by Judge Meredith Carbula with the 4th District or Fourth Circuit here would be unreasonable in doing so, and that's just not the case here. And the defense has failed to meet its burden in showing that to the court. And I just will further cite that in all of these cases that he has cited in his motion involving guilt by association, those are very distinct and discrete on their facts. Those are talking about cases where a car is pulled over and a search is done of the vehicle absent a warrant, or a search warrant of a house where a husband or a wife or an individual is merely present at the time a search is conducted for something tangible like narcotics. And they're trying to infer that because so-and-so is in the vehicle with so-and-so who has narcotics, that therefore we're going to search them and we're going to arrest them for guilt by association on these joint constructive possession issues. This is a very specific case, and the probable cause and factual determinations in this affidavit are very fact-specific to a conspiracy, to a long-term plan for a murder for hire, to a cover-up of a homicide, to continued conversations between the co-conspirators. And based on what is outlined in here, the judge was extremely reasonable in finding probable cause, and the officers were even more reasonable for relying upon that in executing this search warrant and intercepting those wiretap communications. So we're asking that the court follow the case law, follow the United States Supreme Court in Ventresca and Leon and its progeny, and deny the defense motion.
Okay. Mr. Purdy, I'll give you the last word.
Yeah, just briefly. So I would ask the court to read the application, the affidavit. I do have some disagreement with Ms. Stifler's recitation of what was included in there, but the court has the document and is limited to four corners. The deference that this is a non-lawyer document, Your Honor, I think is not the case here. I'm pretty confident that either the state attorney wrote this or at least edited it before it went forward to the court. So this is not the type of affidavit that deserves deference that law enforcement's writing in the middle of the night. This is obviously a document that had legal work performed on it. And then the only other thing I want to point out is that the whole purpose of a trust, as any lawyer knows, Your Honor, means that you can't control the money. So a judge should have known the fact that Ms. Gardner was the beneficiary of a trust means that she doesn't control the trust money. I mean, that is 101 legal. And so
you're arguing that to say what? That the magistrate was...
I mean the state has tried over and over again to connect Ms. Gardner to money. But all they say is that there was the Shanna Gardner trust. Well, it's in the document. Mr. Fernandez was the trustee. Ms. Gardner was the beneficiary. A trust means that the trustee controls the money.
Right.
For the benefit of the beneficiary. But the beneficiary can't force a trustee to do anything unless you go to court and you sue someone for a fiduciary duty violation. But,
okay, so you're arguing that fact to say that when reviewing...
Right, when a judge is reviewing this, a judge should be like, well, what does it matter that there's a trust that she benefits from? That's not her financially. Ms. Gardner cannot financially compensate anyone through her trust. She, as a beneficiary, she has no control over the trust. And that's the point, that there's no financial connection. That Ms. Gardner was on an account that was used to write checks to Henry Tenon that were signed by Mr. Fernandez.
So you're saying a judge should have known that, so that fact should fall away. That couldn't lead to probable cause within the four corners. Is that what you're saying?
That seems to be, as the state goes through here and makes arguments, again, I agree the case law is the reviewing judge deserves deference. But I heard the state talk about that was one of the things that a judge would have seen and would have agreed that it clearly established probable cause. It shouldn't. Just like the fact that Ms. Gardner had communications with her husband.
Okay.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor.
Good
Christine
afternoon.
Nelson. I would like to take up Ms. Gardner's remaining motion to suppress, which relates to 3 warrants, one for her iCloud account, her Google account, and her iPhone. I'm going to focus primarily on the iCloud account since all 3 warrants have similar problems. I'm happy to answer any questions about the other 2.
Okay.
Your Honor, what we have here is that the state sought and was granted 3 separate warrants that essentially gave law enforcement unfettered access to Ms. Gardner's life. Every email, every photograph, every internet search, and every deleted file. And then law enforcement was allowed to rummage through those files with unfettered access to determine what they thought was relevant. To paraphrase Justice Brandeis, the progress of science does not erode the Fourth Amendment protections. And so what we are asking this court to do is to examine these warrants and to uphold what the Florida Constitution and the federal Constitution require. And that is suppression of this evidence. Mr. Curated has already talked to the court at length about probable cause, but we're again talking about probable cause here. I won't repeat all of the same arguments Mr. Curated made. We would incorporate them by reference. However, there are some that are particularly pertinent here. The first is, when we're looking at warrants, as this court knows, there are 2 requirements under probable cause. The first is the commission element, and the second is the nexus element. And so I'm going to take them one at a time. So when we're talking about the commission element, meaning, is there probable cause to believe that Shanna Gardner committed the exact crime for which the magistrate found probable cause? So if we're looking at the iCloud warrant, which we submitted to the court, and I'm happy to provide additional copies if helpful, the commission element there is only premeditated murder. That is the only crime for which we are talking about probable cause, not conspiracy, not child abuse, not murder for hire. And that's important because the facts are slightly different. So what we see here, Your Honor, is that we do not have evidence, allegations of Ms. Gardner's involvement at all pre-Mr. Bridegan's death. There's nothing in the warrant to suggest that Ms. Gardner was involved whatsoever pre-death. Not only that, the evidence that is cited regarding Ms. Gardner's involvement is more along the lines of conspiracy. But there wasn't a finding of probable cause for conspiracy. So that cannot provide the basis for a valid search warrant here. When we strip away all of the, I'll say, conspiracy-style allegations about relationships and communications with co-conspirators and things of that nature, what we are left with is very similar to an argument that Mr. Curated made earlier, and that is that the affidavit focuses on Ms. Gardner's intimate relationships. Mr. Bridegan was her ex-husband, and Mr. Fernandez at the time was her current husband. But Your Honor, that's nothing more than a hunch dressed up in a marriage certificate. And the Supreme Court has been very clear, a hunch is still a hunch, and that is insufficient for a finding of probable cause. I would direct the court, and we cited this in our motion regarding intimate relationships and casual associations being insufficient for probable cause, to U.S. v. DeRee, D-E space R-I, that's at 332 U.S. 581. Unless the court has questions regarding that argument, I'll move on to nexus.
You can.
Thank you, Your Honor. When we talk about nexus, the reason that this is important is because we're talking about warrants that, under the affiant's own admission at a previous hearing, give them massive amounts of information, very intimate information. Detective John said that in Ms. Gardner's bond hearing, and he was right. And so it's not, the Constitution does not allow law enforcement to get all of this data that far exceeds anything related to a crime unless they can show that that specific place to be searched has a connection to the very crime for which they claim that there's probable cause. So what does that mean here? We're talking about the iCloud account and premeditated murder. So what is the relationship between the two? And when we look at the affidavit, there is no substantial evidence that a search of Ms. Gardner's phone ending in 4571 or the iCloud account associated with that phone number would produce evidence of premeditated murder. And that phone number is important, Your Honor, and I'll circle back to that in a moment. But the reason that we see that there is no nexus here is because this affidavit, as lengthy as it is, it doesn't even say that Ms. Gardner had an iCloud account. At base, that should mean that there is no nexus and therefore no probable cause and that this warrant can't stand. But even setting that aside for a moment, the only allegation regarding Ms. Gardner and an iCloud account where the police actually say, we know that Ms. Gardner has an Apple product, is about an iWatch, or an Apple Watch, excuse me, Your Honor. And in fact, that Apple Watch isn't even associated with the phone number for which they requested this warrant, the number ending in 4571. And there are no further allegations that connect Ms. Gardner's use of any Apple products to any other allegations that could be connected to a premeditated murder. And we cite cases regarding this in our papers, Your Honor, but just to remind the court, general propositions and allegations based on training and experience cannot bridge the gap between lacking factual allegations and a finding of probable cause. As Ms. Stifler said earlier, the only thing that they can do is provide context for facts that are actually alleged. We don't have those facts here in order to bridge that gap. The case I would cite for that, Your Honor, is U.S. v. Martin, 297 F. 3rd, 1308. That's the 11th Circuit, 2002. The second requirement, Your Honor, relates to particularity. So we believe that these warrants fail to state probable cause. That means that they should be suppressed. But even if the court finds that there is probable cause, they still fail particularity, which is an independent basis for the court to suppress all three warrants. First, I would start with the date restriction issues. These warrants are slightly different in the scope that they seek. However, I do think that United States versus McCall, MCCALL, it's an 11th Circuit case, 84 F. 4th, 1317 from 2023 is important for this court to take a look at. And the reason is we have a very similar warrant in McCall. What we had there and what we have here is a two-step warrant, where the police go to the court, just as they did here, and they seek the entirety of somebody's account, which is exactly what happened here. And the judge signed off on it. And then there's a second step in the warrant, just as there is here, that says, now we're going to comb through this information and we decide what's relevant. In McCall, the 11th Circuit said, well, actually the district court and the 11th Circuit agreed that that was overbroad. That was too much. They assumed, without deciding, that it also lacked probable cause for the very same reason, because it was so broad, there's no way that all of those categories of information could be supported by probable cause. Where I disagree with the 11th Circuit is that they found a good faith exception. I think we're standing in a different posture, especially a couple years after McCall, and there are several Florida cases that I think eviscerate the good faith exception here. But that's important because the 11th Circuit was very clear, and other circuits have been clear as well, that under the Fourth Amendment, when you have a warrant without any date restrictions, that alone warrants suppression. That's what we have here. And the warrants that do have date restrictions, those date restrictions are not tethered to anything meaningful, meaning they're arbitrary. They're not supported by probable cause. They are not particularized to the facts in these affidavits. I would also point the court to United States versus Blake on this same point. It's another 11th Circuit case from 2017, where the 11th Circuit specifically pointed out that when we are talking about these cloud-based accounts, which is what we're discussing here, law enforcement has the ability to target, to limit, both by date and subject matter. That is oftentimes an argument that we hear in these cases, well, we have to take everything because that's just how it comes. And the 11th Circuit said that's not true. They said it in 2017, and they said it again in McCall, and just as it was true then, it is true here today. Law enforcement has the ability to narrow these searches so they are not collecting every piece of somebody's digital life and then allowed to sort through it. That's what we're asking this court to do here. Regarding subject matter restrictions, it's a similar argument, Your Honor. I would point the court to State v. Demons, D-E-M-O-N-S, which is a Broward County case. I believe that Ms. Stifler provided the court with all of the applicable filings. We cited it in our papers. That case is incredibly similar. And the reason that I pointed out specifically to the court is because there were many online accounts in Demons. And the judge specifically found that, number one, law enforcement had the ability to do this limit that we're talking about in step one. So before they get everything from Apple or Google, they could have narrowed, but they didn't. And then, in addition, the failure to limit by relevant times or descriptive terms makes these warrants overbroad, just as it did in Demons. So it's a two-step problem. It could have been done in step one, and then failure to do it in step two with any sort of meaningful guardrails, which is what we have here as well, also is a problem under particularity. The final case that I would point the court to, and I'm happy to hand up a copy because I understand Ms. Stifler had some difficulty finding it, is in re search warrant application received March 13th, 2023. And this is a bit unusual, Your Honor, but this is a magistrate judge from Miami-Dade County who received one of these two-step warrants, again for a cloud-based account, just like we have in this case. And that magistrate judge denied it and decided to write an opinion on this and publish it because he said, to paraphrase, "We see this problem too much. This violates both the Florida and federal constitution. And so I am issuing this opinion as guidance to those who come to the court and seek a search warrant." We have the same issues here, Your Honor. So unless the court has further questions, I'm happy to.
You have a copy of that?
Yes, I do, Your Honor.
Okay, could I have it? Thank you. All right, Ms. Stifler.
The state rely on arguments I made previously in regards to the wiretap, incorporate those into arguments regarding the probable cause as to the affidavits in these search warrants. I will also note for the court, these search warrants are not only focused around the idea that evidence of the homicide itself will be found in these devices. And just for reference, the iCloud does reference the statute numbers for first-degree premeditated murder and child abuse. The Google search warrant does reference these statutes for first-degree premeditated murder and child abuse. And the affidavit and search warrant for the iPhone does reference statutes for murder, conspiracy to commit murder, accessory after the fact, and child abuse. Although there is the charges as outlined are under investigation and the charges eventually charged are not relevant to the court's determination of probable cause. By its essence, a premeditated murder involves discussions prior to the homicide, a conscious intent to effectuate the homicide, and therefore would encompass a larger range of time period for a probable cause search, regardless of what type of evidence, inherently in its nature, particularly when we've outlined there are multiple individuals involved in the planning of the homicide. There's no statute for murder for hire. So that should not be a factor for the court that there was some failure of articulation of probable cause or a finding by the magistrate for a murder for hire. That is not a Florida statute. It's sufficiently enveloped in the premeditated murder statute and the probable cause outline as to multiple individuals, principal theory, and conspiracy, as stated in the iPhone. I am going to talk about the particularity requirements for digital evidence. I do have a witness to take testimony before the court. At the end of Ms. Nelson's motion, she brought up a Franks violation that the affiant did not include a paragraph, I guess rather a Johnson, it's an omission, that the affiant did not include a paragraph in any of these warrants or affidavits stating that Google and Apple have the ability to, what I'm called, selectively characterize evidence either by subject matter or time frame.
Did you let counsel know that you had a witness? I wouldn't have.
Yes, I let
Okay. And that's how you're wanting to proceed? I didn't want.
I can either argue first or take testimony from the witness first.
What do y'all prefer?
We'll take testimony. He's a CFIU detective. The state's not offering him as an opinion witness in any way. He's here merely to give context and define some of the terms in the affidavit and discuss Google and Apple policy in general as it relates to the Frank's allegation of selective categorization.
Okay, is he already here?
Yes, ma'am. Detective J.S. Padilla.
So we've been going for about an hour. I'll take his testimony and then I'll take like a 5-minute break, okay? Good afternoon.
Detective, you solemnly swear or affirm the testimony you give to be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Great. You may proceed.
Good afternoon, Detective. Could you please state your name for the record?
Detective James Padilla, Padilla.
Hold on just a moment. We were testing. You can get the body mic. We're trying something new. You can, we turn that microphone off, if you'll push that back.
I'm a digital forensic examiner in the computer investigations unit.
And Detective Padilla, are you also a member of the United States Secret Service cross-sworn agent?
Yeah, I'm a task force officer assigned to the Secret Service.
And briefly before we begin, although I'm not offering you as an expert, would you mind giving the court a brief outline of your background in terms of your education and training and experience as it relates to computer and device forensics?
Yes, I have a master's in science for digital forensics out of the University of Central Florida. I have certifications in both mobile and computer forensics from the International Association of Computer Investigative Specialists, or IASIS for short. I have certifications from Cellebrite in both their products and some of their Cellebrite mobile forensics. I have trainings for both mobile and a variety of other disciplines from the National Computer Forensic Institute by the Secret Service, as well as a variety of trainings for both mobile computers and other digital forensics needs from the Federal Law Enforcement Training Center out of Brunswick.
And how long have you been with the computer forensic unit at the Jacksonville Sheriff's Office and/or Secret Service?
Since November 2016 for digital forensics, and I've been, I think, 2018 for Secret Service.
And in your career, have you had the opportunity to perform forensic extractions of digital devices, including iPhones?
Yes, I've done over 1,200 exams on cell phones.
And in your career, have you had the opportunity to receive, either seek through a warrant or consent and receive and review returns from third-party providers for digital evidence, including Apple?
I have.
And Google?
Yes.
I want to talk to you today. First of all, you've had some involvement in this case testified before this court before in regards to some hash values of digital evidence, but you yourself are not an investigator in this case, correct?
Correct.
So you have nothing to offer today in terms of any factual allegations regarding this case?
Not at this time.
Okay. What I want to ask you about is something defense counsel wrote in their motion regarding the ability to do what's called selective categorization or partial extractions of digital data. You know what I'm referring to?
I do.
Have you had an opportunity to review Ms. Nelson's motion?
I have.
And have you had an opportunity to review the 3 search warrants at issue in this case for an Apple iPhone, a Google return, and an iCloud?
I have not reviewed the warrants.
Would it be helpful to you to have copies of them as you testify today? I'm going to ask you to define some terms.
Yes.
May I approach?
Yes. Did you show, okay.
And these were attachments by defense counsel to their motion. Detective Padilla, can you describe very briefly for the court the policies and procedures of JSO in terms of receiving digital evidence from an iPhone?
Yeah, so the workflow is a detective will seize an item, bring it to our office. They will put in a request for examination along with any legal justification, either a search warrant, written consent, or implied consent are the only three that we accept. In the case of a search warrant, we'll review it for legal justification to see if there's any scope limitations. We'll validate that the device is listed as the device that we received, and from there we will continue with a method of extraction based on those information.
When you receive a phone that you're doing an extraction of pursuant to a search warrant, you also receive a copy of the search warrant.
That is correct.
And do you generally review the contents of the search warrant to see that it looks sound and based on your training and experience to conduct the search or extraction of a device?
Objection, relevance. He said that he didn't review the search warrants in this case. He can't speak generally to what the practice is.
What's the relevance of that?
Well, I'm asking him about how it.
What JSO does, what difference does that make?
I can move on.
Okay.
When you perform an extraction of a phone or a device, can you explain to the court the types of extractions you can perform?
Yeah, the highest level is a physical extraction. This is a bit-for-bit copy of the memory space of the device. Below that would be a full file system extraction, which is the closest thing we can get to a file system. It's basically copying the entire contents of the phone over to another device. A lesser file system extraction would be the next level down, and it's not quite as comprehensive, but it's essentially the same thing. Below that would be a logical extraction, which is where we would be the first opportunity for us to do any kind of selective categorizations. This is basically an API call or an application programming interface, and it is basically tells the phone, hey, I'd like to see the messages, please provide me the messages, and it responds to that way. And below that would be a manual examination.
And what does a manual examination entail?
Visually looking through the device.
Are the ability to extract different levels, does that depend on the age of the phone, the presence of whether or not you have a password?
Yes and no. A lot of it has to do with that, but also it's the type of device, the operating system version that's running, and the capability and research that the software that we use, its capabilities.
When you receive a search warrant to do a cell phone extraction, unless otherwise specified, do you attempt to extract at the highest level, meaning a physical extraction?
Yes.
And in your experience, do you have the ability in the extraction process itself to put temporal or subject matter restrictions on the data as you're extracting it?
Limited, yes.
Based on your experience with the computer forensics unit, is it practical to do a partial download if you have the ability to do a full physical extraction?
It is not.
Objection, relevance. The question is not what's practical. The question is whether there was an omission to the ability to do that partial extraction.
Ms. Stifler.
Governor, they've made an allegation that if the magistrate had known that there's the ability to do subject matter categorization of these devices and clouds, that the magistrate would have therefore not allowed the warrant to proceed. Therefore, the court, I want to have an understanding of the practical and real-world application of doing these searches, because the analysis by the court, as the courts have said, should be a realistic and common sense approach to how these searches are conducted by officers in the field.
If I may briefly respond, Your Honor.
Yes.
So I want us to take a step back. What we said was that there was a Franks violation as to the iCloud warrant. What the officer, or the detective, excuse me, is testifying to is the ability to physically extract an iPhone. These are two different things. I haven't heard anything about the officer's ability to extract an iCloud account, which then perhaps there would be some relevance to this testimony.
Maybe I'm misunderstanding both of you. Okay, so I understood the defense to say that the information of the warrant should have been suppressed because it was overbroad in and of itself, and that this should be curtailing from the warrant stage on. Am I understanding that correct?
That's correct, Your Honor.
And then this. And then what I'm hearing the state to say is that even on the front end at a global download sense, that there is the mechanism to then curtail it at the, I guess, the investigative level, even though that there might have been more information given by the magistrate.
I'm asking the witness if that's true. They have to establish that what they're saying is an omission is true. I say, is there the ability to do this? He says yes, with limitations. It's unfair that he's not allowed to then discuss the practical limitations of what they're suggesting should have been done in this case. If we're talking about an overbreadth of search, too many categories, should not have done a full phone download. I want the witness to give context to
A cloud at this point.
I'm going to ask them about the cloud as well. They made the overbreadth argument as to all three, the cloud, the Google return, and the iPhone, saying there should have been subject matter restrictions and date limitations on all three. Your Honor.
I thought it was from the warrant state. I don't know.
Allow me to clarify what our argument is. So we have a suppression argument that I agree with the court's characterization earlier. We also have a separate argument as to what we believe was a material omission from the warrant affidavit in support of the iCloud. And so my objection here is that the detective is testifying about the ability to extract a device that we're not saying there was a material omission about. So I'm
all right. So I'll sustain the objection if you'll move. If that's your purpose, then move to what they're saying the omission is.
They also said that we should have put a time scope limitation on the iPhone because the affidavit says they're seeking communications between parties. I intend to ask this witness about where communications are found in phones and whether you are able to use a time restriction and uncover communications in a phone. I think that directly rebuts or allows the state to have testimony rather than just argument as to the practicality of what they're suggesting and why it's not overbroad. Why does the state seek a larger breadth of time and categories in a phone download than they would otherwise if they're looking for communications? The witness can advise the court where communications are stored in a phone. So the state then can argue why it was proper we sought all these categories and without a time restriction.
Give me a second.
The defense has cited the Damon's case. This is the analysis the trial court took in that case as well.
Appears. So I went back and read it. So where I think the argument about Damon's appears to be on your page 11 in your papers, okay? I was understanding that to mean when the limited search was the request to the search. Am I misunderstanding that? Like that the detective could have requested a certain time frame and limited from the magistrate's perspective what was authorized to be given from whatever provider. I didn't understand that to mean on an investigative level that somehow that could be parsed out after there is, if I'm hearing the defense, an overbreadth of the warrant. Am I misunderstanding that? I think what the state is asking is on an investigative level, they could have gotten everything, and then on a searching level, they could have said, no, we're not going to look at this, or we're not going to produce this. Am I misunderstanding that? Because he said, we get the warrant at JSO, which I sustain the objection, but we get the warrant from JSO, I look at the warrant, I make sure it's the same device or whatever was authorized by the court, then I can do these different levels of extraction. That's on an investigative level, and I thought the defense was complaining on a broader search warrant level.
It all relates. Their argument is fourfold. We don't have PC.
Where is that argument? That's what I'm...
The argument is they're citing the Damon's case, and they're citing specific rulings by the trial court, not the appellate court that reviewed it, which ultimately denied the motion to suppress and upheld the trial court's ruling that limited to a time or date certain digital evidence. There was 13 search warrant in Damon's, however you want to say it.
Okay.
They provided the ones that issued to the court.
Okay.
One of them involved the search of a cell phone, as in here, and they're citing it for the proposition that the warrant in Damon's for an iPhone had a time restriction on it. They are saying that our warrant was overbroad because it did not have a time or a category restriction on an iPhone.
Okay.
The warrant is the subject matter being sought, the evidence being sought per the warrant in the affidavit is communications. In order for the state to argue to the court why it's not overbroad, that we didn't have a time limit, we didn't have category devices, it's proper for me to ask a detective with CFIU who has experience where communications are stored in a phone. If communications are stored only in native messages, then they have an argument we should have only sought native messages. However, that's not how phones work. That's not how criminals hide criminal activity. That's not how communications work nowadays. Instead of me arguing this, the state wants to present the evidence of a detective. And part of their argument is we're not entitled to the good faith exception here because no reasonable officer executing a search would have relied upon this warrant. So the fact that Detective Padilla spends all day, every day, relying on warrants such as these to perform the searches, which is the extraction, I think his testimony is relevant to the court's consideration as to the breadth of the affiant's search warrant, the return from the phone. They're asking, although they haven't specified specific evidence from a phone, they're asking to suppress the entirety of a phone.
The objection. All right, so I went back to what the question was and what the objection was, which the question was, based on your experience with computer forensic unit, is it practical to do a partial download if you have the ability to do a full physical extraction? Answer, it is not. Then the objection came to the relevance of this to this particular motion. All right, and then so you're saying that he needs to be able to explain what is practical if they have the ability to have everything. Like what does that have to do with my decision? What's practical in his view, in his opinion, that you said you weren't offering?
Practical is a starting word for further questioning as to why isn't it practical? Because you're not going to get the full data and you're going to miss databases with communications in them. I can ask it more directly, but I'm trying to lay a record for the court, a factual record from a witness who has knowledge as to the context of these devices, how data is stored, where it's stored, so that the state can make a proper argument why these items shouldn't be suppressed and why it's not overbroad to look into all these areas for the evidence that we are seeking. Give the court insight and context as to, if you have a house, you're looking for a gun in a drawer, that's one thing, but if you're looking for a communication in a cell phone, it could be maintained in a variety of places. This witness is here to give the court context as to the manner of places it could be stored and whether or not it has metadata if it's been deleted or stored in another manner.
Okay.
That goes directly to their argument, unless they're abandoning it and only want to proceed on the iCloud, that the phone search was overbroad as to time and date and subject matter.
All right, Ms. Nelson, so before I rule, I want to make sure, you can lay whatever record that you want. This is a hearing, so I'm not being so strict about it, but I don't want to waste time with information that you don't believe that you're arguing, so.
Sure, Your Honor. Perhaps it would be helpful if I clarify.
Okay.
So,
am I on the right page of what you're saying? It's like 9 through 11 is where I'm finding what you're objecting to, and the state's saying you're doing more. So is it someplace else that I'm not seeing?
no, Your Honor. So my objection is that we started this hearing, the court allowed the defense to orally argue its motion. Then the state started arguing regarding suppression. At the end of its suppression argument, then Ms. Stifler raised that we made a Frank's argument, which is separate and apart from a suppression argument under the Fourth Amendment. They're related, but they are separate. This was after I'd already made my argument regarding suppression, and now we're taking evidence after I've made my argument that goes to suppression and not to Frank's. So,
I asked y'all if y'all wanted to do this.
right, and it sounds like Ms. Stifler does want to present evidence. I would just ask that to the extent that there's additional testimony from this witness that is relevant to our suppression argument, that we be permitted to respond, since I've already made my
I have
argument.
absolutely no problem with that. They filed one motion for 3 devices and 2 issues. It didn't break it up in that order because the state's position is that all of this is one analysis. Or at the end, there is a Frank's assertion that I don't think they've met, but I do think the detective has relevant contextual background information in regards to these devices. The court is adept at digital evidence, but there are some courts that are not. Appellate courts might not be. The state wants to lay a proper record explaining what these things are.
Okay, I don't see any harm in it. Go ahead. I'll overrule it. Go ahead.
I'll be more targeted in my question.
Okay, if that's your purpose, ask it, okay? Ask it.
Padilla, can you explain to the court how communications are stored in an iPhone?
Depends on the type of communications, but it could be in the underlying application for the app, say simple messages. Might be a native application, it could be a third-party application, it could be a variety of applications you wouldn't consider.
In your training and experience in executing search warrants with the Jacksonville Sheriff's Office CFIU department, have you analyzed data in which you have found what would be termed communications between individuals in a manner other than native messaging?
Absolutely.
Can you give the court some examples?
Screenshots of text messages. I've seen them in gaming applications. I've seen them in regards to digital cell phones. What I wouldn't call communications, but I would call evidence of communication would be in underlying other databases like the intents and the knowledge C databases and the biome data structures. They show records of communications, but not necessarily the content of those communications. And those are things you wouldn't get through the logical extractions or select categorizations.
Did you say biome?
Biome, yes ma'am.
Okay.
B-I-O-M-E.
Thank you.
Somebody deletes text messages or other term communications, or even files, photos, voice memos, voice messages. Is there a way to potentially recover deleted data in a cell phone extraction?
Yeah, the vast majority of cell phones are predicated on a SQLite database, which is a data structure, kind of like a spreadsheet that are interlinked with each other, so you can do different queries on that. When you delete something in a database, it's not deleted, it's marked for deletion, and at some point those databases could be vacuumed out and then cleared. So those deletions would be maintained in those databases until other processes created the actual deletions.
If you're able to recover deleted data in a database, does it always have metadata?
Not always.
Can you explain to the court what metadata is?
It's data about data, so basically it's your timestamps and in case of messages, it might be the direction of travel, was it received or was it not received, or was it
From a
sent?
forensic technological standpoint, 2 people could be communicating within a specific time frame. If they delete those communications, they might not have metadata.
Correct.
So if you put a time limitation on a search, you could be missing communications within that time frame because they've been deleted and no longer have metadata.
Yeah, if you strictly say I only want from this date to this date, the system is going to look for those dates, and if there's no dates associated with those artifacts, it will not necessarily pull those.
And when you receive a device like a cell phone or an iPhone and do the initial extraction, is there ability to go back to that device later and do a second extraction?
Yes, you could go back to it later. The problem is the data is in flux, and as I spoke about the databases, cleaning out databases, time creates problems for us, because if you do an extraction on Monday and then do it again on Friday, you're going to have the databases are in different states, and some of that data that we're looking for, the deleted data, may be gone.
Detective, are you aware from your time with the Computer Forensics Unit and other detectives you work with and testifying in court of a defense of, I wasn't holding my phone, it's not my phone, it's a community phone.
Yes.
And as a CFIU detective, have you been asked in cases to testify about what we call indicia of ownership of a phone?
Yes, it's, when we look at the data, you can always look at a text message, and we can say that that messaging app sent a message or received a message, but there's no context as to actually sent the message. Unless you're standing there watching the person do it, you're going to have some kind of attribution, and we would use other artifacts on the device to help prove that.
And not everyone's phone is in their name as a subscriber or their email address as a username in the extraction.
That's correct.
So there is the ability to obtain other evidence surrounding communications in order to determine who is making those communications at a certain time.
Yes, I'd be looking for things like what banking account were they logging into, if they taken pictures of themselves, they do other activities that might indicate who that user might be.
Let's talk about Apple. Apple is a third-party, non-law enforcement corporation, correct?
Correct.
So do they require search warrants for law enforcement to receive content?
They do.
And are the search warrants being used here in Duval County? Generally, I won't say like a template, but for the information that is requested of Apple, are the search warrants here that the Jacksonville Sheriff's Office and other law enforcement agencies use based on the legal requirements of Apple Corporation?
Yeah, Apple creates a legal guide for law enforcement, and a lot of the terminology is taken right from their guide.
And does Apple have the ability to reject a search warrant if it does not comply with their legal requirements?
Yeah, as listed in their guide, they actually have a legal compliance team that will review these warrants, and they will determine if it's, in one of their statements, is if it's overbroad, they will reject, they will object, or they will deny that warrant.
You explained to the court what kind of data an Apple iCloud would encompass.
Generally, the backup of the iPhone, if it was submitted up there, will have records associated to any other device that they may have synced up there. It has messages, potentially, some of the content of devices, and anything else that user has paired with their Apple ID.
Based on your experience, does Apple have the actual ability to limit a return as to content or time restrictions if you were to submit it?
Sustained, you can back up.
Have you submitted and received search warrants and returns from Apple?
I have.
How many would you say in your career?
Too many to count.
And in that time, have you become generally familiar with the types of returns you're receiving from Apple Corporation in response?
Pretty good about complying with what requested, but from my experience, what I've seen is they generally work off their own records, and they will send you whatever is available to them. They don't necessarily always limit to a certain time frame.
And in terms of selective categorization or asking Apple for only specific categories of data, have you, in your experience, seen that done successfully in a return from Apple?
I don't think I've actually limited to that limitation. It's usually give me all the data associated around at most the time frame.
And because an Apple iCloud is a backing up of a phone device, is there also, can you speak to how communications would be stored on an iCloud?
I can't speak to how they store it, but it's basically a server that's connected to that user, and a variety of different ways. One of it is an iTunes backup. You've probably heard that term before. The phone does a backup, and it will update and upload it to the iCloud. Because the iCloud's it's a data storage center is all that is.
The hard drive in the sky.
Yes.
And does Apple categorize people's data for them when they upload it to an iCloud?
Can you establish if he knows?
You reviewed returns from Apple that categorize data.
Yes.
And have you any knowledge, personal or from your experience in reviewing these in general, what types of categories you have found in Apple returns?
Pretty much the same thing you'd find on the phone. Text messages, databases, not databases, data structures such as messaging, pictures, media, everything that would store records about their applications that they've installed, payment records.
What's the basis of his knowledge? I think that was the objection.
Observation of returns he's received, categories he's seen on returns he's received.
From Apple? Are you maintaining the objection? I'll overrule it. You can go ahead. Go ahead. To the base, to the other, I heard all that. So to the other question, which is, does Apple categorize in returns? I guess was a question. I can go back up specifically.
Yes. They do provide it to us in a categorized list, so I'd have to make the assumption that they're categorizing it.
And because it's a backup of a phone, similar to a phone, are communications stored in various data structures or categories other than, for example, text messages?
Yeah, as mentioned before, it's really up to the user of the device how they choose to communicate. If they are using only communication designated devices or applications, they're always going to be there, but it's up to the subject. They could use pictures, they can use any other kind of tool to provide communication, even though it's not designed for communication.
Like third-party applications?
Yes.
So if you have a third-party application that you're using to communicate, like TextNow, WhatsApp, etc., it would not show up in your native messages or text messages on your phone or iCloud.
Yes, those are third-party applications that are designed by other entities other than Apple.
Okay. Turning to Google, have you had the opportunity in your career to submit search warrants, implied consent, or consent to searches to Google and receive returns of digital data?
I have.
And how many times would you say in your career?
Quite a few.
Now, Google provides data in a different format than you would get from a device extraction in iCloud. Is that accurate?
Yes, but similar.
And when you parse data from an iCloud or from a device, you use generally Cellbrite or GrayKey.
Well, Cellbrite is a technology that has an extraction and a decoding and a parser, and GrayKey is more of an extraction process.
When you are creating a UFED reader report, you would parse that through this parsing aspect of Cellbrite in order that it becomes readable as opposed to just ones and zeros.
Yeah, we use Cellbrite Physical Analyzer, and it decodes the data, and then it parses the data.
If you were to take, I'm going to call it raw data from a Google return and parse it through Cellbrite, would it capture everything and categorize it correctly from the raw data to the reader report?
Everything, no, but everything that the program was designed to capture and decode and parse.
To your knowledge, having submitted search warrants to Google, do they also have a law enforcement guide and law enforcement portal?
Yes.
Similar to Apple?
Very similar.
And do they have what they call an independent legal team per their website that reviews warrants produced to them?
They do, and as stated, as Apple does, they review it for a variety of things and will reject it or contest it if necessary.
And like your Apple search warrants, are the search warrants being used by law enforcement agencies here in Duval County in the 4th Judicial Circuit incorporate that language that's required by Google into the affidavit and search warrant?
They do.
Have you ever requested or received a return with a temporal restriction for a Google Drive?
I do believe I have.
And did Google comply with that temporal restriction to the best of your knowledge in the cases where you've received one?
Yes.
To your knowledge, does Google have the ability, based on your experience in the returns that you've received and the warrants you've submitted, to do a selective categorization of data?
Sorry, can you repeat that?
Based on your experience in sending search warrants, implied consent, or consent to search to Google and receiving returns, does Google have the ability to do selective categorization of data?
I would have to assume they do. I don't know their workflow, but I have received limited data in the past.
And for Google Drives, can you advise the judge what types of data you would find? Like iCloud is a backup of a phone and other devices. What is a Google Drive? What does it contain?
It's essentially the same thing as iCloud. It's just a different terminology they use. And you'd find the same things you'd find in an iCloud. It's everything that they have linked to their Google account It's more specific to a Google account than in the Apple infrastructure, but it will contain same things: messages, content of their devices, content of their photos, and backup anything they choose to back up.
And an iCloud or a phone with email application, same with Google, they would contain someone's emails,
Potentially, yes.
their messages,
Yes.
their applications,
Yes.
photos,
Yes.
IP addresses,
Yes.
usernames,
Yes.
bank accounts, credit cards,
All the above.
documents they may have saved,
Yes.
voice memos,
Yeah.
voice notes,
Correct.
notes application,
Yes.
and whatever is backed up or in the hands of these third-party providers is what the user has created, correct?
Yes, on both Android and iOS, there are settings to determine what you choose to back up. So they could self-limit what they back up, and the Google or iCloud would not get that data.
There is some data that Apple and Google captures that the user can't create, like your IP address, for example.
Correct.
If we're talking about content, generally it's content generated by the user, like your text messages, your communications, your photos, the content of those items.
Correct.
So when Google or Apple or a phone are holding that content, it rises to that.
Yes.
And in terms of what we talked about earlier in regards to devices and cell phones, timeline features and other artifacts that indicate the user or the possessor, because they're cloud-based, do they have the ability to hold other data not relevant to a particular individual if that individual has several devices or other people have devices connected to that cloud?
If you're asking, can it have other devices associated to that same count? Yes.
I have a moment, Your Honor.
Yes.
I have no further questions.
Ms. Nelson?
Good afternoon, Detective.
Good afternoon.
Do you want to use this? I don't know. You're okay over there? You can see me over?
I'm okay. Can
Okay,
you hear me
right.
okay? I want to start with iPhones. You and I had talked previously at your deposition regarding different methods of extraction, and Ms. Stifler asked you some questions about it. As I heard you explaining, there is at least a two-step process for iPhones. And what I mean by that is there is the actual extraction of the data. Is that right?
Yes.
And then after you extract the data, meaning take it off the device, that's what extraction means.
Yes.
After you do that, then there's a second step. Is that right?
There is.
And that second step can take a couple different forms, if I understood you correctly at your deposition, so correct me if I'm wrong. I heard you say today you can parse the data, right? As part of
Yeah,
step two.
the tool decodes. Decoding is basically putting it into a human readable format, where parsing is making sense of it.
Thank you. So we have the second step, which is decoding, which the program does for you.
Correct.
Right? And then there's the first, I'll say, kind of human step to understand that data, which is the parsing.
No, the parsing is also automatically done.
Okay, so
Give it to context. If you were to decode a database of messages, it would be just a long string of messages with a variety of different contents. And you'd have to string together this table to make sense of it. When you parse it, it'll show you, like you would see it on a phone, that this message came from this person at this time. But all those elements are not kept in one spot. They're kept in various tables in the database.
perfect.
So the parsing is to bring them all back together.
So once we parse, after that, then we meaning a human, can look at the data and make meaning of it.
Yes, that's when analysis would take place.
So analysis. So when you extract data, you don't necessarily have to parse it, right?
Correct.
And when you parse data, you don't necessarily then have to analyze it, right?
Correct.
So if I extract a cell phone and then I choose to parse it, I could just have that information sit there.
You could.
Right? And I could also then extract, you said multiple times, from the same device,
You could.
right? And then I could take those separate extractions and I could parse both, not parse one. I could do lots of different things with them, right?
If you feel like wasting your time, yes.
Fair enough, based on your time and resources. And then even if I have 2 extractions, I could take one and I could analyze it and limit based on time or subject matter, right?
Yes, but you could do that on either extraction.
Fair enough. Leaving the second extraction completely untouched, right?
Yes.
So that way, if I found information that would lead me to believe that more systems within the phone or a broader time date range would be relevant, I could go back and get that information, right?
You wouldn't necessarily see that if you didn't have the information to look at in the first place.
Right, which is why we have that second extraction, right?
The extraction would be the same as the first, rather than variances in the database structures.
Exactly. I think we're saying the same thing in different ways.
I don't think so.
Okay.
If you extracted here and extracted here, the data is the same. You wouldn't need the second extraction to do what you're saying over here. Over here. They're the same.
We agree. Thank you. So if we're talking about this multi-step process for an iPhone, still want to focus on an iPhone. I believe that you testified that once you extract the data, you have the ability to just look at, for example, a certain category of information.
Yes.
You have the ability to look at just a certain date range, correct?
Yes.
You also have the ability to look at, for example, communications only between number A and phone number B.
Correct.
Right? There are lots of different ways that you can cut this data.
Yes.
And you could still have the ability, like you just said earlier, to go back and look at the whole universe, correct?
Yes.
I just want to be clear, when we're talking about the iPhone in this case, you did not perform any of the steps we just went through on Ms. Gardner's iPhone.
No.
So you cannot give this court any information about whether messages or communications were located in different files in this specific case within the iPhone.
That's correct.
Let's move on to iCloud accounts. You've never worked for Apple, I assume.
I have not.
And you understand that when you receive a return from Apple, that it has different categories of information.
Loosely, it's organized in some fashion, but it is very convoluted and very hard to read in the format they provide. But there are categories, if you will.
So for example, you would typically see for an iCloud return customer information.
Yes.
You would typically see connection logs with IP addresses.
Correct.
You would also typically see something that could take the form of backed up messages, like text messages.
Yes.
You would often see something that would take the form of backed up, I'll say SMS messages to the extent that they aren't in your iMessages. That might be a separate folder, right?
Potentially. A lot of it is buried within the backup files that are associated with those categories as well.
That is a fair point. So we have information that comes from backing up the iCloud that would be returned, right?
Well, not backing up the iCloud, backing up the device.
Backing up the device.
To the iCloud.
You would have that category of information, right?
Yes.
You would also have other information that Apple captures, correct?
Yes.
And that other information might be metadata, data about data, right?
Yes.
It could also be information about logins to the iCloud account.
Potentially.
Right? Location data.
Potentially.
And that would be separate and apart from any sort of iCloud backup, right?
Well, it could be combined in the backup too, because the device itself does record location data, and that would be in the backup potentially as well.
And I think you testified earlier that you are aware that Apple has its own guidelines for law enforcement. Have you reviewed those guidelines?
Yes.
And so you're aware that Apple encourages anybody who submits a subpoena or a search warrant, so whether it's civil or criminal, to be as precise and narrow as possible.
Yes.
So they have the ability to respond without the entire account.
Potentially. I don't work for Apple. I don't know what the capabilities are, but I have seen limited returns in the past.
you've seen limited returns from Apple.
Yes,
Did you author those affidavits?
I did not.
Did you, but you reviewed the search returns?
I have seen several, yes. Not recently. Apple's been a long company with a long history, and sometimes they change things, and they routinely change their databases. I've seen in the past where you've asked for a narrow scope, and you get everything. I've seen in the past where you get narrow scope, and you get some. Again, it's up to Apple what they provide.
And when you saw a narrow scope, was it limited based on time and date?
Yes.
Did you ever see returns that were limited based on subject matter?
I have not.
So the only restrictions you've ever seen are date and time?
Correct.
I have a brief indulgence, Your Honor.
Yes.
Thank you for your patience, Detective. For iCloud returns, when you receive the information from Apple, is it in a human readable format?
Oh, gosh, no.
Okay, say more about that.
It is in a very convoluted, it's an encrypted container that comes originally to us, and it actually has to go out to the iCloud and pull this down from their system and decrypt it. And then it is put into a very convoluted process. And then we take that and load it into our analyzers in order to make it into a readable format.
And once you put the information you get from Apple into your analyzers and get it into a readable format, is it a similar process for what we talked about with the cell phone?
Yeah, it's the same tool and does the same thing. It just utilizes a different input.
And so as part of that process, you could limit the amount of information you look at.
Yes.
And you could still go back to that information later and look at the entire universe. Is that fair? I think we covered this about iPhones, but just to be sure, for iCloud accounts, when we talk about limiting the type of information that you could look at, that could be by date.
Yes.
That could be by people or users.
Yes.
Right? That could be by keywords.
Yes.
That could be by locations, like geotags, for example.
Yes.
That could also be by phone numbers, right? And the same is true for cell phones.
Yes.
Right? Let's talk very briefly about Google accounts. When I talked about the ability to limit what we look at from Google, I want to ask you the same set of questions. When you get returns from Google, are they in a human readable format?
It's better than Apple's, but it's very convoluted as well because they have their own proprietary format. But it is human readable if you can figure out how to parse through their data manually. However, it suffers from the same problem Apple has. It's basically just a data dump. And so you'd have to use some kind of analyzer in order to make sense of it.
And once you do the analyzer, as you just said, and it's in human readable format, are you also able to then parse the data?
Yes, same rules apply.
So it's exactly the same as what we just talked about with the iCloud account?
It is.
And that's exactly the same as what we talked about with the iPhone?
Correct.
I'd like to fast forward a little bit and talk to you about the process for when you receive a warrant. You testified earlier that when you receive a warrant, you look it over before you look at the device to make sure you're in compliance with the warrant. Did I understand that correctly?
Yes.
And once you review the warrant and you go into the device, we can use a cell phone as the example. You're going to review the cell phone. If the warrant says something along the lines of any and all information about who owns this cell phone, are there any standard operating procedures in the department that give guidance to what you can or cannot search?
No, because that's a very subjective term when you say device identifiers. It could be as simple as the device ID, the account information, but you also have to look at the context of the device. What activities was that device being used for? You're going to look at what user accounts to other third-party applications are out there. So you couldn't just say it's just the device identifier you're looking at. It's the breadth of the device is who's using the device, what applications are there. Like take a banking account, for example. Who are the user accounts associated to? So you'd have to look at all the totality of all that kind of stuff to really make a concerted effort to say, this is the user.
So if I understood your testimony earlier, again, using whose device is this as our example, that could mean you're looking at lots of different folders and files. Is that right?
Potentially.
Potentially. Let's name a few if you're trying to identify whose device this is.
Like I said, I'd first start with the ownership of the device. Who's the account holder? It'll have, an email address, and it'll have the phone number and that kind of stuff, the serial number, the IMEI number, the MSN number of the phone. All those are your basic subscriber information. And then on top of that is if I'm trying to attribute that to a particular person, I'm going to be looking at financial records, social media accounts, third-party applications, where are all the user accounts. It's safe to say if every user account's the same email, that it's probably the same person using the phone.
You might look at if they had medical records stored on their phone, right? You might look at if they had copies of driver's licenses stored on their phone, right?
Yes.
So pictures, emails. You would essentially look everywhere that you could find information on the phone. Is that fair?
Potentially.
And I think I heard you answer my question, but I want to make sure that I heard you correctly. Are there standard operating procedures at your department for where you can and cannot search as part of that process?
There is not. There's best practices that we adhere to, but there's not a standard operating procedure. Every device is different. Every case is different.
And so if a forensic examiner is reviewing, again, we'll take our cell phone, there aren't any specific guidelines for what he or she should or shouldn't look at as part of that process.
No, but you got to understand the vast majority of the stuff that we look at, we're extracting the data, putting it into a reader format for an investigator who's linked to the case to review. I don't know the facts of the case, so a phone number may be relevant. I wouldn't know it. So I'm not looking at the data. I'm passing it off to the investigator to look through the data.
And does the investigator have any standard operating procedures to follow if you know?
I do not know.
You don't know?
No, I don't think there's anything in writing. It's based on the case. If you're looking to determine ownership, you're going to look one way at your leads. If you're looking at, pictures of drugs, you're primarily looking at photographs. I mean, it's going to be case specific. So there's not really a standard operating procedure. It's more case driven.
Mr. Carodi reminded me that I forgot to ask you some questions about the analysis piece of an iCloud account, a Google account, or a cell phone. To the extent that your answer is different based on the device, please let me know and I'm happy to ask the question differently, okay? So once we get the information into human readable format, we talked about your ability to then focus in on certain categories of information, right?
Yeah, the whoever's looking at the data has the ability to filter down to whatever they feel like filtering to.
And as part of that, can I call it the filtering process? As part of the filtering process, that could take anywhere from a couple seconds to a couple minutes, right?
Take longer depending on the amount of data that's in there, yeah.
Sure. A typical cell phone, it's not going to take weeks.
For the filtering or for the processing?
For the filtering.
It should depend, depends on how much you're filtering. If you're only wanting to see a particular phone number and you filter it, it takes seconds. But if you're wanting to filter on 80 different things, it may take you multiple steps of filtering to get to where you're going, and that could take weeks of looking through that data.
For the computer program just to run the filter, let me be more precise. Approximately how long would that take on an average cell phone?
It's almost immediate. It goes through and looks through the data. However, most of the filtering is either a single filter across the entire data set or through a certain artifact, say a messaging app. If you just want to look through the messaging app and you want to say, give me all these phone numbers, it'll show you just that application. But if you wanted to look for that phone number across the entire device, then that would be a different search. You're not really saying this phone number and it's usually one or the other.
No further questions. Thank you, Detective. Briefly.
Okay.
This is just a couple questions in response to what Ms. Nelson asked you. If you were to limit a search by filtration, however, through Apple, iCloud, Google Drive, or a phone, or so only specific keywords, that presumes that those keywords are legitimate.
It presumes that those keywords are actually in the device and or valid to the case. Yes.
So if I ask you, Detective Padilla, will you search this phone for the word murder? That's presuming that the people talking about murder use the word murder as opposed to a code word.
Yeah, it wouldn't use any kind of aliases for the word murder.
Or if we're talking about specific communications between two phone numbers, that's presuming that they're communicating with someone who's using a phone registered to them or a known phone number.
Or using the native phone app. If you're using another third-party application, there might be a different phone number associated.
So if you're using Snapchat to communicate or social media or WhatsApp or any third-party provider or gaming application, it might not come up if you search with a particular phone number.
It more likely would not come up.
And if you were looking for communications between individuals based on their names, that would presume that the person using the device has stored that person's name as their, what we call in this line of work, government name, correct?
Correct.
Okay. There are ways, in your experience, people use devices to communicate in non-traditional, non-obvious manners. Is that fair to say?
Absolutely.
Thank you, Your Honor. No further questions.
I have a couple. Give me a second. I just want to make sure I'm understanding your testimony. Okay. I think where I got a little confused was, so there were questions about your experience with iCloud accounts and then the return back. I think I heard two different things. So you have experience where there have been limits on the warrant and Apple has sent back curtailed data, you said that's hard to read. So you have had that experience. So if it is sent out in a limited fashion from the issuing court, you have gotten returns back from iCloud. Because I heard you say Google, but I heard, I think, two different things, and I just want to make sure what your true answer is.
It's hard to tell what they limit because they don't come back with a, here's what we gave you. It's basically a data dump. But you can kind of look at the date ranges and go, okay, well, these only start here. So it had to have been limited, is what I think I'm trying to convey. They don't say, we only gave you the text messages from this time frame. They basically send you a copy of the warrant that comes with it, as well as some delineation in there. But there's really not a lot of, this is what we limited it to.
So how are you deducing that fact? So you're saying that you get the information, then you look at the warrant, and then you look at, once you extract it, you have those two time frames, and you say, oh, they must have limited based on the warrant.
Right.
That's how you're deducing that information.
Absolutely.
Okay, and then I also heard you say that you have, I guess, reviewed the warrant. It's asked for a narrow or precise time frame, and then it says, I have the experience to where the warrant says something narrow, but you get everything.
Yes. That has happened.
Okay.
To clarify a little bit, though, if our warrant is specific to a time frame and we get more back from them, it is my responsibility to limit the report back to the investigator, because as I mentioned, I don't examine them. for the most part. We might interpret data for the investigators, but we're not looking for evidence because I don't know anything about the case. But if the warrant says this date to this date, when I
And you get everything.
report, I'll get everything from the extraction or everything iCloud gives me. I will limit the date range to only the artifacts that contain that date range or anything that does not have a date associated to it, and that would be presented to the investigator. So they would not get anything that would be outside of that scope.
And so I think that's where I might have stopped you. So that's what you're saying. You look at the warrant, you look at what the extraction is, and then you only provide what the warrant gives you authority to provide to the detective,
That's correct.
even if you get everything.
Exactly. Because we represent the data, not the investigation.
When Ms. Nelson was asking you questions about the multiple steps, so I only got to 2. So it's extraction, and then there are 2 automatic things that occur. I just want to make sure I'm understanding you. There's decoding and there's also parsing.
Yeah, and
Is there another step?
analysis, but that's
Analysis.
That's the investigator's role. There's also interpreting of the data that would come back to our unit if the detective says, hey, I want to present this piece of evidence. Can you help me make context to where it came from, how it got on this device? And we would offer our services to help interpret that data.
Okay. That's all I had. Are there any questions based on mine? Okay, thank you. All right, let's take 10 minutes. Okay, court's in recess.
In Google, and in this case, State versus Gardner, the iCloud and Google search warrants at issue here do involve a temporal limitation. There is a beginning date, there is an end date, and by the returns, it appears that the search was conducted within those guideposts. I want to talk a little bit about some of the analysis in the call, and I provided, Your Honor, a binder of case law that I'm relying upon, as well as filings in State v. Damon's case, and a case here in the Fourth Judicial Circuit at State v. that have taken this issue of how modern courts interpret the Fourth Amendment when it comes to digital data because of the nature of devices and phones and iCloud and Google returns, and the types, an enormous breadth of data information that is captured in these that distinguish them from what we consider traditional Fourth Amendment analysis of the search for tangible property in a fixed place, search of a home, search of a car. But in the call, the court gives a lot of analysis and insight into this, that courts themselves struggle with how probable cause and particularity apply to information that law enforcement collects from a cloud account. And note that it would be unsurprising that the police officer would struggle as well. And ultimately, I will end, or begin with the end, which is no matter what the court thinks about the Fourth Amendment and cloud data and temporal restrictions and selective categorization, ultimately, all of these cases, all of these courts, and Your Honor, should land in the same place, which is that these warrants are sufficiently articulated. Like the wiretap application, there is an extensive discussion of the objective facts of this case. There are facts in these warrants not only about their participation in a premeditated murder, a child abuse, a conspiracy, but also an articulation that these individuals
based on what the applicant knew at the time seeking these warrants, were using alternative means of communication to speak to one another about the death of Jared Bridegan, the possibility of financial transactions, arrests of individuals. There are articulable and specific facts outlined in here that several of these individuals, Ms. Gardner, Ms. Jensen, perhaps Mr. Biggerstaff, Mr. Fernandez, Saldana, are talking on wire intercepts about their phones being tapped, about using FaceTime, about looking for other ways to use other phones to communicate, about going to a neighbor's house to use their phone to communicate. So in seeking communications, the reason I had to testify is to give this court an idea that people who commit crimes don't use text messaging, their native messaging to text their co-conspirators from their own phone number, in their own name, to their own name, saying things like, hey, want to go commit that murder today? That defies common sense, it defies logic. The reason the state seeks and should be allowed to look for information in places other than the selective categories that defense would like us to is because people tend to hide evidence of wrongdoing. They tend to delete it. They tend to circumvent traditional methods of investigators finding communications. A phone and a Google return and an iCloud are based upon what the user makes, how the user defines someone on their phone, how they tag them, how they name them, which applications they use, what they delete, what they keep, what they screenshot, what they send, what they record on a voice memo and send. So it's not unreasonable, given the government's compelling interest in investigating homicides, that an investigator be able to look in places other than native messages for keyword searches for murder between two known phone numbers. The same way that if Your Honor were to give a search warrant to a house to go look for a letter about a murder, detectives can look through every piece of paper and every filing cabinet in a house, regardless of whether it's in a drawer that says kindergarten report card or medical records or tax documents. And some of the cases I've cited for Your Honor is because we, the state, and investigators should not rely on the defendant's own categorization of their evidence of wrongdoing. We should not be stuck. We should not be handcuffed because they have taken steps to delete or hide or circumvent traditional investigative means or use other ways to communicate that are surreptitious. The affidavits in this case, Your Honor has to do a case-specific analysis. The affidavits in this case clearly establish probable cause that these people are involved in a premeditated murder for hire that would necessarily involve relationships between parties, long-standing relationships, communications over time, and there is evidence that the applicant relates to the magistrate that they're taking steps to hide their communications and use other mechanisms of communicating. The limit that the detective put in the affidavit is objectively reasonable, and it's reasonable, and this court can defer to the magistrate's determination that it was reasonable. Based on the fact that you're talking about in this case, not in any other case, not in a case like we have cited here where we're talking about a prostitution ring or a spur of the moment robbery. We're talking about relationships between individuals, motives that span years and months between what they want us to consider as innocent relationships. Well, those have historical significance, which gives detectives reasonable grounds to look into that. If Ms. Gardner, as it states in the application for these warrants, is saying on a wiretap that she has previously met Henry Tenon in time when he's being announced as the killer of her ex-husband, then certainly it's reasonable police would want to go back further than the day before this murder to see, in fact, if there is an historical relationship or communication or connection between Ms. Gardner and Mr. Tenon. And sometimes the absence of data is indicative of guilt as well. If they go back in time and see there are no communications that have an instant explanation between these individuals, or there are no similar messages between people not connected to this plan that defeat an instant explanation for some of the communications they're having or not having, or communications that we see or don't see. And recall, that is exactly what the court says. The court talks about then two types of narrowing you can do on a warrant, and recall it by its is stated in the opinion, says it expands the analysis of Blake, which is cited in the defense motion. Blake comes in 2017, McCall is 2023, years later, as our technology is developing and how we investigate cases is developing. They talk about how, in this case, an individual was participating in a game of poker. He felt that he was losing. He called up some individuals to come commit an armed robbery with the individuals he's playing with. And the court contemplates that even though it seemed to be a spur-of-the-moment crime, it makes sense that they would request a larger time frame for a cloud return because there's a pre-existing relationship between this individual and the people he called who came in and committed an armed robbery at his beck and call. They said it was reasonable to look into some co-conspirators or co-defendants' pre-existing relationship to establish his knowledge, participation in this robbery. It is not reasonable to believe such a relationship will be reflected in the data stored in iCloud. So McCall, to me, is the one that the court should look at the most. It's one of the most recent cases. It is specific to a cloud account. It talks about a fact-specific analysis that even in a case like this where they know that the communications between them that day are not going to be on the cloud because of the way it was backed up in this case, that because of those relationships, it makes sense to go back to the court. It also talks about how a subject matter or categorization limitation makes very little sense. And I understand the defense point that this is a broad search warrant and we've gotten all data, but I will tell the court, the state of Florida is not saying that they're holding an arrest warrant affidavit and arrest warrant that says the entirety of iCloud is property being sought. There are specific categories outlined in each of these warrants. Do they cover the majority and bulk of the data that will be contained in these devices or clouds? Yes, but they are specifically delineating. This is not a mere fishing expedition, and what they're looking for is communications, and they are specifically discussing categories of data that would include communications. They specifically say, we're talking about the iPhone warrant, number 10, communications between parties relevant to the offenses. Concerning payments relevant to the offenses, related to the offenses. They're specifying as best they can, but as the McCall court understandably realizes and outlines, is that in today's world, culling digital evidence is nearly impossible when you're talking about subject matter because of the way people store data and the way people communicate. In United States versus Blake, the case cited by defense in their motion, that court says that they're talking about social media, Facebook warrant, that it's not open and shut whether this was overly broad. And then they find that, if it's not open and shut for these courts and we're doing a case-specific analysis and intelligent magistrates and intelligent appellate courts can disagree, then it's unfair to dock the officer for relying on a judicially approved warrant on these issues. The whole analysis for probable cause, it's not a hyper-technical consideration, it's not a legal technician, it's a real consideration. A real person reading this warrant and conducting research based on it would not think these are facially deficient because magistrates themselves can't always agree. But it is worth noting as well, Damon's is cited by defense. In Blake, McCall, and Damon's, the warrants before the court are very different than the ones that are now in front of me in this Gardner's case. And I've provided the remainder of the filings. Ms. Nelson cited a portion of the trial court order in Damon's. I have provided the actual trial filings from that case, including the suppression motion number 1, which is to a phone, and suppression motion number 3, which is to an iCloud. Those include the warrants that issue in that case. And when Your Honor reads those warrants, you'll see a vast difference in how thorough and in-depth those ones were compared to the ones we have here. I mean, in most of these cases, the court, from McCall, they didn't put any kind of restriction on the iCloud. They didn't put a date restriction. They didn't put a content restriction. They asked for the entirety of the iCloud. And the court said that was still proper. They received 2.5 months just based on when it was created. They said that was still proper given the coexisting relationships. But here, the state did act in good faith. The officer did put a temporal limitation in those warrants. He even put a paragraph in, I know Ms. Nelson called it the attempt to save a deficient warrant in her motion, that your applicant understands this is a longer time period than would normally be requested for digital data. However, based on the nature of this case and what it directly based on the nature of this case and the presence of the co-defendant, the fact that we allege this to be a murder for hire, that the applicant expects that there will be relevant information in a longer time frame, just based on the circumstances of this case, the number of participants, and the evidence these people are communicating over time before and after the homicide, and talking about communicating in ways to avoid law enforcement detection. She cites forward information. Again, that court there held that if a failure to limit it in any material way, with no dates, rendered it overbroad. Here we've limited our dates. In Irving, which is cited by defense on page 12, the search warrant went back to the inception of the account and had no limits for dates. Here we have limits for dates. So their cases are distinct. Here, the applicant has done exactly what McCall and Blake have required, which is trying to make some kind of meaningful limitation while still getting the evidence which they're seeking that they would be entitled to given the facts and circumstances. I cited United States versus Brooks, 427 Federal 3rd, 1246. That's a 10th Circuit Court of Appeals. It's talking about, in this case, that digital searching is as much an art as a science. And that's the purpose of Detective Padilla, again, that we're not looking through financial documents where you can control F on a PDF and find what you're looking for by keyword search. We're talking about sophisticated individuals who are using code words, using applications, hiding their communications. So by nature, where we're looking is going to be broader. U.S. v. Burgess, 576 Federal 3rd, 1078, 10th Circuit, talking about sometimes because electronic files can be labeled, relabeled, that we have to look at all files sometimes to find the ones we are seeking. U.S. v. Farlow, 681 Federal 3rd, 15. That is a First Circuit Court of Appeals case which discusses that computer files can easily be renamed, file extensions can be changed, and therefore sometimes the investigator or the searcher has to look in more places than one to find what they're looking for. And this is really to look for what the communications at issue. The identity of the individual making a statement, the identity of the declarant, is always going to be relevant to an investigation. I have been on homicides, I know this court has done on trials where people bring forth defenses of that may be my phone, I wasn't holding it, you can't prove that's my phone, somebody else was using it at the time of this homicide, phones where people's names aren't the subscriber name. Times where individuals come up with a defense of it's a community phone, it's being passed around, somebody else is holding it. So indicia of usership and ownership and possession at the time those communications are being made is always going to be relevant. How else is the state of Florida going to get a statement into evidence of a party opponent without establishing that the party opponent was using the device at the time of the statement? I also provided the court with some cases regarding that type of analysis. State v. Arnago, 973rd, the 3rd DC of Florida. That case actually involves a physical search where officers were trying to determine in a grow house for marijuana the individuals inside who was responsible, who they were going to charge, and they collected cigarette butts, beer bottles, and fingerprints which were located in close proximity to marijuana plants. And the court there found that evidence to ascertain identity is reasonably within the scope of a search warrant, even if not specifically outlined. So even if we're not specifically outlining some of these things in the warrant, which they are for the most part generally outlined, any indicia of ownership is always going to be relevant, is always going to be reasonably contained within evidence that this person is making these statements. If we're asking for communications between Ms. Gardner and her co-conspirators, we have to prove the communications are between Ms. Gardner and her co-conspirators. U.S. v. Bass, 785 Federal 3rd, 1043, it also discusses indicia of ownership that the police can seize more when it's unclear what format evidence will be in. Again, if we're looking for communications, we're not limited to native messages. Communications can be in multiple different types of formats. United States v. Salaman, 742 Federal Sub 3rd, 221. That's the United States District Court of Connecticut. They discussed that law enforcement has a strong interest in determining who owns a phone or is using a phone and linking evidence to a particular individual. And this all cuts exactly to the argument they're making, which is establishing a nexus between the individual and the evidence being sought. U.S. v. Richards, 659 Federal 3rd 527, the U.S. Sixth Circuit Court of Appeals, that detectives doing a digital search would not know the format of a server at the time of the search, so they looked at multiple different servers, and they found that was not local fraud. So the case law is clear that a reasonable limitation is sufficient. They favor a temporal limitation because all this case law recognizes that there are multiple ways you can store digital information. If you're searching for a gun, there's only so many places you can find it. If you're searching for digital evidence that's not tangible, it can be anywhere. Therefore, you have to look more places to find it. As long as you're doing so in good faith upon a validly articulated and judicially approved search warrant, and the courts overwhelmingly have said that suppression is not the remedy. So in Demons, I would love for the court to look at these suppression motions with the attached warrants and see that they are much less detailed, much less specific, much less articulated than the warrants you have before you. And in that case, the court imposed some limitations because none were imposed and severed parts of the warrant, and the appellate court upheld it. Same with McCall, same with Blake. So those appellate courts allow the evidence to be used at trial with warrants that are far less detailed and sufficient than the warrants Your Honor has in front of you today. Lastly, I understand, although not controlling, Ms. Nelson gave you a magistrate's order from Broward County. I have provided a motion to reconsider an order on reconsideration of a circuit court decision here in the 4th Judicial Circuit, State of Florida versus Henry Landon. It discusses Meta, which would be a Facebook return, and similar issues where the defense was attacking the warrant as overbroad and not particular. That one did include a time limitation, and the presiding judge in that case.
You put it in these materials. I haven't looked through this binder.
Yes, sir. Everything that I'm referencing is in the binder and has been provided to defense.
I haven't had a chance to look at that.
That was in Division CRH, and on November 2nd, 2023, the order denying Judge Brandon wrote, asking to look through all data for evidence relevant, in that case to a kidnapping and assault, is not any different than looking through an entire file cabinet that contains all sorts of business files to find evidence that pertains to a distinct financial crime. The state was not required to ask Meta for discrete pieces of data or specific records. Tying the request to a specific account and date range where applicable is enough. On his motion for reconsideration and order denying for reconsideration, the judge also found that the police relied in good faith on the warrant issued, and that noted that the police did not skip the subject matter limitation in the warrant out of some nefarious plot to get more information than the law entitled them to do. Instead, they did what they always do. Use the basic form for these kinds of warrants. There's no misconduct on the part of the police here to deter. They acted in good faith, applying for the warrant according to standard procedures, including those imposed by Meta itself, and received and reviewed the responsive information in good faith reliance on the judicially approved warrant. An officer, ultimately, this is the state's position that these warrants are sufficiently particular, supported by sufficient probable cause, create a sufficient nexus between Ms. Gardner and the items being searched, and Ms. Gardner and the crime alleged, premeditated murder. We believe the time frame is reasonable, given her pre-existing relationships with the co-conspirators and her pre-existing relationships with the victim, and the evidence of the motive developed historically over time. But even if the court were to assume there's not probable cause here, which I in no way conceding, this is the epitome of a good faith case. No objectively independent officer would read these warrants and think that they were not supported by probable cause, given the breadth, depth, and length of discussion in here. In fact, it was approved by by a magistrate. And what Detective Padilla testified to is there's even the third-party layer. These officers are trained that when they submit search warrants to Meta or Apple or Google, that they are told by those third-party providers they have an independent legal team analyzing the search warrants and will reject them for non-compliance. So the officer receiving this and doing this search is aware that there is an affidavit and a warrant of breadth and depth outlining with specificity what they're looking for, where they're going to look for it, for how long they're going to look for it, sent to the third-party providers, accepted by the third-party providers after being signed by the judge. So given the totality argument for the court, we would ask that Your Honor deny the defense motion.
Can I ask what the plan is, because Mr. Fernandez kind of delayed the Franks hearing. Is that what you all plan to do here? If that,
I would say for the Frank's assertion, given Detective Padilla's testimony, that theoretically it's possible, but no one really knows because Apple has never explicitly said it in their law enforcement materials, and he has sent specific limited warrants to Apple and still received full data dumps. I think the defense is
isn't that specific on the investigator submitting information?
Well, before we have a Frank's evidentiary hearing, the burden is on the defense to present.
Right, that's what I'm saying, like, so.
I would say they haven't met their burden, so there's no, you can summarily deny the request for Frank's at the end. They haven't proven, one, that that's even true, two, that it's material that the problem possibly carried the affidavit, or three, that the officer intentionally left it out with you.
Maybe I'm not being on. What my question is, I thought that there was a deposition that needed to.
That is yes, sir. That is, Mr. Drive's petitions are separate from this.
You think, okay.
Well, I think
agree.
so. Yeah, I can confirm Mr. Carruthers.
Sure.
He's on Zoom, correct?
No, it's a different Zoom setup, so that I can talk. Unless you all can correct me if I'm wrong. I don't think anyone on Zoom can talk.
Judge, can you hear me?
Oh, I can. Okay. Yes, I can. Well, I'm under the long pressure. Hello, Mr. Dreiser.
Hi, Judge. I believe our issue is distinctly separate than this issue.
Okay. You agree?
Thank you.
Yes, sure.
Okay. All right. Thank you.
Yes, ma'am. Thank you. If Ms. Stippler's finished, Your Honor, I'll make her argument. I'll pick up at the end with the Frank's hearing. I disagree that we haven't met our burden. I think we actually met our burden through Detective Padilla, who testified unequivocally that law enforcement knows they have the capability to not only request targeted information from Apple, from Google, but they also then, once they receive that information, they know that they have, meaning the forensic folks, have the ability to filter before it ever goes to the investigative team. Detective Padilla was very explicit about that. Not only that they could get it separately, but then the forensic unit itself could narrow that data consistent with any sort of search warrant before it ever goes to anybody with knowledge about the case.
I guess I have a problem with that because he was speaking kind of in generalities, and I'm supposed to take that kind of general. I don't really know I don't know what to use that for. But I mean, so you're like, so he's saying in a general sense, but I don't know necessarily from this perspective, according to this case, that is a case-specific finding. So you're saying I should take his testimony, apply to this case, that is a possibility, so therefore.
So if the court, our position is that in terms of whether the defense is entitled to a Frank's hearing, the answer is yes. And the burden is on the defense to show that we are entitled to one, and I believe that we've met the burden of showing entitlement to a Frank's hearing through detective.
Okay, I understand that. Okay, all right, I get it.
I apologize for not being clear.
No, I'm sorry, it's me. Go ahead.
If the court doesn't have any further questions about Frank's, I'll move back to Detective Padilla. I want to start with something that Ms. Stippler said, which was that law enforcement struggles with cloud data. That's not what I heard Detective Padilla is saying. It's quite the opposite. What he said is what I just said to the court. He was very clear. Law enforcement knows that they can get targeted information from these iCloud companies. They can ask for it, they can receive it. He explained the file systems to the court. Not only that, but even if they get a data dump, which he said sometimes they do, even when they ask for something narrow, they get something really big. He and his team, through their forensic software, knows how to narrow that all the way down by search term, by the person sending and receiving, by keyword, by file type. They're not struggling with this information, Your Honor. They know how to do it. So I don't think that we are in a situation where this is impossible or impractical. Detective Padilla said that filtering process takes a couple of seconds. And he also told this court that even after they filter and give it to the investigative team to look at and make meaning of, that original data still exists. It's still available. So if law enforcement, the investigative team, looks at that filtered data and they then find probable cause to get more information from that cloud-based account, from that cell phone, from that Google account, guess what? They can go back to that magistrate and say, now we have probable cause for a wider data range, for more file systems, for more information. But what we are hearing today is that we should just be able to turn that information over. This court should just agree that even if there isn't probable cause, even if the warrant isn't particularized, and even though Detective Padilla and his team knows that they have the ability to narrow in, we should just turn it all over to the case team and let them go through it. And there's another really important thing that Detective Padilla said today, Your Honor, and that was that when you turn that information over, and I wrote it down, he said, we can look at whatever is there. And I asked him, you can look at this type of file, that type of file, pictures, everything. He said, yeah, we can look at everything. And that's what happened here. Despite the knowledge and the capability to narrow, the magistrate was never presented that information. And we have warrants here that are far broader than the probable cause for this vast amount of information to be able to rifle through Ms. Gardner's entire digital life. It certainly isn't particularized. I disagree with Ms. Stifler's characterization of both McCall and of Demon's, D-E-M-O-N-S, and we're pronouncing it slightly differently. In McCall, the district court, in fact, did find that that warrant violated the Fourth Amendment. And that is the case about the poker game where the poker game wasn't going correctly and then there was an armed robbery. And in that case, the law enforcement did in fact get the entire iCloud account. And the court said that's way too much. And then in fact, when the state appealed, the government appealed to the 11th Circuit, the state conceded that it was overbroad. And the 11th Circuit assumed that there wasn't probable cause because it was so overbroad. This isn't a case where the 11th Circuit simply said a temporal limit of any type is sufficient. That's not the holding of McCall. The holding of McCall is that the temporal limit has to still be tethered to the probable cause determination. What do I mean by that? We have the element requirement and we have the nexus requirement. And the time limit has to make sense. What that means in this case is that there is a time limit in the iCloud warrant. However, it's not tethered to anything meaningful. It's arbitrary. And that's where we see in the Demon's case that the court said that's not enough. There has to be a meaningful limitation here. We don't have that in this instance. And the iPhone warrant, Your Honor, does not have any sort of temporal limitation. Finally, Your Honor, if we are talking about being able to look through somebody's entire device or entire iCloud account, Ms. Stifler said that indicia of identification is always relevant, meaning that that should be a skeleton key to look through every single piece of information. That is not what the law allows. To paraphrase the Supreme Court in Perpetuity of the United States, the court there said, it certainly doesn't take a very creative law enforcement officer to think for any excuse to be able to look through every single file in somebody's digital life. The court there also noted that the average iPhone, this isn't like searching somebody's house, where it's a narrow scope of information. This is like searching warehouses filled with data. And giving law enforcement the permission to look through everything within the entire warehouse, when perhaps all they're looking for is somebody's car keys. And we know today from Detective Padilla that they have the ability to narrow that scope as much as the law requires, still preserving their ability, if they develop appropriate probable cause, to go back and zoom right back out and get more information. So what we are asking this court to do today, Your Honor, is to grant Ms. Gardner's motion to suppress the iPhone warrant, the iCloud warrant, and the Google warrant, both because they lack sufficient probable cause and because they are not particularized. And this certainly is not a case where we should be discussing good faith, given Detective Padilla's testimony here today. Should the court want to entertain parsing the warrant, which I think is what Ms. Stifler has requested, we're happy to be heard further on what we believe to be the appropriate remedy. And unless the court has further questions,
thank you very much. And so I'm going to take this under advisement. Do you all have a time frame that you're looking at?
not from the statement.
So I want to be responsive, but obviously there's, you're all giving me a lot to look at, and I need a chance to go through it. But I do appreciate y'all's patience. I wasn't expecting that trial to interfere with today, so I apologize for that. From your perspective, what would be reasonable? And I'll try to work under those deadlines. But what I'm trying to ask is, I don't know what you all are doing discovery-wise and to comply with the court order that I put into place. Like I want to be able to not interfere with your ability to prepare and be responsive so that you all can kind of know the landscape.
The state has no restrictions for the order to operate. It takes Your Honor to review what we provided and write orders sufficient to state is not going to keep at least my oversight and our ability to prepare for trial.
So I'm otherwise kind of occupied next week. I want to give it to you.
So you're going to file written orders? So I don't know that we need to come back if we get usurp the orders. I was going to suggest June 23rd, because at that point, the first motion regarding BB would either be moved or be right.
So what I'm considering is that might be okay, but if there is a need to have a hearing, brainstorming, if there's a need, like, I don't, like, to me, like, everything is not necessarily tied up. I wouldn't necessarily resolve everything with the written order, so I don't want to give it to you at a point in time where we're pushing up against August. Does that make sense? And so I'll have it out by June 1st, but I'd like to have a court date associated with it, so then I'll try to get out before then, so then by June 1st, we can kind of figure out where do we go from here. And then,
So
what about this? I'm sorry.
Are you saying June 1st is a court date?
I think so.
Yes, Your Honor.
Just a pretrial. And what about the issue of Mr. Dreiser?
I think I'll speak for myself for it. have that resolved with depositions, it will resolve that issue one way or another next week, so.
So maybe June 1st too. When did that pass, Mr. Fernandez?
You did, Your Honor.
That will be fine with me, Your Honor, and if Mr. Bryce are going to have a discussion, he wants, thinks he's going to call his motion, we'll contact the court sooner than that. Is that all right with Mr. Bryce?
Mr. Dreiser,
Yes, ma'am.
did you hear me? Like, is June 1st okay, Ms. Day? Whichever one.
We're out, Mr. Hill and I are out, but Ms. Day, I believe on June 1st could be there.
It's just a scheduling hearing, so,
That's fine. That's fine.
and then I need to know kind of where your team's at.
With Frank's.
Right.
Well,
I don't want to get too far into June, because there's a time frame that I'm out, then I'm back. I have a lot of trials.
We'll have a better idea next week. We're deposing Detective John Monday and Tuesday.
Perfect. June 1st?
Yes, ma'am.
Okay. So, Mr. Hathaway, June 1st, both cases will be in 308.
Yes, Your Honor. 9 o'clock, Judge, or 8:30?
9.
Yes, sir.
Actually, 9:30. I'm changing for a summer schedule.
Yes, sir.
So 9:30.
Yes, Your Honor.
Okay.
Thank you.
So thank you all very much. I appreciate y'all's hard work. Court's adjourned.
All right, that concludes, excuse me, that hearing. We have one more, which apparently took place the same day. That's what this says. It took place the same day. I don't know how it took place the same day. This was May 13th too, so. So that one was basically about the cell phone extraction of Shanna. And this defense is saying that it was an overreach on the state's part. The state's saying it wasn't, basically. They had a motion to suppress the iCloud, iPhone, and Google accounts. And then before that, they talked about Mario, who was her ex-husband, second ex-husband. Jared is the first. So Shanna has a trust account, right? Her family has money, right? So Mario is the trustee on that, and Shanna is the beneficiary. And the state is saying, well, there's a trail. The money trail can go back to money coming from that trust account, paid Henry Tenon his, I guess, paid maybe for his rent, or paid something to him from that trust account. Which is interesting because, A, what the heck is Mario doing as a trustee? That's interesting, but I guess they made him a trustee. And then, she made payments to a rental, which goes back to Henry Tenon. Also, there's data apparently that shows Shanna was talking to somebody about looking for someone to take care of him, meaning her husband Jared, her ex-husband Jared. So there seems to be a lot of evidence here, but I'm also like, they got divorced in 2015. This was 2022, so you're looking at 7 years. 7 years after they were divorced. The kids were like 9 by then. I think they're 12 now, so 4 years. Yeah, they were like 8 or 9. I guess they were involved in this bitter custody battle. So I'm really looking forward to this. I'm looking forward to this this trial for several reasons, and I want to see the evidence that the state has, because right now Sorry.
the form.
Sorry. Wow, that's really loud. Because right now it's well, let me just say right now it doesn't look too overwhelming, but you know how that goes. All right, so this is Henry Tenon. Apparently it was the same day. And he is the alleged trigger man, Henry Tenon. Alleged. How do you spell alleged? It's one of those words where I'm like, I think I'm spelling it right, but clearly I'm not. All right. Where is it? Alleged trigger man, I guess, for lack of a better word. All right. So this is a hearing from, let me just put this up. Sorry, guys. Let me just put this over here. I think that's how you spell alleged. Yeah. It's like one of those words where it looks right, but it's saying it's coming up wrong. Alleged. I don't know. I'm going to go with that. I'm going with that spelling. All right. There's not a D in there? Oh, it is. There is no D. I put a D in there. All right. That's why it's coming up weird. I always want to put a D in there. Alleged trigger man. All right, we'll go with that one. I always want to put a D in there. I always want to say alleged. All right. No D in allege. All right, so here is Henry Tenon from May 13th, which was the same day as we saw the other one. Now, this is about an hour. Yeah, this is like an hour. So if you guys are planning the rest of your day, we have, that'll get us to about 4:45 or so. I always think there's a D in there, right? It seems like allege. To me, it always seems like allege. Oh, send an email about Shanna's text. Okay, cool. Thank you, Richard. I'll check that out. All right, let's get started. And so May 13th. So this was like 6 days ago. All right, here we go.
All right. Good morning.
Good morning, Your Honor. You're here. Is the court ready?
Sorry, I didn't see the plug for my. Give me 1 second for it to hook up to the internet. Okay, I'm ready.
Good morning, Your Honor. Adam Mizrahi on behalf of the state, along with Christina Stifler and Steve Siegel. We are here on the defense motion to preclude statements made during the course of plea negotiations filed by Ms. Schlacks. The parties have discussed calling Mr. Chipperfield first so we can get him out of here as a witness.
Okay, and Ms. Schlacks, you agree?
Yes, Your Honor.
Okay, you may proceed.
Mr. Chipperfield.
Sir, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Morning.
State your name for the record.
Alan Chipperfield.
You have been a criminal defense attorney for...
All right, so we heard about this in a previous hearing that we watched today where he was the defendant, or he was the defense attorney for Henry, and he got removed from it because Henry was telling him stuff. We literally just heard this. We literally just heard this in another. Hold on, where was it? We literally were just. Henry hasn't given any admission. He's a key witness. Yeah, this was the one. Henry's lawyer is cooperating. Won't try. So this was from March. Nothing. Okay, yeah, I think this. They were just talking about this, the one from March. We just watched this one from March. So I think he's Henry's previous attorney. So all right, let's check this out.
For
Morning.
State your name for the record.
Alan Chipperfield.
You have been a criminal defense attorney for over 40 years?
Yes.
So without going into your history, you're a very experienced criminal trial attorney.
Yes.
Did you represent Mr. Tenon, Henry Tenon, previous to today?
Yes.
And during your representation of Mr. Tenon, did you, Mr. Tenon, and the state of Florida enter into plea negotiations about a possible resolution?
Yes, we did.
Have you reviewed your file and emails and things like that to refresh your memory about the sequence of events that took place for that negotiation?
Yes.
Okay. So in looking in our discussions, there is a meeting that took place between you and the state of Florida and Mr. Tenon on February 17th of 2023.
Okay. Mm-hmm.
You remember that meeting?
Yes.
And in that meeting, was this done pursuant to plea negotiations?
Yes, we were trying to negotiate a plea.
And during that plea negotiation conference on February 17th, was explained to you and to Mr. Tenon that anything that Mr. Tenon said could not be used against them because we were having plea negotiation discussions?
Yes.
After that, what I'll refer to as a proffer, after that February 17th meeting, did the parties begin negotiating a plea in this case?
Yes. Well, we were just trying to do that the whole time, but we got more definite in the terms.
And from February 17th until, I guess, February 24th, were emails exchanged about the terms of this plea negotiation?
Yes.
And then as of March 15th of 2023, were the terms 100% agreed upon?
Yes, I think they were agreed upon before. Well, I know they were agreed upon at the end of February and the first day of March. And the only thing that was left out of the plea agreement were the court costs, because I didn't know what they were.
Hold on.
May it please the court.
No. Let me see you all.
Whoa.
No.
May it please the court. She's like, no. Let me see you all. What is happening here? He just said, may it please the court, and she said, no. Let me see you all. And he's talking about when this plea deal was finalized. Holy smokes. Yeah, she said no. I'm not going to fast forward. I want to see every little bit of this. So the attorney that's asking the questions, I'm guessing is for the state, because Mr. Tenon's new attorney sitting there. We saw her, the woman with the blonde hair. I don't know her name right now. All right, that's not me. That was them. Wait, what happened here? All right.
Okay, so the last answer of Mr. Chipperfield referred to the only thing that was left out were the court costs. You can pick up from there.
Thank you.
I apologize for the interruption.
No, and just for my own sake, so the terms of the negotiated plea deal were complete other than the court costs?
Yes.
At the proffer meeting on February 17th, was any law enforcement beyond the state attorneys present? There was the detective. He was not present, right? If you need to refer your...
Well, I know that he was present at one of our meetings. I'd have to look at my notes to see if he was present on that day.
Okay. Well, and correct me if I'm wrong, he was present, and I'll concede with defense agreement that he was present, because we say he's present on 3/15 of 2023.
Yes.
The time of the sworn statement.
Yes, he was there.
And so that was the time that you were thinking about? That he was present?
I think that is. I don't remember without looking at my notes.
Well, if you can do it quickly.
Yeah. Yeah, the lead detective, Chris Johns, was present on March the 15th. And I don't see that he was present at the other meetings.
So there was a meeting on March 15th, which the court has already been supplied with the sworn statement that Mr. Tenon provided. In that meeting, was it for the purpose of furthering plea negotiations?
Yes, he was going to give a proffer.
On March 15th?
All right. I don't know if this puts it to bed or not. I thought it was First Coast News, but it was actually News for Jax. Again, I don't know if this is going to put anything to bed, but this is, if you guys are seeing something different, then let me know. But this is what I'm seeing. Hold on a sec. This is what I'm seeing. This is News for Jax. I don't know if I can actually get it for you. This is from November 21st of 2025. Prosecutors take DP off the table. Again, I don't know if you guys are seeing something different, but I just went to News for Jax and typed in DP for Henry Tenon, and it clearly states it's off the table. According to court documents filed Friday, prosecutors will no longer be seeking the death DP against the estranged. Again, if you guys are seeing something different, I'm sorry, I can't get rid of that black thing there. So again, if you're seeing something different, I don't know. Awesome Potamus, hey, how are you? So anyway, that's, if you guys see something different, cool. But that's what I'm seeing on News for Jax. Sorry, so let's continue on.
They're on February.
He was going to give it then on February the 17th?
I jumped around. That's my fault. On February 17th, he was giving a proffer, and that was for plea negotiations.
Yes.
On March 15th of 2023, were the plea negotiations complete?
They were.
Was the sworn statement given pursuant to a discussion about what the plea would be?
No, we already knew what the plea would be.
So the sworn statement during that process, was Mr. Tenon ever advised that the sworn statement could not be used against him because it was pursuant to plea negotiations?
Not to my knowledge. I don't remember hearing that.
And was law enforcement present for that sworn statement?
Yes.
Was that sworn statement done in furtherance of the plea negotiations as compliance with it as opposed to some negotiations?
Yeah, we had agreed he would give a sworn statement. No, that wasn't written down in the plea, the agreement that was attached to the plea form, but that was our understanding. We knew that was going to happen.
Did you believe that Mr. Tenon's sworn statement could be used against him if he decided to back out of the plea negotiations?
I think I did. I don't remember ever even considering that because I never considered he would back out. I mean, that wasn't ever in my thought process.
Did you have any discussions with Mr. Tenon on the March 15th sworn statement that it could not be used against him. In other words, affirmatively telling him this is for plea negotiations, that you don't have to worry about it being used against you.
No.
Did you have discussions with Mr. Tenon about the sworn statement and that the plea deal was already completed?
I think we both assumed it was completed when I reviewed the plea form with him, with the language that was used on the day of the plea, and he signed the plea form. At that point, I think both of us understood that he had a deal.
And the previously agreed upon plea that took place in late February, early March, is that the exact plea that Mr. Tenon entered into on March 16th of 2023?
Yes.
And then did you subsequently learn that the plea deal was entered on March 16th of 2023, the same time as the grand jury was convening for indictments on Mr. Fernandez, Saldano, and Ms. Gardner?
I knew it then, but I also knew that ahead of time. I'd been told that.
And so it was structured so it could be done essentially at the same time?
Yes.
So I misspoke. It wasn't Ms. Gardner, it was just Mr. Fernandez Saldana that was indicted.
Yes, the plan was to arrest Mario Fernandez right after the plea was entered, or as it was being entered. He was in a different city.
And I think I asked this, but there was no change between the negotiations that were completed in late February, early March, to the plea that was entered on March 16th of 2023.
That's correct.
That's all the questions I have here.
All right, thank you. Cross.
Bucket list.
Hello.
Right here. Good morning, Mr. Chipperfield. It is fair to say that you are an extremely experienced attorney, correct?
I've been doing it a long time, yeah.
And it's fair to say that you have handled probably literally thousands of plea agreements, correct?
Probably, yeah.
And of those thousands, many probably involved some type of cooperation, correct?
Yes.
And you being an experienced attorney, you have become used to a typical protocol here in Duval County. Think that's fair?
With regard to entering a plea with an agreement to cooperate, yeah, I think so.
And one of the ways the state of Florida can elect to do that policy is to have multiple negotiations and then ultimately be satisfied we want to offer a cooperation agreement, correct?
Sure.
And then the plea agreement is presented to the court that's presiding over that particular case, and it's either accepted or rejected, correct?
The court can reject a plea agreement, yes.
And I imagine in your vast experience, you have had situations where courts have declined to follow an agreed upon disposition.
Very few, if any. I'm trying to remember any specifics where we had already filled out a form and had it rejected. I know that I've had proposals rejected. I can't remember if I've ever had one where I had a form and came into court and tendered a plea and it was rejected. I'm sorry, I just can't remember.
You would agree with me in terms of legally binding. No plea is final until the court has accepted it and gone through a full colloquy with a particular client.
That's true.
And besides the court not rejecting, I imagine also in your vast experience, you've had situations where the client originally maybe signs a plea agreement or tells you they're willing to sign the plea agreement, and then through the plea colloquy process, the client declines. Would you agree with that? Has that occurred to you in your experience?
I know that those cases have occurred. I'm trying to think if I've had one where we actually had a form signed. I've had a number of cases I know where clients have changed their mind before we've come to court. I don't know if any cases of mine have reached the place where we're standing there entering a plea and then the client changes his mind. I may have had that. It wouldn't be unheard of.
Okay. And going back to the specifics of Mr. Tenon's case, there was a sworn statement, sworn meaning that Ms. Christina Stifler placed Mr. Tenon under oath before beginning her questions, correct?
Yes.
And you personally were there?
I was.
And you evidently, prior to that meeting beginning, had conversations with Mr. Tenon, correct?
Oh yeah, on a number of occasions, yes.
And I know you just testified that in your mind, all the plea negotiations were finalized before you walked into the state attorney's office on March 15th, correct?
Yes.
You would agree with me what you have determined in your mind may not be the same as Mr. Tenon, correct?
I know later that was true. At that point, I thought he understood that this was our deal. But no, I can't climb inside his head.
Because Mr. Tenon wouldn't know if the court was going to accept his plea, would he?
No, we had not addressed the court at that point.
And respectfully, you didn't know if the court would accept the plea.
No, I didn't know that. I sort of assumed it based on the comments from the prosecutor and the nature of this case and what was going on.
And certainly nothing would have stopped the state of Florida from having the plea agreement fully approved by the court and then taking formal sworn testimony from Mr. Tenon, correct?
They could have done that.
Obviously, you were available. You were in this courthouse every day, correct?
Just about back then, yeah.
And they'd have to get on your schedule, but certainly you could have accommodated that.
Sure.
That's not the policy normally in the Fourth Judicial Circuit, correct?
I've seen it done both ways, where they take a sworn prior to the plea or they take a sworn after.
And so in all these conversations, I know you were asked various different ways, but you would agree with me that at no time during the plea colloquy and at no time during the sworn statement is Mr. Tenon ever advised anything you say can and will be used against you.
He would not. I agree with that.
You were asked by Mr. Mizrahi if it was assumed, but you would agree with me it was never told to Mr. Tenon.
I think I do agree with you on that, yeah.
And although evidently a detective was there, he was never advised of his constitutional rights before any statements, correct?
No, you're right.
In fact, I think you testified that the only statement would have been given on February 17th, 2023. I guess this was more of an informal meeting where there were no recordings, correct?
Right. That wasn't the only time we met, but you're right that it was not a sworn statement. It was what I call a proffer.
And if I understood the questioning of you earlier, Mr. Mizrahi did establish that Mr. Tenon was specifically told in February of 2023, nothing you say can be used against you.
That's right.
Okay. And then ultimately, the negotiations continued and he gave the statement that he gave on March 15th.
Yeah, the negotiations continued until the 28th. The 24th when we exchanged emails about the final terms of the agreement. And the 28th when I talked with Mr. Tenon.
In all of your emails with the state, I know this is very obvious, but just for record's sake, those would be communications between yourself as an individual, maybe co-counsel, Mr. Brody, and the state of Florida representative.
They were between me and the state, yeah.
Obviously, you share with your client all information, but he was not privy to those emails.
I think probably the email of the 24th where we agreed on the terms, I might have shown him that. It wouldn't be unusual for me to do that, so that he knew what I had proposed and what they had responded and agreed to.
Okay.
I know I discussed it with him. Whether I showed him the emails, I can't remember that.
Okay. All right, I don't have anything further. Thank you, Mr. Chipperfield.
Ms. Mizrahi.
Just briefly, I want to make it clear, I know it's in core, but the plea agreement that you entered into with the state of Florida on behalf of Mr. Tenon involved cooperation.
Yes.
And the terms of the plea deal were that he would testify truthfully in the cases involving his co-defendants.
Yes.
And that was the purpose of taking a sworn statement, was to have a memorialized under oath statement about what Mr. Tenon would testify to, so he would satisfy the plea agreement.
Yes, that's true.
That's all the questions I have here.
So before we excuse Mr. Chipperfield, I want to pose a question to the parties and allow questioning on it. Based on the information that has been elicited by both sides, there were questions posed to Mr. Chipperfield related to the court's ability to accept or reject pleas. So in looking on docket line 47, I want to know from the party's perspective, because it just may be a nuance, I'm not sure. This form that's a part of the record the title is plea of guilty with a negotiated sentence. However, the form, the only portion of a possible negotiation, quote unquote, it says see attached form, which is the subject of the questions that you asked Mr. Mizrahi. But there are no other terms, essentially, other than, I guess, anticipated consideration or argument that might be given. So, and I'm opening it up that my understanding is there's very limited opportunities the court has very little discretion to reject open pleas. So it's put on a form that says negotiation. There are no real terms for the court, meaning like X number of years that would be a consideration. So I'll allow y'all to ask questions based on, I guess, the understanding of whether this is an open plea or negotiated plea and any nuance that you believe would bear on the court's decision. So, Mr. Mizrahi, if you have any questions based on that.
I have any questions, Mr. Chairman.
Ms. Schlax, because you posed the question, so I'll let you ask.
Certainly, Mr. Chipperfield, we have discussed this agreement that was filed on March 16th, 2023. You would agree with me that this calls for a range of potential sentence, correct?
Yes, with the bottom being 15 years, no less than 15, up to life.
And meaning that the sentence was very much open, including whatever recommendation the state may ultimately give.
Right.
And those terms were still up in the air, if you will.
Well, yeah, we didn't know at that point what the victim's family was going to ask for or recommend. I didn't know at that point what the state was going to recommend. All we knew was it was going to be at least 15 years. And the other terms that are stated here, that he has to testify truthfully.
Thank you. I don't have anything else, Your Honor.
Okay. All right. Thank you, Mr. Chipperfield.
Sure.
Did the state have anything further, or were there any other, I guess, scheduling considerations? Ms. Schlax?
Your Honor, just argument.
Okay. Ms. Schlax, it's your motion, so I'll hear you first.
Certainly. Your Honor, as articulated in the motion, and I provided to the court hard copies of the individual cases that I had cited previously in my motion, and I'm happy just to run through those very briefly.
Okay.
Because I would argue to the court that the law in this area is somewhat clear, in that the Robertson test, as enunciated by the Supreme Court of the United States, has actually been carried through, and that is a two-part or a two-prong test. And essentially, it's whether the defendant subjectively expected to negotiate a plea, and two, whether that expectation was reasonable under the circumstances. And I would argue to the court that the appellate decisions by various Florida courts, including the Supreme Court, have seemed to turn on whether the agreement was fully completed or whether it was still ongoing. And that is a key factual scenario. I'm going to start with the cases that I imagine the state would start with in regards to they tend to support their argument more, which is Groover and Wainwright. But what is so critical, and I think what turns the decision, is the specific provisions within those agreements that if in some way the agreements fell through, that anything the defendants in those cases said would in fact be used against them. I have provided to the court this sworn statement. I'm happy if there's any question. I know Mr. Chipperfield just acknowledged it, but if there's any question in the court's mind, I know the court was not the sitting judge at the time of the plea colloquy. But during the entire plea colloquy as well, which I'm happy to provide to the court, there is no admonition, there's no suggestion that Mr. Tenon in any way has waived his Fifth Amendment rights about any statements previously given. And that's where I think the case turns.
I'd like the transcript. You have it?
Oh, yes, certainly. I can email it to the court right now.
I'm not trying to interrupt you. I would like a copy of it.
Certainly. I will provide that. And Your Honor, just to go over the specific facts of some of the cases that I cited, Calabro v. State, which was a Florida 2008 decision from the Supreme Court, ultimately was a second-degree murder case where at arraignment, the defendant just spoke directly to the court and said he wanted to avoid trial and reach a plea agreement, and ultimately, spontaneously, additionally said, I'm guilty of this. Ultimately, the Third District Court allowed the statements. The Florida Supreme Court said no. We want to encourage frank and open discussion. These were subjectively and objectively, based on the circumstances, properly considered by the accused to be statements made to a plea agreement, and the court had no problem ratifying that decision. Additionally, in Nunes v. State, spelled N-U-N-E-S v. State, another 2008 decision from the Florida Second District Court of Appeal. And this was a robbery, arson, and murder case. And in fact, after police contacted him, he and his lawyers met with prosecutors. During that meeting, he gave a recorded statement admitting involvement, expecting cooperation might lead to favorable treatment. Ultimately, the court held that statements made while a defendant reasonably believes they are negotiating a plea are inadmissible. And again, citing the Robertson two-tier test, in that situation, the defendant himself subjectively expected that he was in plea negotiations, and that was reasonable under the facts of the case. In regards to State v. Guzman, Mr. Guzman, and this is a Third District Court of Appeal case from 2008, Mr. Guzman made incriminating statements during a polygraph examination. That polygraph examination was agreed to by his lawyers as well as prosecutors because they were attempting to negotiate a case. Ultimately, the court had no problem finding that the statements made during the polygraph examinations were connected to the plea negotiations and were therefore admissible. This can be contrasted with the factual scenario of Wainwright. In Wainwright, Your Honor, a Supreme Court decision from 1997, 704 Southern 2nd 511. The situation in that case was that he entered into a specific agreement to avoid the death penalty. And this agreement was considered completed because it asserted that he was representing and told police, I did not have anything to do with the physical death of this woman. And so he proclaimed that. And they openly told him, and it's announced within the decision, if that turns out not to be true, if we develop other evidence to say that that is contrary, this will not stand. You will have failed the plea agreement, and anything that we elicit from you will specifically be admissible. And he was specifically told that. The second part of his agreement was that he in fact would pass a lie detector test. That was not only that he would take it, but that he would pass it. And additionally, and that he was truthful in all conversations with police. Ultimately, he refused to take the lie detector test and refused to honor the agreement, and the state did not want to honor the agreement. They found, and the court seemed to take great care to, in my humble opinion, to distinguish this from all of the cases we have seen previously. And that is, number one, he had specifically been told, if this agreement falls apart, if you are not able to live up to these set parameters, pass a lie detector test, and not have any involvement in the physical death of this woman, then you get the benefit of this bargain. But he was specifically told, if you can't live up to this bargain, if you can't pass this lie detector test, if we develop other information that you were in fact responsible for her physical death, then your statements are specifically admissible. On the third page of that decision, they actually provided the testimony that had been elicited in open court where the detective testified. We specifically told him these statements could be used. I would contrast that with the situation at hand. In this situation, the state of Florida began to have negotiations with Mr. Tenon's lawyer. There obviously were conversations that took place, I guess, on February 17th of 2023, as well as, according to Mr. Chipperfield, perhaps additional dates. He was specifically told in February 2023, the only time it suggested anything in regards to his right to remain silent or make any kind of statements, that those statements would not be used against him. Your Honor, I would argue to the court that subjectively, of course, that is the only time that he is told anything, contrasted to his interview tape. Before he was questioned by law enforcement, he was read his constitutional rights. No such thing occurred. Was it objectively reasonable based on all the circumstances? Mr. Tenon is brought physically to the state attorney's office. He does not control if he's brought over. His lawyers are there. He's then asked questions. He thinks he's making some kind of an agreement until he's physically before a judge the next day, and that plea is accepted and ratified by the court. Is that plea complete? The state of Florida could have immediately after the entry of that plea, once it was finalized, said, Mr. Tenon, please come over. We need to go through all of these details and secure your actual testimony. That would have been in performance. They were never elected to do that. They only obtained statements from Mr. Tenon when he was under the mistaken belief that he was in full plea negotiations. And I would argue that isn't a mistaken belief, because that is what he believed, and under the case law that I have just cited to the court, we would ask you to suppress those statements.
All right, thank you. Mr. Mizrahi.
Your Honor, I want to commend Ms. Schlacks for providing the court with the Groover v. State, 458 Southern 2nd, 226 Supreme Court, as well as Wainwright v. State, 704 Southern 2nd, 511 Supreme Court, 1997 case. As Ms. Schlacks properly indicated, these two cases are essentially the case at bar, and are dispositive of the issue. As the Groover case says, which is citing back to a number of federal cases and state cases, when an agreement has been reached, further statements cannot be made in the expectation of negotiating a plea. That is the whole purpose behind making statements of a plea of guilty or statements to negotiate a potential plea inadmissible, is to foster open and frank plea discussions. Once the agreement is reached, the Florida Supreme Court says unequivocally that those statements cannot be made in furtherance of plea negotiations and are therefore admissible. The Groover case actually cites a case in a situation in which the defendant had not pled guilty, that he testified immediately after agreeing to the bargain and before entry of the plea. And so the Groover case is citing federal cases that say, even if it's before the plea, if the plea negotiations are done, then they are admissible. And that is the case that we have here. We have no evidence of any subjective belief that this was inadmissible. And we have affirmative evidence that objectively a very experienced lawyer believed them to be admissible. And so, not having, obviously the defense is correct in pointing out that we did not explain to the defendant that these would be used against him, because it went without saying, because the purpose of the sworn statement was for the defendant to testify repeatedly, in this case, over and over again, under oath, sworn testimony about his involvement and the involvement of his co-defendants. So the purpose of taking that sworn statement was because it was not a negotiation, but he was becoming a witness in the case and was waiving all of his rights to remain silent. There's no reason to read him his rights or explain to him it can be used against him, since that was the purpose of entering the plea, was he was going to become a witness in the case. So I think the evidence in the case law is overwhelming. The court should deny this motion.
Well, so looking at the Groover case, I agree with the timeline, and I just want to make sure I'm understanding the timeline. There's a February 17th proffer where he was explicitly told nothing that he said during that proffer would be used against him. Then the next meeting of sorts with the state of Florida was on the March 15th date where the sworn statement was taken.
Correct.
But there were no papers that passed. It was just under oath statement.
Correct. The parties had agreed to a plea deal that was entered that next morning.
Okay.
The plea forms had gone back between the two of them, but obviously they're executed in court.
Right.
We had, via those emails, the state of Florida had agreed to the terms of the plea, and frankly, if the defense had held us to that, we would have been certainly let the court know that we had agreed to it. I mean, there was no further negotiations that were taking place.
And in this Groover case, it says the plea agreement had been reached, and then the negotiations were over, period. And then it says all he had to do was live up to his end of the bargain. And it says the court went on to note that the plea agreement had expressly warned I know that you're arguing that it goes without saying, but there was an express warning that what he said during the course, that was a warning to him. And so in the plea colloquy, in anything, was he ever said, this is going to potentially hurt you, other than, to me, I know it's connected, right? Like if the sworn statement was taken, then the state, for lack of a better phrase, would have a stick. That means if he did not testify to what he said in the sworn statement, then the state could bring other charges. And at that point in time, it would have been a capital case. So he would have been looking at a significant new crime potentially if he contradicted what was put in the sworn statement. That to me is kind of logically linked to what you're saying, meaning that didn't need to be said.
Correct. It's intertwined. When you say...
Wait, this is my question.
I thought you were done.
Okay, no. Okay, so that to me is logically linked, that there is a stick at the end of you give this, you do that, that is flip on us in the middle of open court or whatever, or in a depot, then we can have the stick of a new crime. But if he doesn't go forward with whatever, that to me, I don't know that anyone would intuitively or subjectively know that now that I've given this, it can always be used against me in a prosecution. That's what I don't know is necessarily logically linked, and I want to give you an opportunity.
Well, the requirement to cooperate would have extended to deposition and to trial. No one begins the trial by saying, you know, this can be used against you.
Right. That's what I'm saying. That's logical to me.
Right. Well, the sworn is part of that. You're going under oath in front of the detective and you're giving sworn testimony about you becoming a witness in the case. Remember, saying this can be used against you, the defendant's facing life without the possibility of parole based on his plea. He knows it's going to be used against him. When you talk about this whole warning, the cases don't say that because of the warning, the holding of Groover, the holding of Wainwright, the holding of all these federal cases does not say a warning is required in order for these statements to be admissible. It's one more piece that gives the courts a little bit more comfort in deciding that, but the holdings of these cases aren't that the warning is what is necessary.
Can I ask you this, because just intuitively, right, like federal cooperation is so different, right? They have forms.
The process is different.
Yes, they have proper forms. They have cooperation forms because their guidelines are different. So because the cases don't necessarily say it, could be because of the practice, right? Like that they have these kind of like gotcha moments in their papers that would then hold the cooperator basically at bay at every given step. Like they don't get the guideline mitigation. They don't get those because all of their papers are required. The state is more fungible, and if the state draws out for whatever strategic reason their cooperation, meaning they need full performance before they get the benefit of the bargain, but it's never said, generally speaking.
I don't understand what the court's question is.
My question is because those cases don't say it because their practice is different. And then it was brought in evidence here that the state practice is different. The proffers are different. It is more fungible in the state system as opposed to the federal. So because they don't say it doesn't mean that it did not exist because their papers are more strict. That's what I'm saying.
I understand that, but it's not what the holdings of the cases say. That's what they said, oh, and by the way, there was a warning. They don't say that the warning is required in order for this to be. Remember, they're moving to strike this statement under a Florida statute and a Florida rule of criminal procedure that deals only with plea negotiations. This is not a motion about Fifth Amendment rights. The motion that was filed has to do with a criminal rule and a criminal statute, both of which say plea negotiation statements are inadmissible. What the court has before it is zero evidence about the defendant's subjective belief and overwhelming sworn to testimony of an objective belief that this was admissible. Based on the record at hand, the court should have no questions about its admissibility. The state can always do things better than we do, but when the defendant is facing life without the possibility of parole, is becoming a witness in this case, the fact that his statements could be used against him is understood because he's pleading guilty. He's taking responsibility for what it is. So how can you be more guilty than pleading guilty? No, that's not an artful way of saying that, but of course it can be used against him because he's taking responsibility. He's facing life without parole. To say that further doesn't make a whole heck of a lot of sense. No one's anticipating that a person under oath is going to completely change their mind and withdraw from a plea agreement. It's never contemplated. You don't go over. Now, if you back out of all this stuff, we can use it against you because remember, the examples that I'm sure the court is familiar with and the state are situations where the defendant in a deposition or in trial changes their testimony. Those times they're never warned. They take the witness stand in a trial and no one ever says, oh, by the way, your testimony in this case can be used against you. The defendant at that time can make the decision to withdraw his plea after testifying in the case. And at that point, is the court saying that because he wasn't warned on the witness stand that it could be used against him, it's inadmissible? No, because it's not for the purpose of plea negotiation. And that's where I think I have to take the court back to, is his sworn statement wasn't in violation of the criminal rule or the state statute that says it was for plea negotiations. He's there with his lawyer becoming a witness in this case.
I want to be clear. I'm not criticizing the state.
Okay.
I'm pointing out that case law turns on facts, right? So courts don't comment on facts that they don't need to comment on because it's a part of it. That's what I'm saying. I'm not criticizing either system. They have their benefits and drawbacks, but to say that it doesn't necessarily turn on it when the cases say that there is an express warning, that there is an express, is because it exists within the facts of that scenario. And I'm not saying anything about what the state does. You do whatever you want to do, but I'm just saying that there is a logical flow from that based on the facts that are before the court, which is, I want to give you the opportunity to argue it to me, and I'm not making any comment. I want to make sure that I'm understanding this correctly. The timeline the state has is that there were negotiations, that there was communication now that this court knows through the testimony of Mr. Chipperfield, and then there was a meeting / proffer, I guess, to determine what the potential testimony would be. And then between those two times, that is the 17th and then the 15th, there were further firming up of what the terms of the negotiation would be. Then there is the sworn statement. Then there is the plea. And so that is what I'm giving you comment on, because I guess I have to analyze it with what I have before me based on the law, but the facts are important to me. And then, they can be distinguished or they can be similar, and that's why I wanted to give you an opportunity to comment on it.
Well, I mean, in the Groover case, if the court wants to turn to page 3 of that case, in that particular case, when the defendant testified, I think it's U.S. v. Sterling, that the defendant agreed to plead guilty on one charge, testified truthfully before the grand jury in exchange for a dismissal of other counts. He testified immediately after agreeing to the bargain, but before the entry of the plea. The indictment returned was unsatisfactory to him on various grounds, therefore he withdrew from the plea agreement and pled not guilty. And in that case, the Second Circuit upheld the trial court's refusal to suppress the grand jury testimony because the rule, the state rule, is the same as the federal rule. The inadmissible testimony has nothing to do with whether we advise the defendant or not. It has to do with whether or not the statements are made in furtherance of plea negotiations. And when that plea negotiation is completed, the statements are admissible. And that is what, and Groover is citing to that federal case saying, we are the same. Once an agreement has been reached, further statements cannot be made with the expectation of negotiating a plea. Again, I turn back to the concept that we have no evidence of a subjective belief. We have a motion. We have no evidence of a subjective belief that this plea, these sworn statements were not admissible. And the only evidence the court has is the objective statements of the defendant's lawyer at the time, who said, I believe they were admissible, because he was becoming a witness in this case and was going to testify in depo and at trial.
Okay, thank you. Ms. Schlax, I'll give you the last word.
Thank you. Your Honor, if you look at all the language used in State v. Calabro, they specifically talk about there are specific situations where it, of course, is verified that the defendant would have a subjective belief that they were speaking versus plea negotiations. And they point to factors like, was there a lawyer there? Were they meeting with lawyers? Were they talking about terms of a plea? All of which took place in this situation. What I harken back to, and I think the court correctly considers, is there is a vast difference between cooperation agreements in federal court as well as state court. State court does it in a certain protocol, as Mr. Chipperfield explained. However, what all the appellate decisions point back to is the Robertson test. Subjective belief and objectively reasonable. Respectfully, it is not what Mr. Mizrahi thought, or Ms. Stifler thought, or Mr. Chipperfield thought. It was the circumstances surrounding Mr. Tenon and whether or not his statements were freely and voluntarily given, ultimately.
What do you have to say? What do you have to say about Mr. Mizrahi's point that there is no evidence of subjective belief?
I can very reluctantly call my client and I told him.
Yeah, it's up to you. I'm just asking, like, what would you say about that? So, I mean, we have Mr. Chipperfield's take on it. We have the state's take on it. So.
Your Honor, I will very reluctantly call my stand for the...
I'm not telling you what to do, Ms. Schlax.
I understand. I told my client that we might get to this position. I was reluctant to do it, but I told him that this exact question may come up and that the court may want to hear specifically from him on that specific issue.
I don't want to hear anything what y'all want to present. He made a point, so.
Your Honor, at this time I would call Mr. Tenon for the very limited purpose of his subjective belief on March 15th.
Okay. Do you want to talk to him some more?
I've been able to talk to him this morning. I told him that we might be here doing this.
Okay. Mr. Tenon.
Do you need to talk to me at all?
Jim. I dropped it. Okay.
Mr. Taylor, will you raise your right hand as best you can, sir? Sir, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? Thanks, sir.
Mr. Tenon, can you please introduce yourself to the court?
Yes, good morning.
Good morning.
And sir, I'm going to take you back specifically to March 15th of 2023, a day you were brought to the state attorney's office and ultimately were asked questions by Ms. Christina Stifler. Do you remember that day? Do you remember answering those questions?
Yes.
Okay. Were you at any time told that anything you said could be used against you?
No.
Did you believe you were speaking to them for a plea agreement?
Yes.
I don't have anything further going on.
State. Mr. Mizrahi.
Morning, Mr. Tenon.
Morning.
The plea negotiation that you entered into with the state, your plan was to become a witness in this case, correct?
At that time, yes.
Right. And at that time, your plan was to testify truthfully, correct?
Yes.
You didn't enter a plea with the plan that you weren't going to testify, correct? You did not enter into a plea that said you were going to testify knowing you were never going to testify.
I did.
You did? So you lied under oath to the court about that you were going to testify truthfully?
No, because I did wasn't intending to speak with the police because My understanding is that I can change my plea at any time for sentencing.
Okay, well, that was never explained to you by anyone, correct? Lawyer didn't explain that to you, correct?
Yes.
And the judge didn't explain that to you, correct?
Yes.
Okay, they told you were pleading guilty and that you were going to testify, correct?
Actually, I was intending to change the order here, but something got missed out of the way. I missed the time.
All right, I don't understand what that means, Mr. Tenon, but you would agree that you entered into a plea agreement knowing that you were going to have to testify in this case. That was what your agreement said, forgetting what you thought in your mind.
Yes.
Okay. And no one ever told you that your sworn statement under oath in front of the detective could not be used against you, correct?
No.
No one ever told you that?
No.
And certainly you could have asked your lawyer, hey, can this be used against me?
See that?
You could have asked your lawyer that question. Can this be used against me, correct?
I didn't.
Right. Because you were becoming a witness in this case.
That's it, yeah.
And the agreement on March 15th, when you gave your sworn statement, was the exact agreement that you pled guilty to on March 16th of 2023, correct?
Correct.
Thank you.
Ms. Schlatt?
Nothing further.
All right, thank you, Mr. Tenon. All right, I'll hear you.
Yeah, or just to reiterate, and we keep almost going back to this premise that somehow we have changed the standard that we have always adhered to, in that now instead of advising someone who's accused of a crime that they have the right to remain silent in anything they say, now we're putting the standard that supposedly Mr. Tenon should have asked that question. And again, the state of Florida had a number of options of how they could have proceeded in this case, and we would be in an entirely different posture. Had they elected at any time after March 16th, 2023, when that plea was fully accepted and ratified by the court and was a binding plea agreement, they could have asked Mr. Tenon to come over to the state attorney's office. They could have demanded that Mr. Tenon come over to the state attorney's office and asked him whatever that they please. And at that point, I agree. I would be stuck with this is simply statements in furtherance of the plea. But that's not what occurred here. There were too many things that were unknown. He had a subjective belief that it was not final until the court would ratify it, and that the state would actually present it with, again, victim approval. He did not know that. He was never told. All of these statements that you're saying, hey, if something goes awry with this plea, if we decide we're not going to want it, if you decide you're going to withdraw it, nothing was ever said, and how easy that would have been for them. There's a reason that every detective is taught upon sitting down with a suspect that they are going to read them their constitutional rights. The state of Florida elected not to do that, furthering his objective belief that in fact this was all pursuant to his plea negotiation that he was continually trying to do. And so we respectfully request the court to grant the motion to include any private statements by Mr. Tenon to the entry of his physical plea on March 16, 2023.
All right, thank you all very much. I'm going to take the matter under advisement and write. So we can recess, Mr. Tenon. Okay. I need a date. I'm out next week, so I'm thinking, when are y'all available?
Your Honor, with that, I guess the Tuesday the court's back. if that would be acceptable. I'm just pulling up the date. The 26th, Your Honor. And in that time period, Mr. Mizrahi and Ms. Stifler and I have already started discussing potential proposals for a trial base, and we'll try to get something more solid.
Is that okay with the state? The 26th? Okay. Mr. Tenon's case will be passed to May 26th, ruling on motion. Thank you all very much. Court's in recess. Melanie, we have a question, so go downstairs. I'll leave this all up to you. I'll leave this all up here. All right, you're done, right? You're done. Okay. See ya. Have a nice trip. Okay. Yeah, you want me to take that back downstairs? She is, okay. Okay. Yeah. Okay. Sure.
All right, that seems to be it for that. I wanted to read one thing. This is from the police report, Jacksonville Beach. There's somebody who heard shots and saw a truck leaving. So at 10:07 hours, I called Allison Preslar, as she had previously redacted. She stated on the night of the homicide between 1955 and 2000 hours, she and her boyfriend, Joseph Magish, were walking the dog. They walked the dog from his residence on Sanctuary North to the northeast corner of Jacksonville Drive at America, where she said she heard 4 shots. She said she did not hear any screaming or arguing, just the 4 shots. She said there was no pause between the shots. She and her boyfriend Joseph, then began to walk back to his house. When they got to the center of Sanctuary Boulevard, she saw a blue older model truck, which had been going south toward JTB, do a 3-point turn and drive out the southbound lane. She said the truck was going real slow and she knows it was a man driving, but could provide no details such as race, etc. She said the truck had a wide silver trim around it, like a 2-tone truck, but was unable to say if it was 2-tone. She only was able to say it was blue on the top, and she said she noticed large black full trash bags in the bed of the truck up near the driver. She further said she believed it was a 2-door with a long bed. When asked if she saw anything else, she advised there was a dark car and a tan or gold car behind it stopped on Sanctuary Boulevard southbound, which would have been in the south of the truck she saw. She did not see people or activity and said it looked like they were just stopped there. She said it was dark and she could not really see, and said there was no flashing lights or anything. She provided me with a number, blah, blah, blah. All right. I've got a lot. We've got a lot of papers to read, so we'll do that. We're going to do at least two more. But Richard, you sent a couple things. This is one. So this is this text message between Shanna and her friend Kimberly Jensen, right? So Kimberly Jensen is one of her friends, and so prosecutors released more evidence saying May 2024 hearing. There's a text that says Shanna would allegedly use code words like funeral potatoes and doing magic to discuss potential murders for hire. In one text exchange where Gardner says she had a bad day, Jensen replies, I'm still trying to send stupid to prison. If I can't make a casserole, prison is the next best option. So prosecutors say Gardner frequently referred to Jared as stupid with friends. So Jensen saying she's going to send stupid to prison. That doesn't make sense. So Jared and Shanna shared custody of the 2 kids. Her frustration with their arrangement is clear in one text where she says, just when I think doing this whole 1 week off on thing is such a good idea, it gives me such great pleasure imagining slitting his throat. Wow. Jensen has not been charged in connection with the case, but prosecutors included a text exchange in the evidence that shows her asking about hiring a hitman for another person. Jensen tells the friend Shannon needs a guy, the kind that performs permanent disappearing acts on certain people. Know any magicians? Now I've watched an interview with this Kim Jensen. I don't know. I'm not sure what's going on here. All right, so prosecutors withdrew their intent to seek the DP shortly after Tenon began to have doubts about cooperating with the prosecution. All right, so this is from March 2nd of 2026. So we've seen a couple places where the prosecution has withdrawn the DP. So I guess until I see otherwise, we're going to go with they have withdrawn. But Richard, I want to thank you for sending that, among other things. But all right, Karen, Jose Baez is one of her. Even though we've only seen him on one. He's only been in one of these hearings. He's keeping a very low profile for such a high profile attorney. He's keeping a low profile as far as these hearings are concerned. I think I saw him on one Zoom, and I think he was once in person. But other than that, he's not been present during these hearings. So, pretty chick, I enjoyed being here with you all today. Awesome. We appreciate that as well. All right. we're going to wrap it up here. I just want to say thank you for joining us today. Appreciate that. Let's see. Grampy, I always show you a Super Ball. So there's Super Ball. She's hanging out in the sun, trying to get some sun there. So, all right, guys, thanks for joining us. Thank you to our mods. Thank you to Aaron. We're going to do probably at least 2 more, if not 3 more dives into this trial as we get closer. There's going to be I know there's at least 1 more. I'm sure there's probably going to be 2, if not 3. This starts, we have the dates, March, listen to me, not March. We have the dates, it's August, let me go back. So much happened today. So jury selection for Mario's first, August 10th through the 14th, and then the trial starts August 17th. And they're figuring 3 weeks. Yeah, 3 weeks. They're going to go 3 weeks. So August 17th through the 28th. And then, is that right? No, it's 10 days, 11 days. So then jury selection for Shanna starts August 31st. That's going to go to September 4th, and there's Labor Day on the 7th. So judge said they may go into Saturday and Sunday. And then her trial is going to be 3 weeks. Her trial is the September 8th through the 25th. So mark your calendars. We also have Tupac's, I think that's starting August 10th. We have Courtney Clenny maybe starting at the end of August. We got to see when that kicks in. But all right. I did. Yes, we did. We did learn a lot. All right. Swanee, thank you. The McCormick family. Hey, good to see you. Cindy, thank you. Horse Welfare, thank you. Karen, have a fantastic night. Richard saying have a good night. Amby, thank you. Appreciate that. Horse Welfare, we'll see you tomorrow. Aussie Gardner saying good night. Kaylee saying good night. Kimbers, have a good one. All right. I am going to wrap it up. Thank you guys again for joining us. Thank you to our mods, and thank you to Aaron. Have a great night. Tomorrow, we're going to prepare for Alicia Andrews' sentencing. Well, her motion to dismiss her trial, motion for a new trial. That's going to be on Friday. So tomorrow, we're going to take a look into Alicia. That's tomorrow, Thursday, and then Friday is going to be her motion for a new trial. So join us tomorrow. We'll probably start around 9 o'clock tomorrow. And we will see you guys then. Take care. Bye.